Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in the Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Vishnu Danpal, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency, the President, Christine Kala Kangalu, ORTT. By Her Excellency, Christine Kala Kangalu, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Mr. Sanjiv, Boodhu. Whereas Senator Vishnu Danpal is incapable of performing his duties as a senator by reason of illness, now, therefore, I, Christine Kala Kangalu, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Sanjiv Boodhu, to be a member of the Senate temporarily with effect from the 6th of February 2026 and continuing during the absence of Senator Vishnu Danpal by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 6th day of February 2026. Honorable Senators, a senator is required to take the oath. Can we all stand?
I, Sanjiv Boodhu, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
The leader of government business, Honorable Leader.
My Lord, I'm sorry, Mr. President. I have the honor to lay on the table the following paper, as listed on the order paper in the name of the Minister of Land and Legal Affairs. The Land Acquisition Requisition Order 2026.
Questions on notice, questions for oral answer.
The Honorable Leader of the government business.
Mr. President, we're pleased to announce that the government is ready to answer all questions on the order paper today.
Senator Dr. Marlene Atz.
Question number 35 to the Minister of Transport and Civil Aviation.
Sport and Civil Aviation.
Mr. President, in response to the government's decision to extend the permissible age for the importation of certain foreign-use vehicles from 3 years to 8 years, the Ministry wishes to assure that all existing systems relevant to vehicle inspection and certification remain firmly in place to safeguard road safety and vehicle roadworthiness. These systems currently apply to all vehicles in Trinidad and Tobago and would equally apply to any additional vehicles imported within the expanded age limit. The policy adjustment does not lessen inspection standards. Rather, it operates within a regulatory framework designed to ensure that only vehicles that meet prescribed mechanical safety and environmental requirements are permitted to operate on the nation's roads. In this regard, regular and rigorous inspections will continue to be conducted by transport officers at authorized vehicle inspection stations to verify compliance with established roadworthiness standards. These inspections include critical safety components such as braking systems, steering, suspension, lighting, tires, chassis integrity, emissions, and other mechanical and safety-related features. Additionally, electronic monitoring systems are utilized within the vehicle testing process to track inspection activity, results, and outputs over time. This allows for greater transparency, performance oversight, and early identification of issues, thereby strengthening the overall integrity and effectiveness of the inspection regime. Routine and targeted compliance checks would also be undertaken by the relevant enforcement agencies, including licensed officers, the Trinidad and Tobago Police Service, and traffic wardens to ensure that vehicles operating on the public roads continue to meet statutory requirements. Importantly, any imported vehicle that falls within the prescribed manufactured year threshold for mandatory roadworthiness inspection will be required to undergo inspection and certification prior to being placed on the road. This requirement will ensure that all imported vehicles are assessed before entering active service, thereby maintaining the government's road safety objectives and protecting the motoring public.
Yes, Senator.
Thank you, Mr. President. Thank you, Minister.
Public business, government business, bills, second reading.
Minister of Defense and Minister in the Ministry of Homeland Security.
To move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Mr. President, we are gathered here today to debate a bill which has two primary purposes. The first is to remedy the ineptitude of the last administration when they piloted the Bail Amendment Act 2024, and more particularly the obvious lacuna left by Section 5.5 of the Act. And the second purpose is to protect the administration of criminal justice from those elements who wish to use the criminal justice system to launder the proceeds of their illicit activity and to use the system to do so. Mr. President, if I can go straight to the first purpose of the bill. And the first purpose of the bill is to make it undoubtedly clear that when applying for bail for murder, an accused is required to show exceptional circumstances or sufficient cause, as the case may be, to justify the grant of bail. And this is achieved by Clause 4 of the bill. Mr. President, the bill seeks to clarify an issue relative to Section 5.5 of the Act that emerged during the passage, or after the passage, of the 2024 Bail Amendment Act, which was passed unanimously with opposition support, whilst they on the other side were in government. Mr. President, the concept that an accused in capital matters and other serious offenses is required to prove exceptional circumstances has a recent history. It first started with the Court of Appeal ruling in Daniel St. Omar and the state, and thereafter for murder in particular in the seminal case of Achille Charles and the state. In that case, the Privy Council held that the judges of the High Court always had and continue to have jurisdiction to grant bail for the offense of murder under common law. Prior to the ruling of the Judicial Committee of the Privy Council, the offense of murder was regarded as non-bailable by virtue of Section 5 of the Bail Act and Part 1 of the first schedule of the Act. Following the board's ruling, persons charged with the offense of murder exercised the right to apply to a judge in chambers for bail. Section 5 of the Act, as of July 2024, provides that the court may grant bail for inter alia murder only if exceptional circumstances are shown by the accused. Mr. Speaker, Section 5.5 of the bill in particular, following from subsection 2, and which I would get into shortly, Section 2 reads, 5.2 reads, subject to subsections 3, 4, 5, and 6, a judge or master may grant bail to a person who is charged with A, the offense of murder, before, on, or after the commencement of the Bail Act, Bail Amendment Act 2024, where he can show exceptional circumstances to justify the granting of bail. And all other subsections were, in essence, consistent, except 5.5. 5.5 stated, where a person is charged with the offense of murder or an offense mentioned in subsections 3 or 4 and brought before the court, but no evidence has been taken within 180 days of the reading of the charge, or where evidence has been taken but the trial is not completed within 1 year from the date of the reading of the charge, that person may apply to a judge or master for bail. Mr. Speaker, following the passage of the Bail Amendment Act 2024, a number of persons, in fact there was a deluge of applications from persons charged with murder. And starting with the case of Terrell Tony, which came before Madam Justice Gail Gonzalez, it was found that in spite of subsection 5, or 5.5, all persons charged with murder were required to show exceptional circumstances. Thereafter, there is the erudite judgment of Lady Justice Nalini Singh, which made it quite clear that that was not the case, and made it quite clear that looking at or using a purposive approach, and also, if taken quite literally, section 5.5 created a very different scheme. So under 5.5, because the Act starts off with 5.2a saying subject to, which means except for. Except for subsection 5.5, you have to show exceptional circumstances. And then section 5.5, quite apart from every other subsection which required exceptional circumstances or other such prerequisite. Section 5.5 read, where a person is charged with the offense of murder, as I just read, and either A, no evidence has been taken within 180 days, or B, evidence was taken, but the trial was not completed before a year. This section makes no mention of the requirement of proving exceptional circumstances. So it created, in essence, two regimes. Now, the interesting thing, Mr. President, is this. When one reads the judgment of Justice Nalini Singh, and more particularly from pages 18 onward, it is quite clear that the government at the time, in the House of Representatives, were alerted to the obvious lacuna, and alerted by the Member of Parliament for San Juan Barataria as to the lacuna. The then opposition at that point had in the House a number of very senior lawyers. If I can start, they had the then Attorney General Reginald Amor, or former Attorney General, the former Attorney General, now Senator Faris Al-Rawi, and both of them were senior counsel, Amor and Al-Rawi. The former Attorney General, member for Trinity Maloney, a lawyer. The member for Port of Spain North St. Anne's West, a senior counsel. The member for Port of Spain South, another senior counsel. The member for Ruka Lopino, and the member for Labantil West. And let's not forget the member for Arima, now leader of the opposition. 8 lawyers, 3 former attorneys general, 4 senior counsel. And in spite of the issue being raised by the member for San Juan Barataria, none of them sought to have the bill, Section 55, amended. Now, this bill, when piloted in the other place, 3 options were given in terms of the amendment to Section 55. The one contained in the bill before the Senate today in 4B. The other option was to amend 5.2, which I read earlier, and which started with subject to subsections 5, and others. And the last option would have been to simply delete 5 altogether, because it was rendered otiose. Because if you are required to prove exceptional circumstances, whether you come within the tenets of 5 or outside of it, then what's the point of 5? The opposition in the other place circulated a number of amendments, none of which dealt with 5, if I recall correctly. So they accepted that they had bungled the entire thing, and the only criminal lawyer among them, because there's not one on the opposition bench today in the Senate who practiced criminal law either in the High Court or Court of Appeal, or whose names feature or are of note in any case of note. So we are here today again. There's the opportunity. We've given the 3 options. The other purpose of the bill seeks to create a regime which already exists in practice. Now, in practice, Mr. President, when a cash bail alternative is given by a judicial officer, in excess of 10 years, for the last 10 years or more, the clerks of the peace had taken the initiative, probably because of policy considerations, but there was obviously no statutory license to do so, but they took the initiative to embark upon what was, in essence, an investigation into the source of funds. And if they were not satisfied that the funds came from legitimate sources, then the bill would not be approved. Judges are, of course, judicial officers with inherent jurisdiction, but masters and magistrates, being creatures of statute, had no power to embark upon any sort of investigatory exercise into the source of funds. We are here today to give statutory cover and to allow for magistrates and masters to embark upon such investigations to prevent the criminal justice system being used to launder money. Now, in essence, bail, when one stands as a surety, he is saying that I have faith that this person would turn up for his trial. I have so much faith that I am willing to pledge my property valued at X amount, or to put cash valued at whatever figure the court deems just. And it is faith that I have so much faith in the accused that he would not risk me losing my property by not turning up. So it's in essence a pledge or a bet he wages. When persons obtain property by the sweat of their brow, that's an entirely different matter that weighs heavily on them and would weigh heavily on the accused person, because he wouldn't want the person who has secured his liberty before trial to lose his property. But when the money used to secure bail is from ill-gotten gain, then there's nothing to prevent the accused from absconding, and the criminal justice system loses. Because the sweat of thy brow argument is not a factor. There have been instances, as a criminal practitioner I can disclose, where persons took cash bail, gang leaders from members of their gangs, and then shortly after these accused persons are executed or no longer with us. The money, however, is now cleaned. So we are seeking to prevent the criminal justice system from being used in this way. Now, if I can go to the bill starts in essence with, quite apart from clause 4, which in essence deals with the lacuna mentioned earlier with respect to 5.5 of the Bail Act. The bill starts by defining the bail source hearing, and then goes into the actual hearing and how it occurs. Now, a bail source hearing is, in essence, an inquiry conducted by a court. So let me say what it is not. It is not what was suggested in the other place, a trial with cross-examination that would use up all of the time of the limited amount of masters who sit to hear issues such as these. So this is not going to create a burden. In essence, it is no different to a judge in chambers when he conducts his hearing, his bail application, and he has concerns with the surety declaration filled out by the proposed surety, and he refuses bail. And if he refuses bail because he's not satisfied with the bona fides or whatever of the statutory declaration, you continue to remain in custody. So it's not a trial, and the court in itself will determine its own procedure. And it's, in essence, if we go to 6 now, there's a new 6b, the court shall conduct a bail source hearing in relation to all offenses where in attempting to post or secure bail, the accused or the surety presents cash in the sum of $30,000 or more, or a certified copy of a deed. Now, another issue was raised down below in relation to the word shall, stating that shall is always mandatory. That is not the case. And the judgment of the Judicial Committee of the Privy Council in Charles Matthews makes it clear that contextually, and more specifically when you are dealing with a court, shall can be interpreted as directory. So that if it's not mandatory and directory, and it has to be in proceedings such as these, where the court is looking at the particulars of the deed of conveyance and so on, or embarking into an investigation into how you obtained the cash used to secure bail, the court obviously has a discretion. So it's not mandatory, because a court being presented with a document and seeing it's a deed of 30 years or more would obviously have no concern about whether this was achieved by illegitimate means, and would therefore not have to embark upon a bail source hearing. It does not target poor people, as suggested by the member for Diego Martin East. It targets everyone. And again, it is the court who would trigger the bail source hearing by fixing bail in the amount of $30,000 upwards. Everyone knows that if it's a resisting arrest or assault or obscene language or these cases, own bail is usually granted, because if you remain inside, given the system what it is, then you may very well be like Alice in Wonderland, serving your sentence before the trial. And the court would have to take into account that you would not see justice if you are acquitted thereafter. So the court would trigger it by fixing bail in a certain amount, and the court, on its own motion, can embark upon a bail source hearing, or the court can embark upon such hearing at the behest of the prosecution. The burden, of course, is shifted, and the law reports are replete with cases which suggest that the shifting of a burden does not by itself amount to an infringement so much that it infringes your constitutional rights. The case of Noor Agar and the state of Punjabi is authority for that proposition. Now, the government took into account that there are arguments which may suggest that sections of this bill might infringe upon the right to privacy and other such rights. And I'll go into the Surat and Suraj discussion later. But in terms of the privacy aspect, when the bail source hearing takes place, the surety or the accused can request of the court that this hearing takes place in camera, meaning outside of the public view, so that when it takes place outside of the public view, the financial information of the accused or his surety, whether it's his family or his friends, that information is not disseminated to the public, because if it is, there are obviously concerns. One can be the subject of extortion and kidnapping and so on. So to strike a balance, we've made provisions in the bill for these hearings to take place in camera. Now, the bill also creates a duty of confidentiality on persons employed in the criminal justice system and who may have, during the course of their duties, access to the financial information of the surety or the accused. And quite apart from the duty of confidentiality, the bill creates an offense for disseminating such information obtained during the course of your duties. And it fixes a penalty of a fine of $50,000 or 6 months imprisonment if the person in breach is tried summarily, and if the person is tried on indictment, a term of a year imprisonment and 12 months hard labor, and the fine is doubled. We say, to deal with the privacy concerns, the fact that we have created this offense and the punishment is harsh, that in essence establishes a legitimate aim. It establishes the test of proportionality. It's justified, it's necessary, so that persons within the criminal justice system would think twice about exposing persons' financial information. For those who say that the fines or the terms of imprisonment are too high, we say it's proportionate, because it must be high enough to deter persons from taking the chance of using that information, which can be used to cause further harm to persons whose financial information is disseminated to the criminal element in particular. Now, I've dealt with that. Now, this bill has one more subsection, what is now subsection 8, section 8, or clause 8 of the bill, in essence, amends the existing statutory declaration affixed to the second schedule of the Bail Act. There was an attempt below to amend it, but the amendment sought to create much more confusion. But it's 8 clauses, and we do not expect 106 amendments to these 8 clauses. We do not expect amendments from anybody seated here below because none of them have any notable experience in the criminal justice system. Not one. Now, I heard an argument below, so I'll deal with it up front. An argument relative to separation of powers, and anyone wishing to raise that argument, I would ask them to look at the very same Achille Charles, paragraph 89, paragraph 89, page 28, which says in essence, the separation of powers is not a freestanding, legally enforceable principle that exists independently of and above the Constitution. Now, we have consulted with the Law Reform Commission. The task given to them produced an advice, and the advice suggested that there was only one jurisdiction with this sort of mechanism, and that was the United States. And we examined the seminal case which gave rise to what is called a Nebbia hold, which is in essence what we are putting in statutory form today. That's a case coming out of the US from 1966, but since then, in 1984, the state and federal legislatures, in essence, amended the law to strengthen the issue of Nebbia holds. Now, if I can go back a bit to Section 5 of the Act, again, we've presented this Senate with 3 options, and I would invite members of the Senate to perhaps have a look at the judgment of Lady Justice Nalini Singh from paragraph 41 onwards. Now, at the end of paragraph 40, the judge found that 5.5 of the Act was amended to introduce and to tackle the mischief of 5.5 by creating a time-based entitlement to apply for bail where the justice system failed to progress the case. And at paragraph 41, the learned judge made reference to a discourse which happened between the member for Samuel Barataria and the then Attorney General Reginald Amor. And a question was asked about whether 5.5 required exceptional circumstances or not. Now, Reginald Amor, if I can no, that's not correct, not before the judge entertains it on the application. That answer obviously made no sense when one read it. He seemed to be somewhere else. So the member for Sanwan Barataria asked, does he have to show exceptional circumstances? The Attorney General, not before he makes an application, Mr. Hussain, and that is within 180 days. If the 180 days expires, then does he have to show exceptional circumstances also? Then Attorney General, give me 1 minute, let me consult. The answer to that is yes, Mr. Hussain. So during the 180 days, and after 180 days, he still has to show exceptional circumstances? Yes, Mr. Hussain. So then I remembered when we did the 2019 amendment, there was a denial of bail for the 120 days, and within that period, you have to show exceptional circumstances. But after the 120 days has expired, you no longer had to show exceptional circumstances. And that at the end, at paragraph 42 of the judgment, the Lady Justice Singh opined that the Attorney General's response to Member of Parliament Hussein's query was ambiguous and internally inconsistent, and it has now led to uncertainty regarding the application of bail provisions for persons charged with murder. Initially, the Attorney General indicated that exceptional circumstances must be shown within and after the 180-day period for a bail application to succeed. This position suggests that the 180-day time frame has no meaningful impact on the standard for granting bail, thereby calling into question the legislative purpose of the time limit. So it now falls upon the Senate to determine which of the three choices highlighted earlier you would be most amenable to when it comes to amending Clause 4 in particular. Now, if I can also deal with some suggestions made by the member for Laventille West below. The member for Laventille West suggested that perhaps we should consult the Law Association. We do not believe that it was necessary, and more so having regard to the last opinion they provided in the ZOSO legislation, where they simply did not grasp very basic concepts of criminal law and sentencing, burden of proof, things like that, where they said, in essence, a particular provision, the fine was disproportionate and too high. And of course, any first-year law student would tell you that when any punishment appears in a bit of legislation, that the judicial officer is not bound to follow that. It's simply a maximum, a statutory maximum, and that the judge can give anything below that, judge or magistrate. If you missed the lecture in first year, then during practice, if a lawyer with with an ounce of common sense would know that one has to read judgments coming out of the Court of Appeal and the Privy Council as soon as they come out, so you keep abreast. Apparently that doesn't apply to the Law Association, because if they did so, they would have known about the case, and it's somewhat old, the case of Francis and Hines, which made that very point, and Francis of Hines sought to deal with the Dangerous Drugs Act, which fixed a mandatory minimum sentence of 25 years for drug cases, and the Court of Appeal said no. A 5-judge Court of Appeal was assembled to deal with that very point. So, no, we did not consult the Law Association, and no, we do not intend to in the very near future. Because we have the expertise of Senator Chote, Senior Counsel, who has a wealth of experience in the criminal justice system. Sadly, we can't rely on anyone below. We heard another bizarre suggestion during debate from a young lawyer, Mr. Marcel, who suggested that this bill should go to a joint select committee and that we should invite judges to participate in the joint select committee. I know that there's someone very bright on the other side, sworn in minutes ago, who might very well take the same point. But let's make it clear, it's 8 clauses. There's no need for a joint select committee on basic legislation. And in any event, should Senator Boodhu raise it, let me say it in advance, you don't invite judges to sit on parliamentary committees because they'll have to pronounce upon the very thing that they were a party to. So that's the other objection they made. And of course, it's not worth mentioning the other amendments they circulated. None of them made an ounce of sense. So, can I ask how much time I have, Mr. President? Sorry? I end at 2:26. So I did not intend to stay that long in any event, but let me say in essence that we look forward to a very lively debate, more particularly on how we fix 5.5, because we have a former Attorney General over there who was down there and who heard the conundrum explained and failed to fix it. Of course, we'd like to hear the explanation, but as I said before, we either delete 5.5 in its entirety, we go with what the bill suggests and was not interfered with by the opposition downstairs, and or we do as suggested with respect to 2A. With respect to the constitutional issues, we have taken the decision to remove the section dealing with the certificate, which dealt with bills under Section 13 to comply with Section 54. We removed it because we found that there's no serious infringement of any rights under Section 4 and 5, and in any event, if there were, we've looked at the rulings in Surat and Sturge, and we are certain that the steps we've taken, in essence, meet the Balancing Act, so that they are, in essence, steps to mitigate against any perceived abridgment of constitutional rights. So, with these few words, Mr. President, I beg to move.
Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Senator Faris Al-Rawi.
Thank you, Mr. President. Mr. President, we are here to debate the Bail Amendment Bill 2026. The Minister has just taken us through a tour of insults, recommendations, loaded with condescension, and has invited us simply to just accept the bill as it is. In addressing the law this afternoon, and in response to the Minister, I propose to be as succinct as possible because 40 minutes won't do enough to what is really required for us today, by us today. So the bill before us, as amended in the House, having removed the special majority considerations, as the Minister just said, occupies 8 clauses. Essentially, the 8 clauses can be split into 2 issues. The first issue falls really with respect to clause 4 of the bill, and then the second issue falls in considering clauses 3, 5, 6, and 8, 7 and 8. And when we go to the issue on clause 4 of the bill, that is the need for an amendment to section 5.5 of the Bail Act. We're going to have a discussion about sequential amendments. If we take the second limb, that is clause 3, clause 5, 6, 7, and 8, then we're going to have, I propose, an interrogation of bail conditions, variation of bail, proportionality, constitutionality, and consequential amendments. So let's get to the chase. The Bail Act of 1994 has been with us for some time. Indeed, up to 2015, we had 12 amendments. Every single amendment to the law and the parent law in 1994 itself has been passed with a special majority. Why? Because we're obviously dealing with constitutional issues. The constitutional issues that we're looking at occupy the reflections in sections 4 and 5 of the Constitution, touching on reliefs in section 14, touching on proportionality in section 13. When we look to the rights that we're treating with today, that is what bail is and how this bill affects it, permit me to put on the record, because it is an aid to interpretation and in challenges, that we're looking at section 3 of the Bail Act. Bail in criminal proceedings means bail grantable in or in connection with proceedings for an offense to a person who is accused or convicted of the offense, or bail grantable to a person who is under arrest or for whose arrest a warrant endorsed with a direction for bail is issued. That's what bail is. Bail is associated with the golden rule that you're innocent until proven guilty. You can go as far back as Wilmington versus the DPP. You can go to the Magna Carta. But in our Constitution, moving from the preamble of the Constitution, we enjoy, in Section 4 of the Constitution, very clear rights. 4A, the right of an individual to life, liberty, security of the person and enjoyment of property, and the right not to be deprived thereof except by due process of law. The right of an individual to equality before the law and to the protection of the law. The right of an individual for his private and family life. If we go to section 5, and we note in particular that subject to the Constitution and section 54, Parliament may not effect the arbitrary detention or imprisonment or exile of any person. It may not, in 5(2)(c), deprive a person who has been arrested or detained of the right to be informed promptly and with sufficient particularity of the reasons for arrest or detention, of the right to have a legal advisor of his own choice, the right to be brought promptly before an approved judicial authority, Part 4, Roman 4, the remedy by way of habeas corpus, or bring the body, as to the validity of his detention. And we look as well to the right to a fair hearing in accordance with the principles of fundamental justice in subparagraph E. We do have in F the fact that Parliament cannot deprive a person charged with a criminal charge of the right to be presumed innocent until proven guilty in accordance with the law, but that this shall not invalidate a law by reason only that the law imposes on such a person the burden of proving a particular fact. The right to a fair and public hearing, and in Roman 3, to reasonable bail without just cause. The minister says to us, quite interestingly, that Suraj and Surat, i.e. the proportionality of the bill, will satisfy the requirement of passage, that we don't need to go to a formalistic 3/5 majority in the honourable member's view. Now, the reliance on Surat and Suraj is something that I uphold on most occasions. In fact, Mr. President, for the record, I fought against the very minister himself on umpteen occasions as to the correctness of Lady Hale's judgment in Surat, and then took the case of Suraj to the Privy Council to uphold Surat. In fact, it was the Honourable Minister and the opposition, now government, that on every occasion said that Surat will fall. And in fact, the record in relation to bail amendments and this bill shows that the entire Bail Act collapsed when the opposition refused to support its continuation. In the House of Representatives, the bail laws of this country were reversed by 24 years into a state of 1994
Mr. President,
legislation.
46(1), I think he's going very far back. Let's find ourselves what we're dealing with here today, not the history of that.
No, I think the debate has now started. I'll give him an opportunity.
I know my friend is new to the House, but soon he'll catch up. So in coming ahead to the bail law, which we're amending today, the fact is, Mr. President, that the 3/5 majority has always been a feature of every bail amendment and the Bail Act because of the views taken in Surat and Suraj not being adequate alone to take passage. In the 2016, 2017, 2019, and 2024 amendments, some of which we propose in this bill to touch on, they were brought by a 3/5 amendment, even though I, as one of the strongest advocates for Surat and Suraj, hold that view. It was clear in our minds that the rights that were being touched were so carefully in need of preservation that we had to have a 3/5 majority. And I'm going to come to that in a short while. Because contrary to the bare assertion that separation of powers is something that we ought not to really take on because of the dicta of the Privy Council, that is not the truth, because it is too simple a proposition of law to be taken seriously. The fact is, a 3/5 majority is necessary in our respectful view because the bill proposes an ouster of the court's jurisdiction in the section 5.5 that we seek to amend in clause 4. That is because we are anchoring only 2 occasions in law where a person charged for murder can approach the court for consideration of bail. The first occasion is when a person charged with murder under Section 5 of the Act is brought before a master or a judge and must show exceptional circumstances within the parameters of Section 5.2 of the Bail Act as to why he should be given bail. And then secondly, the only other time that a person can approach the court for bail consideration is when Section 5.5 is triggered, and that's after 180 days has passed or your trial has not been completed within 1 year. Because there is an ouster of the court's jurisdiction for any other period of time, we in the government then in 2024, in 2019, in 2017, in 2016, we brought special majority considerations because we were conscious that the ouster of the court's jurisdiction could only survive the proportionality within Surat if we went with a 3/5 majority. Now, the minister, coming as confused as he was today, took us through, after a set of hurling results and insults about who is qualified and not qualified, if we took the standard of qualification for any debate to be who practiced in the area beforehand, it would make a mockery of the Parliament, Mr. President. So, by that own standard, we expect the minister to contribute to absolutely nothing in law unless it relates to criminal law, where he has practiced. Clearly not well enough. But when we get to the Honourable Minister's submissions, the minister spent a lot of time focusing upon one case, and that is the case of Jamal Mohammed Khan versus the state, a case where he in fact appears as attorney at law for the applicant. The minister said that this was a seminal judgment that came up. He went in passing to refer to another case, and that is the case of Terrell Tony. He didn't give the citation, he didn't give the judgment's particulars, but he said that the Nalini Singh, Madam Justice Nalini Singh judgment in the Jamal Mohammed Khan case came after the Terrell decision. For the record, the minister also said that it was as a result of the shortcomings of the now opposition, then government, as spotted, allegedly spotted by member Saddam Hussein in the House back then, that he came to fix this whole conundrum. Mr. President, facts are important when one wishes to establish the truth. The fact is, Jamal Mohammed Khan versus the state was a decision delivered on the 13th day of December 2024. The fact is that decision did say that the Honorable Judge considered that for reasons of statutory interpretation, number of reasons of statutory interpretation, the Honorable Judge held that Section 5.5, which we seek to amend today of the Bail Act, was not limited to exceptional circumstances considerations. The fact is that the Honourable Minister failed to tell us that the Honourable Madam Justice Gail Gonzalez, in the case of Terrell, T-E-R-R-E-L, Tony, T-O-N-E-Y, versus the state, in CR-HC POSIND 707-2022-1, that in that matter where he also appeared for the applicants, the date of that judgment was the 28th of January 2025. That is after the Nalini Singh Madam Justice decision. In that case, Madam Justice Gail Gonzalez held the opposite of Madam Justice Nalini Singh, and the Honourable Judge in that case said that the reason that the Honourable Judge agreed with the state that Section 5.5 considerations, that's where you go to apply for bail, whether you need to show exceptional circumstances, the judge held you do need to show exceptional circumstances because the judge rationally connected Section 5.2 with Section 5.5, and the judge said plainly that the reason that 5.5 also includes exceptional circumstances is that it provided none of the conditionalities. The learned judge said that Section 5.2 had the conditionalities, and subsection 5.5 provided a fetter as to when you can apply. That is, in 120 days, 180 days, or 1 year after. So there's a material omission on the minister's part, and that material omission is that there is another judgment of the High Court, which he in fact appeared in, which says the opposite of the judgment he relied upon from Madam Justice Nalini Singh. Now, apart from showing the minister's lack of forthrightedness, it does ground a good point as to why we're here. The good point is that two first instance judges have come up with contradictory opinions as to the intention in subsection 5.5. Now, contrary to the allegations that we are here because there's a hero in the House of Representatives who is the member for Sanwa Barataria, the judge found no such thing as to say that the then government, now opposition, failed to clarify subsection 5.5, because clearly Madam Justice Gonzalez agrees with the interpretation that the government stood by. In fact, the mere fact that the vote came with the same member, the Honourable Saddam Hussein, voting in favor of the bill without any reservation, shows that he too agreed that the law was clearly stated. Now, Mr. President, I must point out, relative to constitutionality and separation of powers, that in 2019, we had proposed with a 3/5 majority that a new section 6.7a be introduced, so that notwithstanding any of the conditions of subsection 5, you could still apply for bail at any point in time where there were exceptional circumstances. Now, Mr. President, as the author of the exceptional circumstances law, because it came under my hand, I looked to the laws of New Zealand, Mauritius, and Canada, and the United Kingdom. I was satisfied that the Constitution allowed for the reversal of the burden of proof. I've just read it a short while ago. I was satisfied that the courts would interpret what exceptional circumstances meant. The now government made a mockery of it, saying that that was unconstitutional, that exceptional circumstances was unclear. They are here today relying upon the same law that was passed. But I've raised subsection 7a to say that in limiting the right to bail to only 2 occasions in subsection 5, 2 and subsection 5.5, and ousting the jurisdiction of the court in any other circumstance, reliance on the legitimate aim principle in Suraj and Surat is not enough to hold that law together, and that it would be prudent to actually use the 3/5 majority as the Constitution says ought to exist as a layer together with the reasonable and rational connection in Section 13(2) of the Constitution. But, Mr. President, the honourable member, I genuinely suggest, has come here very unprepared, because the other sections of the law that cause concern go to Section 3, Clause 3, that's the interpretation clause where we introduce the meaning of bail hearings. 5, Clause 6, Clause 7, and Clause 8. Let's go to those provisions. Mr. President, may I ask what is full time, please? 258, thanks. So, Mr. President, Clause 3 says, interpretation, insert bail source hearing. Inquiry conducted by a court either on its own volition or at request of prosecution, with a view to determining whether the source of cash or real property, let me underline that, cash or real property, used by an accused or the surety to post or secure bail. Let me underline that word post. Nowhere in the Bail Act is there a concept of posting bail. It's new to the Act, no problems, has some institutional understanding to make sense of. Clause 5, the Act is amended by inserting that into Section 6. Section 6(2) is where you can say a court has the liberty to deny bail. And we're inserting here a new one. You can deny bail where the court, having completed a bail source hearing, is satisfied that the source of cash, underline cash, or real property, underline that, used by the accused or the surety to post, underline that, or secure bail was derived from illegitimate means. Clause 6 introduces a new subsection, a new section 6b. A court shall conduct a bail source hearing in relation to all offences, where in attempting to post, underline, or secure bail, listen to this, the accused or the surety presents, Mr. President, A, cash in the sum of $30,000 or more. B, a certified copy of a deed, underline that. If the Honourable Minister is so all-knowing and so confident as to who is prepared or not prepared, how then does the Honourable Minister explain Section 12, subsection 4b of the Bail Act which we are amending? And here's what Section 12, 4A says. Where security is given for the grant of bail, it may be in the form of A, cash or certified check, where the amount of the security is $10,000 or less. B, certified check, where the amount of security is greater than $10,000. C, a bond issued by a licensed financial institution as defined in the Financial Institutions Act. D, a charge on immovable property. Or E, such other form of security or combination thereof as the court sees fit. You don't have to rely on the legislation alone, you know, Mr. President. You can go to the Justice Gobin decision dated 31st January 2023, Benjamin Martin versus the Attorney General, Nilion Bagu versus the Attorney General, and to another decision of Mr. Justice Henderson, which I'll come to in a short while. Because at paragraph 10 of the Gobin judgment, we have set out, and going thereon, what the conditions that the clerk of the peace looks at with respect to security. But when I get to the point as to whether the minister has come well prepared, the new Section 6b proposed by Clause 5 is in contradiction. It collides with Section 12(4a), because 12(4a) says the only amount of cash you could ever be dealing with in court is $10,000 or less. So he's so well prepared, he comes here with aplomb, insulting everybody, to now tell us something which is contradicted by an express provision of a law that he doesn't amend. Worse yet, Section 6b. Look at Section 6b in Clause 6. New 6b, certified copy of a deed. That collides with the fact all immovable property, as the rest of the Act calls it, is not dealt with by way of a deed only. What about a certificate of title? What about a shows in action? What about a bill of sale? What about a chattel? There are a number of methods of title ownership which the schedule to the Bail Act, which section 18, which later sections of the Bail Act I'll come to deal with, none of them confine themselves to a deed, a certified copy of a deed. Because when you're dealing with a memorandum of transfer which is registered, it's not effective until the certificate of title is produced. So is it that in the minister's brilliance, with his insults to all of us, that a court shall only conduct a bail source hearing, cash in the sum of $30,000, not permitted by 12(4) or a certified copy of a deed? So somebody roll up with a certificate of title, with a Bitcoin, with a warrant, with a bond, with a financial institution underwritten facility, a security deposit. None of that goes into a bail hearing. Only a certified deed with the brilliance of the Honourable Minister and cash in the sum of $30,000. But let's assume that the Honourable Minister did his homework. Let's go to the Parent Act. If we are really fixing Section 5.5 for this odious error by the then government, all hail member for Barataria Sanwan for his brilliance in asking questions that he didn't ask and that judges have not held. How do we explain subclause? How do we explain sections 6A of the parent law and 9A of the parent law? Let's look at that. 6A of the parent law. 6A is split between 6A1 and 6A1A. It concerns the matters of appeal. Where a person is convicted by a magistrate, that's 6.1, for an offence punishable with imprisonment, appeals and is refused bail, that person on prosecution, as the case may be, may appeal the decision of the judge or master to the Court of Appeal. 1A, capital A, where a person is refused or granted bail by a judge or master, so we're dealing with indictable or triable either way, or other things that a JIPA sends to a judge or master, that person or the prosecution, as the case may be, may appeal the decision. But look at subsection 3. Where the prosecution appeals a decision of the judge or master to grant bail under subsection 1. First of all, a judge or master does not grant bail under subsection 1, it's only a magistrate. Or a decision of a judge or master to grant bail under subsection 1A, the Court of Appeal may dismiss the appeal. But Mr. President, that requires the Honourable Minister to have done the homework to spot that amendment that's necessary. But let's go further.
Mr. President,
when we get
I think we're going very far outside of the scope of the bill, the things he might want to put into the bill. That's not his function. Let's focus on the bill.
I'm giving the first speaker the opportunity to develop his point. Similarly, the independent bench. After the independent bench, I will then have a statement to make. Continue.
Thank you, Mr. President. I'm dealing with clause 6, insertion of 6B, and I'm showing the natural tangent as the same leader of the government business.
Please. The offending senator using that device, could you step out of his chamber and return in 20 minutes? Please. Continue, please.
Thank you. Lest the leader of government business gets lost again, clause 6, insertion of 6B, pay attention.
Mr. Speaker,
deals with...
I rise on standing order 46-4, please.
Pay attention, is it so?
No, Senator, I'm not. You want to explain? Go ahead.
Definitely, Mr. President. Mr. President, the member made a statement that appeared to be insulting language, very insulting to the leader here in the Senate. So I rise on standing order 46-4 to avoid that kind of insulting remarks to be made, and for him to use more parliamentary language when he's speaking about the honourable leader of the government bench in the Senate.
All right, well, yeah, all right, I understand your point. You're making an ask members and so on to show more respect towards each other. Continue, please.
Thank you, Mr. President. Mr. President, in the 13 minutes I have left, on clause 6, the new insertion of 6B, is directly related to section 9A of the Act. Where a judge or master grants or refuses bail to impose conditions on bail under subsection 5(2), 3, or 4, the judge or master shall give reasons. If they're going to proceed with the amendment to section 6 by the new section 6B, you must qualify and amend section 9A of the Act. Otherwise, reasons are not deemed to be required for a refusal or grant of bail under subsection 5, which we're amending in clause 5 of the bill, Mr. President. Mr. President, let's get to the fact that the Nebbia hold, or the bail hearing which the honourable member has raised, that Nebbia hold comes from the United States of America. Let me put on record, Mr. President, the origin of this thought for money laundering, etc., comes from a paper which I asked the Anti-Terrorism Unit and Criminal Justice Unit to prepare. They produced a note to me quoting the United States versus Nebbia decision in 1966, as well as the Castellano versus State decision of the 2nd District DCA of Florida. And in that, the court was authorized to consider source of funds used to post bail under both the Florida Rules of Criminal Procedure 3.131 subsection B subsection 3 pretrial release, and the Florida Statute Chapter 903 section 406 2F purpose and criteria for determination. And the note which I had created dealt with the fact in its recommendations that by codification of practice above, the court ought to be invited to examine bail, premium, and collateral as other forms of legitimate sources not required through illegal activities. Consideration would have to be given as to whether this criterion would apply to all bail applications or only for serious crimes and consequentially special majority requirement. Because in the United States of America, in their rules and in their statutes, it is fine-tuned to largely drug-related matters. So proportionality for bail hearings could rely on Surat and Suraj if you were honing it down to odious offenses in the schedule. But the bill before us proposes that a bail hearing is done for all proceedings, magisterial matters, as well as in the High Court by a judge or master. More than that, when the idea was being discussed under my time as Attorney General, it was specifically because we had invited the judiciary to consider a policy together with us on licensing bail bondsmen as a system and regulating practice. Why? Because in the judgments I've referred to, in particular the judgment of Madam Justice Gobin I referred to a little while, chapter and verse is set out as to the fact that there is in fact an illegal system of bail offerings for commission and indemnity which are offensive to Section 18 and Section 19 of the Bail Act. And to get rid of that illegality, but necessity, the judge has reflected upon the fact that people are bound to suffer in a system where they cannot access bail because they have no land, they have no security, the surety can't be given because the person is not rationally connected, all of which this bill seeks to treat with. But the premise of using the Nebbia hold was because we were coming with a bail bond system. And that's why in 2019 we amended Section 12(4)A to include other forms of security. So to say now that you're coming to introduce bail bonds, that you're coming to introduce a Nebbia hold for all proceedings is to take only a scintilla of what was being discussed in the AG's office then, which is reform money laundering, bring bail bond system forward, harmonize. I should tell you, Mr. President, the manner in which the AG's office under my time was considering this was that for AML, CFT, and illegality purposes, Madam Justice Gobin, Madam Justice Gonzalez, Mr. Justice Henderson in the judgment that they have looked at, and for the record, let me put Mr. Justice Henderson is in the matter of the bail application of Andrew Felix, CRHCPOS Bail 572-2022-1. In looking at these cases and in recognizing the illegal system of bails, a bail being offered by a professional bailer in contravention to sections 18 and 19 of the Bail Act, we were looking specifically at creating a registry. Every time you used property for bail, you would go to the Registrar General, you would lodge a notice, because if you're looking to a proper system of surety and security, as they are reflected on in sections 12 and section 16 of the Bail Act, if this is to make sense and survive without 3/5 majority and to be rationally connected, you have to take care of the observations of Justice Gobin, Mr. Justice Henderson, as he then was, he's now in the Court of Appeal, and Madam Justice Gail Gonzalez, which say to you that the system is so terrible that you are bound, if you are investigating quote-unquote title, or you're looking to where the legitimacy of funds come from, to be sent to jail as a matter of course. Now, the Nebbia hole in the United States is only done in relation to bail bonds, and where the Constitution of Florida says that you have to make an application for pretrial detention. In other words, then, the minister has not come with clean hands to tell us that the precedent from the United States involves a conditionality imposed by the Florida Constitution and their courts that you cannot have people in pretrial detention whilst this investigation is going on unless the court determines that they shall be put in pretrial detention. Therefore, this law is properly unconstitutional. Because if you look to the dicta of the umpteen judgments, there is no way that you can investigate the title. There is no system. You would have to get the Registrar General to do a title search on the property. There is no registration of charge or interest at the public registry to say you know that the deed has been used before. You have to go through an ad hocism of checking all the registries to see if a professional bailer came before, or the deed was used once, or the deed was used twice. But the law is so badly drafted before us. The minister has come to post bail, cash over $30,000 when the law conflicts and says it must be under 10, not amending that section, so you're going into confusion on implied repeal, and the minister has confined himself to a certified copy of a deed. So everything else in section 12, subsection 4, out the door, because the minister is so brilliant in his presentation today and so condescending to the opposition and to other persons in society, including the Law Association, we must just take it at face value. No, sir. That is not the way law operates. The fact is, Mr. President, that this law, if the Honourable Minister really wants to get it right, requires the establishment of an AML-CFT register. It's not uncommon. I could make life easy for him. Go and look at the Real Estate Agents Act. Look at the Non-Profit Organizations Act. Look at the Scrap Iron Dealers Act. Look at those pieces of legislation, and you will see how you set up an AML-CFT. But, Mr. President, the minister has pinned the proportionality of this law in relation to the right to privacy on the point that he's criminalized disclosure. He says we're good because we criminalize it. Wrong. Elsewhere in the law, it says you have to give decisions in writing. So what are you going to do? In camera doesn't mean the record is sealed. In camera doesn't mean that the right to private life and all your financial business not out there. That's why we did the civil asset explain your wealth legislation with very careful safeguards, and they were beaten up and crying over it. But what happens when the judge publishes all your information and it is there on appeal? What happens then? Just so the whole back door open, minister and border to cross-reference the law. So you have penalization, but the whole thing published by the court. G's and ages. Come better than that now. You have to read the law as a whole. That is the act, Mr. President. You could be as condescending as you want. Why the member for Laventille West was right in the House on our GSCs that we could fix this. Put in an AML CFT register, have the registration of the deed so that the process is right. You see, Mr. President, we're fighting a concept of reality, you know. Let me make it clear. The Financial Action Task Force does not require this to be done. The Caribbean Financial Action Task Force does not require this to be done. In proposing these amendments, the minister is taking us from compliance to confusion. The minister is taking us, in terms of law, to conflicts of law with the Parent Act. The minister is taking us to apples compared with horses, because the United States of America mandates under their constitution that you have to have a pretrial detention to say, I want to check your property, so I'm going to apply to the court to have pretrial detention so that we can check your source of wealth and your legitimacy of the earnings while you are in detention with the court's permission. And by the way, their system is much easier because they're using bail bonds. And Mr. President, we cannot just do it. So we are faced with a serious and draconian issue today, you know. Shopping for one vote. Who good to go? One thing the Honorable Minister said, 1 minute, thank you. One thing the Honorable Minister said that was correct. This applies to everybody, rich or poor. The system is not designed to work with this. It cannot work. It requires a 3/5 majority, and as surprised as the minister will be to see amendments, we will be proposing amendments, Mr. President. Thank you very much.
Senator Anthony Vieira.
Thank you, Mr. President. I rise to contribute to the debate on the Bail Amendment Bill 2026. This is not an easy bill. It raises serious questions. It engages competing but equally legitimate public interests. This bill, as I see it, sits at the intersection of public safety, financial integrity, and personal liberty. It is precisely the kind of legislation that tests our commitment to the rule of law, not in theory, but in practice. At the outset, let me say this plainly. There is much in this bill that is logically defensible and legally intelligible. But there is also much that gives me pause. And my concern is not academic, it is constitutional, practical, and humanitarian. As always, I begin by asking, what is the purpose of the bill? What is the mischief to be cured? The bill makes several significant amendments to the Bail Act. First, it expressly requires that where bail is sought under Section 5.5, the accused must demonstrate exceptional circumstances or sufficient cause to justify the grant of bail. Secondly, and more fundamentally, it introduces a concept of a bail source hearing, empowering the court to inquire into whether cash or real property used to post or secure bail was derived from legitimate means. Thirdly, it places the burden of proof squarely on the accused or on the surety to establish that legitimacy. Fourthly, it mandates such a hearing where bail is attempted using cash of $30,000 or more or a deed, regardless of the offense. And finally, the bill declares in the explanatory note on the face of it, where there's arguably an inconsistency with sections 4 and 5 of the Constitution, it declares expressly and unapologetically that it only requires a simple majority vote. To be fair, not long ago, when bail proceedings involved little or no scrutiny of the source of funds, cash could be produced without inquiry. Deeds could be tendered without confirmation that the property was still owned, unencumbered, or even real in a meaningful sense. Clearly, that is not good enough. Clearly, this cannot be a satisfactory state of affairs. I accept the legally sound logic behind the need for conducting due diligence in respect of bail being posted. This is obviously right in principle. The state is entitled, indeed, the state is obliged to ensure that the criminal justice system is not underwritten by the proceeds of crime. Bail should not be illusory. It should not be a mechanism by which illicit wealth converts into temporary freedom, particularly in cases involving organized crime, narcotics, or financial offenses. So in that sense, the bill addresses a real and long-standing deficiency, as indicated by the Honorable Minister. Due diligence in bail is not only sensible, it is necessary. And I accept without hesitation that courts should have the power to inquire into the provenance of bail security. But, Mr. President, logic is not enough. Policy is not enough. The Constitution is not suspended because our law is well-intentioned. Section 5(2)(f) of the Constitution guarantees that no law shall deprive a person charged with a criminal offense of the presumption of innocence, the right to a fair and public hearing, or the right to reasonable bail without just cause. The Constitution does permit laws that impose burdens of proof in limited respects. But that permission is not a blank check. It does not dissolve proportionality. It does not extinguish fairness. It does not license indifference to consequence. And it is here that the Privy Council's decision in the Attorney General against Achille Charles becomes central. In Achille Charles, the Privy Council articulated the proportionality test applicable when legislation limits fundamental rights. And the court asked 4 questions. First, is the objective sufficiently important to justify limiting a fundamental right? Secondly, is the measure rationally connected to that objective? Thirdly, could a less intrusive measure be used? And fourthly, has a fair balance been struck between individual rights and the interests of the community? Crucially, the board emphasized that this is an adaptable test, sensitive to context, severity, and consequence. Applying that test here, I accept that the objective is important and that the measures are rationally connected to that objective. But it is the third and fourth limbs that trouble me deeply. What troubles me most about this legislation is the potential impact on the everyday man. The practical consequences. What happens when this law meets real life? This bill does not operate in a vacuum. It operates in Trinidad and Tobago as it is, not as we might wish it to be. This is not the United States. We are a society with a significant informal economy, slow and sometimes dysfunctional administrative systems, imperfect land registration records, and large numbers of citizens who are financially strained, financially incontinent, or destitute through no moral failing of their own. Under Clause 7, a bail source hearing is mandatory once the threshold is crossed. Under subsection 2, the entire burden rests on the accused or the surety to prove legitimacy. And if they cannot do so promptly, because bank records take time, deeds are delayed, valuations are slow, bail may be denied. Bail may be denied not because the accused is dangerous, not because the accused is a flight risk, not because the prosecution has shown just cause, but because they could not assemble paperwork quickly enough. This is a serious constitutional concern. When accused persons are held hostage to administrative processes, is this a trading away of rights? Mr. President, access to justice is more than a right. It is a reality. Access to justice is not merely the formal availability of a hearing. It is the practical ability to use the law. This bill risks creating a system where those with accountants, lawyers, liquid assets, and unencumbered property navigate bail with relative ease, while the poor, the marginalized, and the informally employed remain incarcerated longer than is reasonably necessary, or worse, they cannot post bail at all. That is not equality before the law. That is subordination of liberty by financial force. That may be victimizing the wrongly accused. Discrimination, as we all know, involves treating people differently when they should be treated the same. But discrimination may also include treating people the same when they should be treated differently. A uniform evidential burden may appear neutral, but its impact is not. The rule of law serves at least two purposes. First, predictability, and secondly, protection of the weak against the strong. Mr. President, I worry that this legislation, however well-intentioned, can be weaponized, not by malice, but by structure. When liberty turns on documentation rather than danger, when freedom turns on liquidity rather than lawfulness, we risk drifting from justice into arithmetic. Having one testicle may be mathematically accurate and technically true. But the law is not arithmetic. The problem is not with the logic or with the maths, but how it's applied. Benjamin Franklin warned against trading essential liberty for temporary safety. The United States Supreme Court Justice Louis Brandeis, he cautioned that liberty is most vulnerable when government action is well-intentioned. Nelson Mandela reminds us that freedom means living in a way that enhances the freedom of others. These are not rhetorical flourishes. They are warnings born out of experience. So where do I go? How should I land on this bill? Mr. President, when I am faced with two competing, rational and laudable policy objectives, on the one hand, protecting society from the misuse of bail, and on the other hand, safeguarding the innocent poor from prolonged or unnecessary incarceration, I am guided by this. Justice must not only be done, it must be felt to be just. I would not like Trinidad and Tobago to become a heartless, mechanically driven, mechanically oriented nation. I do not want a system where being wrongly accused becomes a life-altering event because one could not marshal documents in time. Justice cannot be for one side only. It must be for all. I believe this bill can be improved through safeguards, timelines, evidential flexibility, or judicial guidance. And I will be circulating amendments in this regard. And just for the record, in case my pedigree on criminal law is brought into question, let me say that in the early 80s, throughout the 80s, I practiced heavily in the criminal courts. And in the early 90s and mid-90s, I was an undefeated lead prosecutor in the British Virgin Islands. There's a lot of good in this legislation, but certain aspects make me very uncomfortable. My primary concern remains that this bill may inadvertently risk binding the weak to the will of the strong, not by intent, but by effect. I am concerned that this bill may constitute a barrier to impoverished but innocent persons being incarcerated for longer than necessary, or worse, not being able to post bail at all. That's the issue my mind circles around again and again, and it always returns to the same place. When balancing equally competing legal policy considerations, when two laudable policies are in conflict, I follow the light I trust most: the preservation of human dignity, the liberty of the subject, and fairness under the rule of law. I hope the government will give favorable consideration to my proposed amendments, and I thank you.
The Minister of Planning, Economic Affairs, and the Minister in the Ministry of Finance.
Mr. President, thank you for allowing me to join this debate. And while I wish to address some of the issues raised by Senator Vieira, and Mr. President, if any time in this debate I stray for irrelevance, please correct me, because there are a couple of matters as in my former life that came across, well, actually one involving one of my soldiers who served with me in 1995. And he sent me when he heard about this debate, he sent me an article documenting his time incarcerated for almost 20 years without trial and without bail. But I'll share his case because when I was speaking to him today, it almost brought tears to my eyes. But I want to start by addressing some of I can't address the issues raised by Senator Al-Rawi because I practice neither criminal law or any kind of law. And my legal acumen is significantly less than most persons in this honorable place. But it seems as if while Senator Al-Rawi accused the Honorable Minister of doing a tour of condescension, he did a tour of his own. And that tour seems to center on the fact that every time we try to bring or improve legislation, some of which he may have had a hand in amending or taking forward, he seems to take umbrage to the fact that we have had on more than one occasion to fix some of the things he couldn't get done. Mr. President, you know, while Senator Al-Rawi also spoke about the different judgments that some of the learned judges would make, I am not so sure whether we are here to debate the views on the judgment of some of those honorable judges. But it just goes to show that as we continue to build a better Trinidad and Tobago, there are many areas in our legislative processes as well as in the things we do that we have to keep trying to make better and to make right. No amount of insults traded across the floor would change the fact that this government is a government focused on making sure that as we seek to take Trinidad and Tobago in the direction in which people have longed for and have had consistently failed in over the last 10 years or so, that there is a brand of requirements that this Attorney General and this Prime Minister intend on making sure that we bring about. And let me just say that whether or not FACTA requires this, or whether or not very many of those on the learned bench, regardless of their view on it, at the end of the day, citizens like Ricardo Stevens, and if you permit me, Mr. President, I want to refer to the article that he sent me. People like Ricardo Stevens, they need this. And I stand in a very somber mood, Mr. President, because when I read this article, and it was published on Wednesday, 11th of June, 2025. And while Senator Al-Rawi spoke in his own condescending way to my learned colleague, the Minister of Defense, he was one of the lawyers in this case. Almost 2 decades after they were charged, 4 men, one of whom was ex-Defense Force Special Forces soldier, have been freed of a 2005 murder of real estate agent Jared Gopal. Initially, 8 men were on trial in February 2020. With your permission, Mr. President, before Justice Norton Jack and a 12-member jury at the Hall of Justice, Port of Spain. Jury trials were halted as one of the measures to protect staff and other court users at the start of the COVID-19 pandemic in March 2020. They were charged for a 2005 murder. The trial before Jack was one of the first casualties of the lockdown measure. Although when restrictions were lifted, 4 men pleaded guilty to felony murder. Their sentencing was held in camera to protect the remaining accused men since their trial.
Mr. President, Standing Order 46.1, there appears to be no link to this.
Sorry, thank you.
Yeah. You could probably refer to the article, but try to relate it to the bill that is before us. Yeah.
And as I said, I stand corrected by that because I just wanted to bring some context to this, so thank you very much, Mr. President. But just to say that Ricardo Stevenson was one of the 4 who was held over and never pleaded guilty. The judge, Melanie went on to say She also faulted the prosecutor's failure to disclose U.S. transcript detailing the admission and disregard of prosecutorial duty to ensure that the proceedings are fair, not only in outcome but in process. So, Mr. President, Ricardo Stevenson and these 4 men sat behind bars for 20 years. During that time, his wife died. He was not allowed to even attend the funeral of his wife. When he went into prison, Mr. President, he had a 12-year-old daughter. When his wife died, he had... Dr. Brown, go ahead. Go ahead, go ahead. No, go ahead.
Mr. President, I don't know if the member has responded to 46.1 and linking it. Maybe you could just link it to the bill.
And so during that time, he was never given an opportunity to apply for bail. He was not charged, and therefore he could not, from what he said, during that time, applied for bail. He was not extradited along with those who were sent to the U.S. for trial. Sadly, or unfortunately, those who were sent in the U.S. and pleaded guilty served their time, and he was still left behind bars. His trial started in 2025, and the learned judge upheld the case of no submission. But the point I'm making, Mr. President, that when Senator Vieira talked about the human cost, Senator Vieira, while I hear you, and I understand your learned approach, I vehemently disagree with you. Because the cost of those who are currently in the system is not one where they are denied bail because they don't have accountants. The cost of one, the ordinary people outside there, is nothing like what you describe. People like Ricardo Stevenson, they want a system where there is greater clarity, where there is greater structure and greater opportunity for them to either be able to post bail or with surety with a bail source hearing. Part of why people like them suffer is because people like us want to make sure that we have it so right that we think that their constitutional rights are being challenged, but their constitutional rights were taken from them in a system fraught with so many loopholes and fraught with so many inconsistencies and inaccuracies, where many judges may interpret things differently. We have an obligation to people like Ricardo Stevenson. So when you talk about the human cost that may be incurred if we are faced with situations such as these, where we create specific processes that seems to favor those with required structures such as accountants, as you would have described them, I am suggesting to you, Senator Vieira, that the persons who are suffering today are people like Ricardo Stevenson, who have no means, no access, and therefore require us to put bail source hearings in place where they can have persons coming with sureties, where they will have a system that can be easily understood and accessed. So while persons that and as I said, I wasn't aware of all of that, but I know I recently became aware of it. And that is one of the reasons why I wanted to participate in this debate, because I felt that there are persons who are in the system today who need us to have greater clarity in terms of how we can amend the bail structure so that they are able to access it. Senator Brown, you want to say something? Because I'm constantly being instructed by the looks that I'm getting on this side. I know, mister, but I try not to go down that road.
Go down the road now.
I'm really fighting hard not to go down that road.
Go down the road.
Because I really want to enter into an honest debate about how people like Ricardo Stevenson could benefit from a better bail structure that seems to give the judicial officers ways in which they can create a framework that is understood, accessible, and clear to all who participate in that learned profession. There's another cost, Mr. President, that I think, besides the human cost, you see, as I said, Senator Vieira and I have different understandings of what that human cost is. Because while I never practiced in a court, I did work in prison ministries. And I did work among persons who have had to have long years waiting for trials. And in our system, I think one of our big failures is the length of time people have had to wait for trials without accessing or having access to bail. And that, for me, Senator Vieira, is the human cost that I think about. The families that are destroyed, children without parents, children like Rishi, Stevenson's daughter. I've taken a leaf off the book of my good friend, Senator Rishi. So where bail systems are weakly regulated and illicit funds can flow and used to buy freedom, that's the other side of it. Is the way in which, Senator Vieira, a weak, inadequate, and irrelevant bail system allow us to be susceptible. So when you talk about persons with accountants buying, or the systems in which they can structure bail, think about the persons who have access to illicit cash. And the perpetration of persons who come in and out of our system because they can get and access that in ways in which we can't regulate. And therefore, how many persons who continue to commit crimes outside on bail because they could afford it? A lot of the persons, and you see, that is why when we think about this structure of bail, I, for one, want to make sure that we have a system that can be properly regulated in ways in which it gives both the court and those who are accessing court services a clearer and fairer understanding as to what can take place. So, Mr. President, it is a fact that the criminal justice system, we remain vulnerable where courts cannot scrutinize the source of funds. And countries that fail to address this face not only reputational damage, but also it brings into complicity our banking system. It brings into complicity the cost of investments and trade. And so there must be some clear oversight where some of these funds, as it come into our criminal system, where it comes from. And that is the very definition, Mr. President, of organized crime. The very definition of organized crime is when we have such lacuna, such ease of access, where criminal enterprise, because they are the ones who take control of our system as we have it now. They are the ones who have the greater access to the system as it is now, not the small man. In fact, those are the persons who oftentimes suffer because they don't have the kinds of access that we think they have. I have not seen, when I visit many of the penal institutions, unlike those we would see in the on television and so on some of those high-profile cases. Have any of us ever been into a prison and visit people in the prisons, look at the prison services, look at the conditions under which people have to live there? It is constantly a source of, it's not meant to be a holiday. It's not meant to be somewhere where people go and don't understand the consequences of their actions. But it is not a place where persons who do not have to stay there should or want to be. So that is why it's important that we today, as we amend this act, put into the public domain and support the fact that we need to create a better structure so that in our jurisdiction, as we face and as we strengthen the pre-trial detention and bail scrutiny for serious offenses linked to criminal activity, that we seek to make sure that financial power is not a danger to our system of jurisprudence. We in the Caribbean, we are a small place. Money laundering and anti-money laundering activities, we continue to have to put oversight to make sure that we keep it out and improve international confidence in what we do and how we do it. So, Mr. President, the amendments to this bill demonstrate understanding that the issues of court appearance is highly important to this government, addresses the matter of protecting public finances while reducing the fiscal burdens on the state from persons who abscond, and of course, the resource demands of rearrest and continued prosecution. So therefore, Mr. President, these amendments are judicial enforcement mechanisms that reduce and improve our efficiency in the public institutions and the lower arm of reducing systems costs. We as a small Caribbean state, there are means by which we can holistically approach the solution to give citizens greater comfort and trust. And that's what this tries to create, Mr. President, public trust. Strengthening public confidence in our public system. Identify the bail systems lacking effective surety oversight that undermines public confidence and to create perceptions of inequality. And as I said, that is where Senator Vieira and I disagree. Inequality that we have is skewed to disadvantage those who are more impoverished than others. So, Mr. President, it is therefore the aim of this bill to strengthen the efficacy of our legal institutions. Is linked to higher trust, better compliance, and improve public service delivery. So I would leave, Mr. President, the legal arguments for those who are much more capable than I am. But I want to just talk very briefly on the perception of fairness. Mr. President, I just want to reassure my colleagues that while Senator Vieira talked, and I agree with him, about the context and the consequence of this bill, and he said that it impacts everyday man and what happens when the law meets real life. And that is why I raised the case of Ricardo Stevenson and many others like him, who in their real life came face to face with a system where they were not allowed to participate in ways in which this law is designed to do for those coming after. See, Mr. President, requiring courts to assess the financial capacity of persons standing as security for bail supports the perception of fairness, builds the credibility of bail conditions, and enhance public confidence in judicial control of accused persons. This is particularly important in small jurisdictions, as I said, such as Trinidad and Tobago. This form of judicial reform also benefits the system by reducing cases of backlog, pre-trial detainees, which have been a major area of concern in the public domain. It is recorded that Trinidad and Tobago has one of the highest rates of pre-trial detention in the Caribbean, with remand prisoners constituting over 50% of the total prison population, which of course contributes to the significant cause of case backlog in our judicial system. So, Mr. President, I must commend the Minister of Defense, the Attorney General, for bringing these amendments. Contrary to what many may say, this is a humane approach to dealing with the crime situation of Trinidad and Tobago and continues to demonstrate the commitment of this Prime Minister and this government to tackle the criminal state of Trinidad and Tobago. The aim is not to deny bail, but to ensure that the very system is not used against itself to further sponsor that which it intends to stop, crime itself. So, Mr. President, we are listening to the calls of the public regarding unfair detention and overcrowding in our prison system, especially with those awaiting bail hearings. Through the Bail Amendment Bill 2026, we aim to reduce the volume of cases requiring urgent bail hearings, minimize the pressure in the courts while streamlining case management, therefore allowing more individuals awaiting trial to do so outside of the prisons. The court system faces less pressure to process cases rapidly, allowing for more thorough legal proceedings. In passing these amendments, we are also improving other areas in the prison system, such as reducing jail overcrowding and increasing the efficiency of case processing and streamlining court operations. So, Mr. President, that's one of the reasons why I was at pains to start off talking about my former friend and soldier. Because, as Senator Vieira would have mentioned, what happens when this meets real life, it couldn't get more real than that of Ricardo Stevenson. I am not so sure of all the issues surrounding that because, as I said, I wasn't here for that time, and I am now becoming more familiar with some of the events that would have taken place. But one of the things that I am sure that was not the intention of Senator Vieira was that persons such as Ricardo must, in terms of those representing them, to give them access to the judicial system, would benefit from a very clear and delineated process that brings clarity to those who have to opine and, of course, use it in their daily practice. So that is why we consider this to be a very humane, a very people-centered approach to making sure that there is greater clarity in how justice is administered in this country, while at the same time reducing the scourge of money laundering that seek to take and have taken in very many ways, sometimes control of our processes. So the persons today who have access are not the small man, but the people who continue to use the proceeds of crime to their own advantage. And that's why, Mr. President, I want to stand in strong support of these amendments. And while I didn't address it too much, let me try to address some of it now. Some of what Senator Al-Rawi spoke about, Mr. President, I continue to think that, and maybe I missed something, Senator Al-Rawi, when you piloted your last bill, did you brought a 3/5 majority and it was taken out? It wasn't, but it didn't, sorry, it didn't.
Thank you, Honourable Member. Very quickly, I'm appreciative of your time. On all occasions, there were 3/5 majorities.
And they were not?
For bail amendment, yes, sir.
And they were passed with a 3/5?
Yeah, one was defeated when the government refused, when the opposition did not support, now government. And the last one in 2024, brought by AG Armour, was passed with their support, or with 3/5.
With the government support?
Yeah.
With the opposition support, sorry. I just ask that because, you know, when we sometimes come to this house, and the reason why I feel very strongly, Senator, about this bill, especially, as I said, because, you know, for those of us who have had prison ministries, we see the consequence of some of these failures of legislation not being, and Senator Vieira would have raised it, of what happens when legislation meets real life. And it couldn't get any more real when you look at those in the prison system. This bill is important in order to bring some balance to that. This bill is important in order to bring some structure to it. I disagree that this bill requires a certificate. I trust the judgment of the Attorney General in this regard, and I will let him deal with that in his own time. But I want to also, therefore, suggest that the leader of government business and all those on this side are firmly prepared to stand up for the people of Trinidad and Tobago, for the small, ordinary persons who cannot benefit from the proceeds of crime. In terms of having access to persons who can fund their way out of some of the issues that they might face, in terms of having a system where bail source or the source of funding for bail is not properly scrutinized, where persons who can be part of a legitimate system can have an experience that is able to provide not just clarity, but to provide surety as they seek to deal with their presumption of innocence, even as they access bail. So, Mr. President, these reforms, therefore, are not theoretical. They directly support Trinidad and Tobago's broader CFATF compliance agenda and help protect the country from being labeled a high-risk jurisdiction, which is an outcome that would harm every law-abiding citizen and business through higher transaction costs and reduce access to international banking. We are enhancing Trinidad and Tobago's reputation, strengthening the financial and legal controls, where we can have real economic consequences by giving confidence to international agencies and investors as we seek to make sure that not only are we creating economic resilience, but we are creating judicial competence as we seek to amend this bail legislation. So, Mr. President, in tightening this bill and the Bail Act, it's not about abandoning human rights. We are doing this to strengthen the framework for well-designed bail systems, which must preserve the presumption of innocence, protect against arbitrary detention, such as that experienced by Stevenson, ensure judicial discretion remains central, safeguard confidentiality and financial information, prevent discrimination or abuse, and scrutinize the source of funds used in bail scenarios. The Trinidad and Tobago Amendment, therefore, these reflect the balance, the caring approach that this government will put in an evidence-based decisions that will empower the courts, introduce confidentiality protection, and make sure that the offenses for unlawful disclosure of financial data are well enshrined. This is how democracy is modernized, not by weakening justice, by making it smarter, more transparent, and more resilient to criminal manipulation. This is how we show that we care for the well-being of our citizens. The fight against crime, therefore, is also a fight against illicit financing. Bail systems are no longer just procedural tools. They have become part of the front line of financial crime prevention. And these reforms are designed to protect our citizens, protect judicial system, preventing the rule of law from becoming corrupt and allowing due process to flourish. So, Mr. President, I wanted to share those thoughts because I was stimulated when I got that WhatsApp message early this morning, and therefore I decided to participate in this debate. And I also wanted to make sure that I spoke directly to some of the human elements raised by Senator Vieira. I can't speak adequately to the legal arguments raised on the floor by Senator Al-Rawi. I can, however, say that on this side, we will continuously fix the legislations he brought while he was Attorney General. We make no apology for that, because that seems to be the order of the day. And in many ways, Mr. President, Senator Al-Rawi, I felt he was very animated today. I felt he was looking at this side. He accused the honorable mover, the mover of the motion, the honorable Minister of Defense, of coming unprepared and of being touting his criminal acumen. Honorable Minister of Defense was somebody who was on the defense of that same case that Ricardo Stevenson was part of, together with, I think, other learned attorneys. And that is why the judge throughout upheld the no submission, because of the sterling defense put forward by the Honorable Wayne Sturge and others, and freed 4 men who were incarcerated for almost 20 years. So I want to commend the acumen, the preparation, and the sterling legal defense put forward by my colleague, Mr. Sturge. I am not so sure that, thank you, Mr. President. I am not so sure that Senator Al-Rawi could point to such a sterling record in the criminal system. But I can say that having had the experience of defending persons and being in that system, that the Honorable Minister of Defense and the Attorney General and those on this side, together with our Honorable Prime Minister, felt the need to make sure that such travesties of injustice never take place again in the courts of Trinidad and Tobago, and brought this bill to make sure that these will never happen. Mr. President, I also want to tell my colleagues on that side that when you think, and that's one of the reasons why when you talk about persons of who would have stood in the gateway to make sure that people are not ordinarily transgressed on or trampled on, it takes a particular kind of leader to stand and say, we not just will fix it, but we will make sure it works for the ordinary people of Trinidad and Tobago, because our system for far too long was only accessible to a few, benefited a few, taken advantage of by a few, while the vast majority of people left incarcerated behind bars with little access. This bail amendment bill fixes that and creates a sterling example of how we can have tough law with humane conditions that will serve the vast majority of Trinidad and Tobago, and that is the commitment of this government. We are going to serve the vast majority of people of Trinidad and Tobago to make sure that we remove what was previously beneficial to a few to now beneficial to the many.
Senator Janelle John Bates.
Good afternoon, Mr. President, and all in the House. Yes. Mr. President, this Bail Amendment Bill 2026 is a short one. On the face of it, it looks like a simple one. But it is one where there are serious ramifications, both in a legal context and in the day-to-day reality of the lives of those who are unfortunately involved in the criminal justice system. I want to begin, Mr. President, by making it clear that the opposition supports strong, reasonable, effective crime legislation. Legislation that addresses weaknesses in our criminal justice system. We support legislation that addresses real structural problems. Problems such as delay and backlog in criminal matters, our low detection and conviction rates, prison overcrowding, operational inefficiencies in investigation and prosecution, and outdated and opaque statutory frameworks. What we oppose are laws that are disproportionate, laws that are irrational, constitutionally careless, and unworkable in the Trinidad and Tobago context. Our constitutional role is to scrutinize legislation, especially one such as this, which goes to the heart of one of our human rights protected in our Constitution, liberty. Liberty, and especially when this liberty is being affected by new burdens that seem to be cast upon the population without due consideration and care. Now, this bill seeks to do two things. It seeks to clarify that the burden of proof lies with the person applying for bail to demonstrate exceptional circumstances or sufficient cause to grant bail in cases such as murder, and It introduces what is called a bail source hearing, a bail source hearing, which is a new and separate procedural process allowing the court to investigate the origins of funds over 30K or property used to secure bail. The first aspect of the bill appears reasonable, appears defensible, but the second aspect of this bill, though it may sound reasonable, it may appear reasonable on paper, if you examine it closely from a legal, constitutional, and practical sense, you can see it is clear that it risks damaging one of the oldest liberty safeguards in our legal system, bail. So I want to focus really on that second objective of this bill. Mr. President, I want to start by laying the foundation. Bail is not a favor. Bail is a constitutional right. Here in Trinidad and Tobago, there exists the right of individuals to equality before the law without discrimination by reason of race, origin, color, religion, or sex. Our Constitution specifies in Section 5(2)(f)(3) that Parliament may not deprive a person charged with a criminal offense of the right to reasonable bail without just cause. And that is the constitutional principle that should really remain at the heart of this debate at all times. Now, our existing law already contains recognized just causes to deny bail. They are outlined in Section 6(2) of the Bail Act. They are well known to those who practice or have had cause to come in contact with our criminal justice system, but for the benefit of those who may not have had that pleasure or displeasure, depending on where you stand, I'd want to identify some of these just causes to deny bail. The court could deny bail where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would fail to surrender to custody, commit an offense while on bail, or interfere with witnesses, or otherwise obstruct the course of justice. The court, it is in the discretion of the court to deny bail where the court believes that it is in the defendant's benefit that they are kept in custody for their own protection. The court can also deny bail where it does not have where it is satisfied that it has not been practicable to obtain sufficient information for the purpose of taking the decisions required by the section. So there are already just causes built into our bail regime. But, Mr. President, none of these just causes includes the sophistication of one's financial paperwork. And that must never be a gateway to the condition to liberty. And unfortunately, Mr. President, the new clause, as proposed by the government, does just that. Now, this new clause 6B puts a burden on persons proffering cash or real property to prove that the source of cash was derived from a legitimate source. In relation to cash, that usually requires a clear, documented trail that explains the origin, accumulation, and transfer of the cash. So the stronger the paper trail you have, the easier it is for you to prove that the source of your cash is legitimate, not dirty, as they say in money laundering circles. So the easiest way to do that is by using your bank-based funds. You could present salary deposits, you can show proof of wire transfers, loan disbursements, certified institutional records. But the reality here in this country is that many law-abiding citizens operate partly or entirely on cash. They operate in the cash economy. So, in his contribution, the Minister of Defense sought to justify the imposition of this new Section 6B by saying, It does not target any particular group. It doesn't target the poor, actually, he said. He said it has an impact on all. But the fact of the matter is that it is patent that the impact on this section would be more on those who operate in the cash economy, those who are indigent. Our central bank, in its National Financial Literacy Survey, reported in 2022 that 19% of individuals in Trinidad and Tobago were unbanked. In 2024, the TNT International Financial Center and the United Nations Capital Development Fund, they conducted a survey and they found that roughly 25% of Trinidad and Tobago's adult population lack access to basic transaction account. 1 in 4 individuals, please. Or if you take the average, 1 in 5 individuals are without bank accounts in this country. Now, some people have bank accounts, but they do not utilize it in a consistent manner. Mr. President, I am aware of hairdressers, vendors, small tradesmen. Yes, they have a bank account, but they do not often put the money that they receive into a bank account. You get paid in cash, you use the money for day-to-day living, you go in the grocery, you give your children money, you take a taxi, you put gas in your car, and if after some time they accumulate some savings, then they would put it in the bank account. So their bank account would not reflect accurately the amount of money that would have passed through their hands or they have access to. So if a family member who operated in such an informal economy brought cash, or as is said by the law, actually it should be in a certified check form if it's over 30K, or they brought a deed to secure bail, the court is then asked to launch a financial inquiry. And given the amount specified by the new clause, that is cash over 30K or a deed, it is most likely a master who will be treating with this matter, because lesser offenses, which would not attract a bail requiring 30K in cash, would go to a magistrate, and judges do not deal with bail. So a master then would be required to conduct a bail source of funds. And if they are unsatisfied, the bail will be refused. So they now have the discretion to refuse bail, not because of the nature and seriousness of the offense, not because of the character, antecedents, or social ties of the person, not because of the record of fulfillment of past bail obligations, not because of the strength of the evidence before them, but whether or not this surety could pass a financial background investigation. Now again, as I said, the impact of such a requirement is heavier on the poor, on the socioeconomically disadvantaged. And clearly, Senator Kennedy Swaratsingh agrees with me because he said so. He was at pains to emphasize that the new section without it, or with it, the impoverished are disadvantaged. And that was one of the things that was very interesting about Senator Swaratsing's contribution. A lot of the times, he supported the opposition's position. It seems he wants to come back on this side. And in the Balize, we welcome all. So welcome back. Because Senator Swaratsingh, and his timber was genuine. So I believed him, you know. He told us about the pain he felt about learning of a colleague who was incarcerated from 2005 for 20 years. He told us, because of his work in the prison ministries, he was very much in touch with the realities in prison, the conditions, overcrowding. He was so passionate about it. I was moved, you know. I can see why he was what he was in one of his previous former lives. And Senator Swaratsingh said another thing, which I know to be true. He said, I cannot speak to the legal arguments in this matter. And that was clear. Because he said stuff like, a defense in relation to no case submissions, and he spoke about the small man benefit from the proceeds of crimes. It was clear to me that he wasn't so current with the law. But, and I don't know if it's the pain he felt because of what his friend told him so early in the morning via WhatsApp, or because of his deficit as it comes to law, but he somehow was of the view that bail source hearings improved the bail structure and added clarity to the bail structure. And because of this clarity, if it was existing in 2005, his friend would be able to access bail. Far from the truth. Impossible. It is impossible, Mr. President, because in 2005, as the law stood, you could not get bail for murder. As simple as that. The existence or non-existence of bail source hearings would not have helped his friend in 2005. And that is the reality. And even today, this bail source hearing would not help his friend, because what it is actually doing is adding more bureaucracy. It is not clarifying anything. And, you know, he added on, in Trinidad, we have one of the highest rates of pre-trial detention. How does the bail source hearing assist us with bringing down our pre-trial rates by adding another hurdle to accessing bail? He then goes on to say, because of the bail source hearing, we now have a humane approach to deal with crime. How is a pre-trial detention? Because now, masters, and I'm going to get into that later on, masters now have additional things to assess that will take more time. How is that a humane approach to crime? You are actually now entrenching pre-trial detentions, pre-trial punishment. The person now is even further denied of access to bail. How is that humane? Especially given the conditions that he himself would have identified in prisons. He said that these bail source hearings would minimize the pressure in court. Again, how? Mr. President, masters who are the persons who would have to deal with this, they are overworked. They are overburdened. Let me give people an insight into the workload of a master. Masters have to deal with charge cases. Then they have to deal with initial hearings. And at these initial hearings, they have to verify the identity, the place of abode, the given address of an accused. They have to make inquiries surrounding the accused legal requirements. They have to give them the alibi notice. They have to, at that point, too, hear initial bail applications. And a lot of times, these hearings are adjourned. Then they have status hearings. After the initial hearing is adjourned, you have a status hearing, and you have more than one, to see if any orders that would have been made have been complied with. Then you finally progress to your sufficiency hearing, where you have to determine whether there's sufficient evidence to establish a prima facie case of indictable offenses. That means this magistrate has to make a decision primarily by reading statements that have been filed by the prosecution. In most of these cases, there are at least 20 statements, that's minimum, for them to read before they come to these sufficiency hearings. And these hearings, either
Mr.
side...
President, Standing Order 53-1E, there's a drone in the chamber. It's making it difficult to follow my colleague.
I'll ask members to, if you want to talk or speak, do it in hushed tones, so that we don't disturb the proceedings. Continue, please.
Thank you, Mr. President. Mr. President, after they have spent time reading these lengthy 20 or more statements, they didn't have to come to court, mark exhibits, and hear submissions sometimes by either party. And many times, the party's not ready, they have to come back again. They adjourn these sufficiency hearings to come back again. Then, when it is decided, decision is made that there's sufficient evidence, we can go to a trial, the matter is transferred to a judge, masters are still required to do case management conferences on behalf of judges. It is at this time they ensure that everything that is needed for the trial is ready. You could find all your witnesses, you have all your exhibits, you have these certificates you need. They give timetables for parties to file certain things. Any submissions in advance, tell me how much witnesses you're calling, what is your length of examination in chief and cross-examination, a lot of documents, and again, it's not one case management conference per matter, because invariably, most times, there's delay on the state side. The state is always asking for an adjournment. Then, there are bail variation applications, because sometimes people, they're given bail in the magistrate's court, they're not satisfied, they make an application, you have to come before a master to ask for your bail to be varied. They have to do jury exemptions. So when persons have been selected to be part of the jury pool, somehow people don't like to do that. I always thought it would be very interesting to be a member of a jury, but because of my profession, I'm denied. But people somehow afraid to be jury members. You have to listen to scores of people giving all manner of excuse to avoid being part of a jury. They have to do search warrants. And this is in addition to all the multiplicity of administrative duties that they have. So again, I ask, how is adding another procedure going to, as indicated by Minister Swaratsingh, minimize the pressure already faced by masters? How? They have crowded lists. These lists are not one or two matters on a CMC list or one or two. Scores of matters on a daily basis. In the other place, the government sort of minimized the burden that would arise because of this bail source hearing by saying it's just another layer in the inquiry required by Section 1. You're just adding something further to when they normally consider the suitability of a proposed surety. It's not a trial. Minister Sturge, Honorable Senator Sturge, he wanted to emphasize that. There will be no cross-examination. It won't use up time. But even if we was to suppose that this was 20 minutes, it's not one person, no. Every 20 minutes counts for a master in their day. And really and truly, if you want to investigate the roots of the source of funds, it's not a cursory inquiry you have to do, you know. Hiding the illicit roots of source of funds is a very complex thing. Money launderers know that. You have placement, you have layering, and you have integration. Those are the steps to money laundering. Layering speaks to undertaking numerous financial transactions to hide where the money comes from. So if you really have to do a proper bail source hearing, it's not a matter of, hey, bring a statement for 6 months' worth of bank statements and I look at it and, no. You have to do document tracing, cross-checking, and validation. That is very different from your ordinary surety assessment, very different. So if we want to arrest the scourge of crime, we must ensure that sufficiency hearings and trials are completed in a timely manner. And adding a bail source hearing will inevitably slow down the progress and erode the gains we would have gained with the passing of a jipper. Do we really want to go back to the days where it took 7, 8, 9, and God forbid 20 years, as identified by Senator Swaratsingh? Now, the government sought to, as they normally do, they normally bring some comparators for us to show that in other jurisdictions, something similar is happening, that we are not an outlier, this is not strange, this is unusual. But dedicated bail source hearings as a separate procedural step, it is not standard across Commonwealth systems. Actually, the government was only able to really focus on nibia holes, and I won't get into that because it was already discussed by Senator Al-Rawi. But in the bill essentials that we were provided with, the government made mention of the legislation in St. Lucia, Guyana, and Dominica, where the court is required to have regard for the financial resources of the surety when determining their suitability to post bail on behalf of the accused. And they are saying those pieces of legislation somehow lend support to this very invasive bail source hearing. But let's have a look at what the law says in Guyana. This is the Guyana Bail Act 2022, Section 26(1) says, in considering the suitability of a proposed surety to be provided for the purpose of ensuring that a person to be granted bail in criminal proceedings will surrender to custody, the court may have regard to the surety's financial resources. And I emphasize may, because that's the first thing that is different from what we have, which is a shall, despite what was said by Senator Sturge, Minister. And what does it mean by consider financial resources? Does that mean looking at the provenance of the resource or the source of cash? It does not. It means looking at the adequacy of the funds. Does this bailer have enough money in case the accused runs away to fulfill its obligation? That is what this law is about. And this law is found in the UK. The UK Bail Act 1976, Section 8 says basically the same thing. In considering the suitability for that purpose of a proposed surety, regard may be had, amongst other things, to the surety's financial resources. And I take comfort in what I'm saying in that having regard to financial resources is very different from this proposed bail source hearing, because all I have to do is look in Blackstones. I don't have to sit down here and think about it. Any criminal practitioner knows that Blackstones is almost like the holy grail, almost like the holy book for a criminal practitioner. So if you're looking for an answer, look in a Blackstone or your Archbold. That works just as well. And what does the Blackstone say? Blackstones. Like I didn't work with my copy of the Blackstones. But the Blackstones is very clear in saying that bail, having regard to the financial resources, speaks to the adequacy. That was emphasized in Section D7 in the Blackstones. You can have a look at it. It seems I didn't have mine. But trust me, it's there.
Mr. President, I'm just wondering if she could help us. What edition of the Blackstones?
2025. You can look in the 2025 edition, but I'm sure it's in all the others. D7, have a look.
That's a good guess.
I'm sure my copy is probably in my bag. I'll pass it over. Yeah? Now, oh no, look, I have it. Sorry, it was attached to I have it right here. Let me read it. D7.57 of the 2025 edition of the Blackstones, taking the surety. It says, as the surety is promising to pay money rather than handing over any money at the outset, it is therefore important for the court to be assured that the surety has sufficient funds with which to honor the undertaking given in court. And that follows the section on who can be a surety. So you can have a look there for the explanation. So, this liberty-restricting bail source procedure is highly unusual. The government has pointed us to nowhere else in the Commonwealth that has such a requirement. And where a power or piece of legislation is unusual in comparable legal systems, the burden on the government to justify the necessity, safeguards, and proportionality is higher, not lower. And I submit that the government has not met that burden. Now, the government has also sought to justify the need for this bail source hearing by pointing to CFATIF. It has been said that it is necessary to ensure compliance with CFATIF requirements. In the other place, the Minister of Defense would have said that this measure ensures CFATIF compliance, and today he said it protects the administration of justice from elements who wish to use criminal justice system to launder proceeds of crime. That is a very serious and technical claim. And because of that, it deserves a very equally serious and specific support. I submit, given the seriousness of that claim, we needed more. the Senate deserves some particularity. Now, and before I go on, I also want to again reference Senator Swaratsingh, who says that the bill helps us from being labeled a high-risk jurisdiction. He went even further than the Minister of Defense. So with these serious allegations of the need for this bill to prevent us from being listed as a high-risk jurisdiction, because being listed as a high-risk jurisdiction has serious ramifications, especially for our banking system in this country. So it has been proffered by the government that without this, we are at risk of being labeled a high-risk jurisdiction. Now, I reviewed the principal publicly available CFATF and AML CFT assessment documents related to Trinidad and Tobago. I look at the fourth mutual evaluation report of 2015. In there was no recommendation relating to bail procedures. I looked at the third enhanced follow-up report on technical compliance re-rate in 2019. No identified deficiency in bail. And these documents are 50 pages and over each. I looked at the National Risk Assessment Report for 2021 to 2024, which rates the AML legal framework as broadly comprehensive, and it does not identify bail hearings as a vulnerability. The word bail does not even appear in any of these documents, not once. Now, when in the AML CFT analysis of this country, or generally in the circles, if you are familiar with AML CFT requirements, the sectors that are usually considered vulnerable to money laundering are banking and financial institutions, securities and insurance sectors, designated non-financial businesses and professions. Again, the Minister of Defense spoke about a gang member or gang leader standing surety, using cash, and then mysteriously the person who he stood as surety for was no more. As an example of the money laundering risk associated with bail. I have never seen such an example anywhere proffered in any document as it relates to AML CFT concerns. As I said, businesses that are normally considered vulnerable do not include the judiciary. They include businesses, as we call them in this country, listed businesses such as art dealers, motor vehicle sales, gaming houses, yes, lawyers who undertake certain activities, Senator Al-Rawi, not all lawyers, those who undertake certain activities, accountants who undertake certain activities. Nowhere has it ever been listed that the judiciary is somehow vulnerable to money laundering. So my submission in the Senate, and by extension to the listening public, is that we need more in terms of evidence. If CFATF has in fact identified bail source verification as a compliance gap, then tell us what report, what recommendation we need to address, what deficiency was identified. Was the consequence? Somebody's asking. The government can't simply make an assertion and then maybe turn around and rely on confidentiality or say that the report was technical or advisory. I ain't buying that. So if that's what they're coming to say, I ain't buying it. The information I just asked for would materially assist this chamber in assessing whether the clauses in this bill, whether they are targeted at compliance, or if they are broad policy choice framed in compliance language. By requesting that level of detail, that information, I'm not trying to be obstructionist. I just want to make good law, and I need some information to do that. When we legislate in the name of international compliance, the compliance basis should be clearly demonstrated. So, Mr. President, we can be firm on crime, because I heard about strong laws. We can be firm on crime and still be faithful to the Constitution. Any derogation from a constitutional right, especially the right to liberty through bail, must be grounded in demonstrated risk. Risk of flight, risk of interference, risk of committing another crime while on bail, not administrative suspicion about your financial paperwork. If the state believes that the funds are criminal in origin, we have anti-money laundering laws and proceeds of crimes laws that already exist. And they have been said to be very robust in nature, the laws that is. And really, the problem we have in terms of compliance with CFATF and FATF is implementation. So we have the laws, use them. The tools exist, they are designed for that purpose. So my objection with these amendments, well, the amendment to bring in the bail source hearing, is not that I am opposed to financial financial scrutiny. But I don't want us to misplace that scrutiny inside of a bail law, where the question here is about attending a hearing, not about the origins of your cash. The objective of preventing illicit funds from influencing bail decisions is a legitimate one, but legitimacy aims do not cure misplacement of method, and I thank you.
Senator Francis Lewis.
Good afternoon, Mr. President, colleagues. When I received today's order paper and the supporting documents for today's sitting, I was reminded of a question of how should a batsman deal with a rising ball outside the off stump. This required, I'm not a particularly good cricketer, I have to tell you. This requires a combination of judgment, quick judgment, balance, and most importantly, knowing what not to play. And if you play it wrong, in that corridor of uncertainty, it can entice a batsman to putting the ball into hard hands. So, with that as a caution to myself, I thank you for the opportunity, Mr. President, to bring a contribution to this debate on the Bail Amendment Bill of 2026. And my focus is on what would be required for governance, better governance, effective public administration, and the optimal use of scarce judicial resources. At the outset, let me be clear. The objective, and I accept the government's objective, to strengthen the bail framework in the interest of public safety, and I think it's a legitimate and necessary one. The state has a duty to protect citizens while at the same time upholding the constitutional presumption, as has been so amply echoed, of innocence and access to justice. The challenge before us with this bill is not whether the reform is needed, but how the reform is designed and implemented. Before I turn to the substance of the bill and a recommendation or two that I may have, a quick prefatory remark would be useful. I am conscious that sometimes in the course of debate it's been suggested, perhaps sometimes, Mr. President, with more enthusiasm than reflection, that a meaningful contribution on this bill ought to properly come from those who are learned and practiced in criminal law. I take no offense at the suggestion. After all, but, Mr. President, the Senate is nothing if not a place for ideas to be robustly exchanged with perhaps a little seasoning and perhaps a little less intended condescension. However, I would remind the Honourable Chamber that the Senate was never intended to be a second criminal bar association, or its members appointed solely for litigation experience. We're here precisely because Parliament recognizes that making good law requires more than legal expertise alone. I readily concede that I am not a practicing attorney, not at all. What I hope to bring to this debate is many years of training and professional experience in the design, management, and reform of complex systems and institutions, decades in fact, including the allocation of scarce human resources, the management of high-volume processes, and the consequence of well-intentioned policies, but perhaps not which were poorly integrated into operational reality. And that, Mr. President, is the lens that I propose that we use in consideration of this bill. The legislation does not operate simply in theory. The Constitution is clear, the bill is clear, it's simple and straightforward, but its operationality is within systems. And to echo some earlier colleagues, when we add new responsibilities to already overstretched institutions, such as the Magistrates' Court, it is not enough to ask whether the provision, or to simply ask whether the provision is legally sound. We must also ask whether it is administratively workable, resource efficient, and fit for purpose. And so, with the indulgence of the Honourable Senate colleagues, and without attempting to trespass on territory of distinguished criminal law practitioners, which may worry the minister who introduced the bill, I propose to offer a contribution grounded in governance, system design, and the practical management of public institutions. I hope that this perspective is not a distraction from legal analysis, but a necessary complement to it. So, with that said, colleagues, any discussion on bail reform must be grounded in the real operating conditions of the Magistrate Court, and I will certainly take advice from those who are closer to that practical reality. Right now, as I understand it, we have 13 districts, magistrate districts across the country. I went online to try and understand how many matters do they process in a year and how many do they decide on. So what is the throughput? What is the efficiency of the system? My best information, and this is some old statistics, is that well over 130,000 cases are considered annually, with some districts, particularly Port of Spain, handling tens of thousands. There are persistent comments over successive years by various authorities of persistent case backlogs, limited number of magistrates, resource and infrastructure complaints, and a concern around increasing procedural complexity. And I am conscious of the notice from the government of a bill that will, I expect, to certainly become before the House for a reorganization of some of that, and I think that's very welcome. My understanding is that historically an average of over 142,000 cases pass through the magistrates' courts annually. And those are all statistics dating back to 2015. And I could find no official annual statistics on the volumes that are going through, except that they are quite high. And it's almost as though you're emptying the sea with a spoon. The more work you do is the more that there is. And I'm sure this leads to a high level of frustration of the practitioners in the field. In management and systems terms, a field in which I have some training and some experience, this is a high-volume, resource-constrained system. Any new statutory requirement, such as proposed, that requires an increased workload without redesigning the processes will probably slow down the entire system, which is not what I think any of us would want. Mr. President, the bill introduces several important changes, including the concept of a bail source hearing, intended to address or assess the legitimacy of funds of property used to secure bail. From a policy standpoint, that is not without merit. But there are concerns that need to be raised. How will the effectiveness of this reform or this proposed amendment be operationalized? A well-intentioned reform that's poorly integrated into an existing system can increase delays, exacerbate backlogs, undermine public confidence in the justice process, and of particular interest to me, and I know of quite a number of members on both sides of the aisle, slow down the very real social and economic renaissance that we require to move this society forward and the economy forward out of the doldrums we're currently in. So, with that in mind, who should conduct the bail source hearings? And central to that question is that the best use of a magistrate's time? So this is not about should or should you not have it. It's a question of the operationalizing of it. Magistrates are highly trained judicial officers whose core function is to weigh evidence, determine the questions of law, and adjudicate contested matters, particularly affecting liberty and rights. And most of all, they are not an unlimited resource. From a systems and management perspective, it is neither efficient and perhaps I would suggest not necessary for magistrates to personally conduct every administrative or verification function regarding what is proposed in the bill. And please, this is not a criticism of magistrates, nor is it a criticism of the bill itself. Rather, it's an acknowledgement of scarcity and specialization. So, colleagues, for consideration, could we consider a tiered systems-based approach? I'm suggesting the bill would be strengthened by adopting a tiered bail source process consistent with modern public sector management principles. The model could include initial administrative assessment, where that verification could be conducted by a magistrate's registrar, clerk of the court, or other designated trained judicial officers. And I'm reminded that the registrars of the courts have been identified formally as judicial officers. This will focus on documentation, financial disclosures, procedural compliance. Certainly, the matter may be reviewed by the magistrate for sufficiency, so that should there be anything untoward, or the source is disputed, or legal issues arise, or exceptional circumstances are claimed, then the magistrate can take the time to deal with it. But I'm proposing, can it be taken off the desk, the table of the magistrate, and put somewhere where it can be addressed? And so the magistrate continues to have full judicial determination as necessary, and the full authority to contest over contested or complex bail decisions. This process preserves, I think, judicial oversight while ensuring magistrates' time is reserved for matters requiring their specialized and required judicial judgment. Colleagues, this is not simply a legal issue. It's a governance issue. For a management system to work, you need, and what we have found and what we know, is you need task differentiation to improve efficiency, specialization to increase throughput, and parallel processing to reduce bottlenecks. By delegating the administrative function to competent officers and retaining the judicial control where it matters most, I would hope that the system can process cases faster, reduce unnecessary adjournments, improve consistency, and most of all, use in the national interest what is a skilled but limited human resource more wisely. My understanding, and it is very much subject to correction, is that this is a standard practice in a number of well-functioning Commonwealth jurisdictions, and I'm told including Jamaica, the United Kingdom, and some parts of the Eastern Caribbean. Mr. President, I want to stress that efficiency must never come at the expense of fairness. Any delegation must be accompanied by clear statutory limits, proper training of the officers who do it, registrars or other court officers, transparency in record keeping, and prompt judicial review mechanisms. But I hope in this way we can improve the process while improving the systemic performance of the whole. This bail amendment bill, I think, is worthy in its intent. It seeks to respond to real concerns about crime, public safety, and the confidence in the justice system, which is almost inimically tied to speed of how quickly a case is heard. The old adage of if you take too long, you don't receive justice, even when you do at the end. It seeks to respond to real concerns, and its success will be dependent, this bill, on whether and how it becomes operationally realistic, administratively sound, and aligned with the realities of our magistrates' courts. Therefore, I urge that as this bill progresses, serious consideration be given to structuring bail source hearings in a way that maximizes the limited time and better utilizes the expertise of magistrates, utilizes competent judicial officers for administrative functions, and strengthens rather than burdens the functioning of magistrates' court. I think, if we approach this reform with a systems mindset, we can achieve both public safety and judicial efficiency without sacrificing fairness and constitutional principles. Thank you, colleagues. Thank you, Mr. President.
Okay, I think we'll take the suspension at this time. I'd like to indicate to all speakers to come. Pay attention to Standing Order 46.1 and 53.1b, respectively. The sitting is now suspended until 5:41. Senator Rishi Tripathi.
Thank you, Mr. President. Mr. President, I am glad to be back, and if you permit me, I wish to congratulate you on your elevation to this honorable President of the Senate. And if you'd also permit me, I wish to congratulate the Honorable Prime Minister for the overwhelming mandate received in April 2025. And also wish to congratulate my colleagues who now form part of this forward-thinking, progressive government, who really will change the landscape of Trinidad and Tobago over the next 5 years. So I wish to congratulate them. Now, Mr. President, it's very important that the UNC's mandate is spoken about, because the UNC's campaign promises form part of government policy now, unlike the other side, whose whimsical promises, very flimsy promises during their time in office, the last decade, really have not panned out. Promises never materialize. So we are part of a government who received an overwhelming mandate, and one of those mandates on the campaign trail spoke to our ability to reduce crime and some of the plans that we'll put into place upon entering into office. Now, crime is something that there is no magic wand. I think we all know that by now, Mr. President. And it's something that you have to tackle from all sides. I think we can all agree on that. And as I make my contribution to this bail amendment bill today, that is one of the crime-fighting methods that we adopt will be one of the areas that I choose to focus on. But before I go into the bill, Mr. President, if you'll permit me, there's some comments I want to make about some of the contributions I've heard. Now, Mr. President, as you would know, this is not my first time in the Senate. I've been here on a number of occasions before. And unfortunately, some of the rhetoric and the theatrics on the other side, they're not new to me. We've been here before, we've seen it before, and whether in government or opposition, it just remains, like I said earlier, flimsy. Now, Senator Al-Rawi in his contribution today spoke to 40 minutes will not be enough. But I wish to ask Senator Al-Rawi, where were you for the last 10 years? You were in government. So, Mr. President, I would like to ask further. You were the Attorney General for a large percentage of that time. But today, instead of coming to tell us about why we need to amend this bail bill, you chose to give us a LLB level lecture on bail, which I think anybody could Google and get the clauses of the bail act. So I also listened with great concern the Honourable Senator's obsession with the member for Barataria Sanwan, which I personally find to be a bit concerning. And outside of the ranting and raving and the LLB level lecture on bail, I really do not see much to respond to, unfortunately. You know, when we were in opposition, we listened to Surat and Suraj every day. The number of bills that were brought to the parliament, both houses, and majorities removed. Surat. In fact, the honourable member should be called Surat Council. Mr. President, as I respond to Senator John Bates, you know, Senator Bates, in her presentation, she said the opposition supports strong, reasonable legislation. But for 10 years, you had consecutive attorney generals who brought bills, flawed legislation, that supposed UNC lawyers had to take to the court to correct. So I cannot understand how you can say, and I really empathize with some of my colleagues on the other side. When I sit down and I look at them, and they have to defend some of the actions or inactions of some of their former cabinet colleagues who sat at the table and were part of the decision-making process, and as younger persons coming into the Senate, it really bothers me, and I feel sorry for them. Now, Mr. President, you know, on the last occasion on Tuesday when we were here, Senator Al-Rawi mentioned gestation. Most of the PNM's ideas and laws remain in the gestation stage and never reach the people of Trinidad and Tobago. And on my last occasion here, back in 2023, I spoke to an implementation deficit with the PNM. You have all the ideas when you come to the parliament, but when it actually plays out in real life, it is very flawed, and it does not really touch and benefit the people of Trinidad and Tobago. Now, Mr. President, another point that my colleague Senator Bates made was that the PNM will stand in defense of liberty. But, Mr. President, as we all know, bail is not an absolute right. It is a qualified legal entitlement, Mr. President, subject to statutory restriction, judicial discretion, and public interest considerations. And, you know, it alarms me as someone who, you know, my colleague worked at the DPP's office, how quickly people forget the state of the system when it becomes politically convenient to them and their arguments. Mr. President, the senator mentioned, what about people who transact mostly in cash? Why would you transact mostly in cash in this day and age? With the crime that they have left us, would you really take the chance of keeping all that cash in your pocket? You make yourself a possible victim of crime. And was it not a PNM Prime Minister on the campaign trail who talked about ending the cashless society? In fact, it was our Prime Minister who said that she would preserve the ability of persons to choose whether they choose to go cashless or not. So we have to give credit to the Honourable Prime Minister in that regard. And the UNC once again continues to stand and defend the vulnerable citizens of Trinidad and Tobago. So when my colleagues come on the other side and talk about how they want to protect the citizens of Trinidad and Tobago, the citizens needed protection from you all. And part of the whole argument about transacting in cash, Mr. President, I learned Senator Anthony Vieira, my senior at the bar, mention that there's a parallel society in Trinidad and Tobago, or we could call it an underground society, underground economy, sorry. And part of the problem is that money is not being deposited in the bank, people are not paying taxes, and we don't know, when money goes into the bank, you have to declare a source of funds. If I represent you in court, Mr. President, as your attorney, and you mistakenly send me money to my personal account, the bank calls me immediately. Where did that money come from? If you paid me $10,000 or $15,000, depending on how well I represent you, I would immediately get the phone call. And we are moving society to a point where we need to start regularizing and start creating systems where our money is traceable. And the meat of my presentation will speak to AML. I'm very passionate about that part, the anti-money laundering element of it, and we'll speak to that. And, my colleague also spoke to adding hurdles to the masters and the judicial officers with the bail hearings, the bail source hearings. But these things already happen in practice. The discretion is already there for persons, for masters or magistrates to ask the question, where did you get the money from? Or where did you get the property from? What we are doing is simply codifying it. We simply want that in the heat of court matters, in the overburdened court system that our friend left because they refused to outsource the judiciary efficiently, that it is not overlooked, that it becomes a requirement. And it's not for every offense. It is qualified. It has to be cash in the sum of over $30,000, or where a deed is involved. And there is judicial discretion involved. That is the key element that's missing here. So, Mr. President, all the pomp and flair and theatrics, I think it's getting very old. And as I get into the meat of my presentation, the question we have to ask in Trinidad and Tobago is, are we prepared to modernize the criminal justice procedures in line with global standards, or do we want to remain in the dark ages? It has happened too many times in the last 10 years that Parliament has been rushed to convene to meet a deadline so that we don't run afoul of some international requirement, so that countries outside don't look at our investment, our country as a red flag for investments because of our lack of regularization of these anti-money laundering standards and laws. Mr. President, this bill is not about restricting bail. It is about preventing the criminal justice system from being used as a tool, as a conduit for the legitimization of unlawful assets. Mr. President, a bail source hearing, that's something that takes place in jurisdictions, we've heard, in the US with the Nebia hearings. That's a tier 1 system where it's codified. But there are many other systems in Canada, in the United Kingdom, and other places, Australia, where it's in the common law entrenched already. We just wish to codify it and put it on the law, make it a mandatory thing to take place. At its core, Mr. President, the bail source hearing will simply be an inquiry enabling the court to determine whether cash or real property used to secure bail is derived from legitimate means. And, Mr. President, sometimes I really wonder why every time we bring matters of accountability, of transparency, we get the most fight from the other side. And sometimes you have to ask yourself the question, why? Mr. President, we must situate this reform within the broader anti-money laundering landscape. Our country has faced scrutiny over the years from international organizations, and I just spoke to the fact that we've had to rush to come to Parliament to pass bills and new regulations. And criminal enterprises today are not merely violent. They have become increasingly sophisticated. And they operate through layered transactions, proxies, nominees, and front entities. And there are several businesses in the country that, have been flagged over the years for their, involvement in such. When substantial cash or property is presented to secure bail, and there's a burden regarding criminal guilt. Now, Mr. President, in a hypothetical situation, given the porous borders left by our friends, which the very capable Minister of Defense is aiming to address right now, what stops someone from, or a criminal enterprise, from posting cash bail for someone, maybe a person of interest who has been charged? And, the accused appears before the court. One of his colleagues comes and places the guarantee. And then they both abscond, and they go to Venezuela, which seems to be something that has happened a lot in the past few years. Then we have another fugitive who's just on the run, traveling back and forth freely. And where is the oversight? No, Mr. President, this bill, it preserves the judicial discretion. Bail is not automatically denied. The court must first conduct an inquiry and be satisfied that the source of funds is illegitimate before refusing bail. So that judicial discretion is preserved. The rights of the accused is not removed. Legitimate applicants retain full access to bail process, and alternative forms of bail remain available. The right to liberty is preserved, and the abuse of that right through illicit finance is curtailed. Now, Mr. President, I anticipate that, other speakers will, and those gone by already, will frame this bill as an erosion of constitutional protections. And our position is that that characterization is misplaced. The legislation regulates the manner in which bail security is assessed. It does not abolish bail or remove the court's discretion, which is very noteworthy. The jurisprudential question we have to ask, therefore, is whether procedural regulation constitutes a constitutional abrogation. And the answer to that is grounded in our constitutional framework, please, Mr. President, and reinforced by the reasoning referenced in my friend's most popular case, Surat and the Attorney General. And Mr. President, I'm hearing a constant murmuring on the other side, disturbing my presentation at this point. Yes. Anyway, Mr. President, this is not the first time that the Parliament has navigated through that constitutional distinction. Honourable members will recall the several debates where the former Attorney General Faris Al-Rawi removed this requirement at various stages. And some of those pieces of legislation include the marriage bill, interception of communications amendment, the income tax, the evidence bill, and the list goes on and on. And like I said, Mr. President, it's very unfortunate when persons on the other side come and speak in a self-righteous manner here, when in reality, they have been in power, in control of this country for majority of the time since our independence. Mr. President, another concern that could possibly be raised would be regarding privacy. And this bill explicitly safeguards that privacy that an accused should have, including the ability to hold hearings in camera and strict confidentiality provisions backed by criminal penalties for disclosure. These protections reflect a careful balancing between transparency and individual privacy. Mr. President, I wish to put on the record, as I said earlier, there is no magic bullet in solving crime. And this just happens to be one aspect of our ability to monitor the guarantees, the security being placed to allow persons accused to possibly re-enter society. I cannot see in what world the accountability element, why it would cause so much unrest on the other side. We will continue to tackle crime head-on from different aspects and different elements. Unfortunately, these also went a particular way. And I don't think we know our Prime Minister very well. She's a very determined person, and we will continue to bring good law to this Parliament and continue to take on the fight. And I wish to implore all members of this Honourable Senate to support this bill as one of the necessary steps in the fight against crime and the oversight against the criminal element. And I wish to commend the Honourable Attorney General, the Minister of Defence, for the work that they've done on this bill. And I hope that all members are inclined to support, and I thank you for the time.
Senator Raj, Senator Melanie, Roberts-Radgman.
Thank you, Mr. President, for the opportunity to join this debate at this time. Mr. President, I join this debate with a very high level of decency, of decorum, of civility, and of complete respect for what this esteemed Senate is meant to represent. And for the sake of expediency, because I think we've quite well ventilated the issue so far, I will not spend too much time, I wouldn't spend any time actually on those aspects of the bill with which I take no umbrage. Rather, I would focus on the reasons why I join with my colleagues on the opposition bench in rejecting those clauses which introduce an arbitrary and an unfounded distortion of the true intent and purpose of bail. Mr. President, we would have heard Senator John Bates state it very clearly. Bail is not a privilege. It is a constitutional right. And despite any attempt that any government might make to erode all of the rights or some of the rights that we are entitled to as citizens of Trinidad and Tobago, whether outside or inside of Parliament, once we get to this Senate, we have a duty to preserve and to protect those rights at all costs. So we have before us these proposed amendments to the Bail Act, which now imposes a hearing requirement whereby an accused must prove the legitimacy of the source of funds or property being used to secure their bail. And the court must be so satisfied of the legitimacy before the accused can be released. What troubles me at the outset is the wording of clause 6B1. It says a court shall conduct a bail source hearing in relation to all offenses wherein attempting to post or secure bail, and then it goes on to the conditions. And when the Honourable Minister piloted the bill, I guess he anticipated the arguments or the concerns that would be raised on other sides concerning this wording. So he hastened to mention that although the word shall is used, the court does in fact have discretion as to whether or not this source of bail hearing is carried out. Mr. President, if that was indeed the intent from the get-go, then I ask the question, why did the drafters not use the word may to avoid any concern in the first place? As written, Mr. President, this bill does not give the court any discretion to determine whether the circumstances are such that it is necessary to even impose such an inquiry in the first place. Now, a few other concerns come to mind, and whether I take these concerns individually or whether I look at them collectively, they all provide sufficient reason to reject the amendments that are presented to the Senate here by way of this bill. Now, one of the most obvious concerns is the undermining of the presumption of innocence. This is a fundamental and a foundation principle in any criminal justice system. Every person that's accused of a crime, you're treated as innocent unless and until the state proves your guilt. The burden of guilt is on the state, not on the accused. The accused doesn't have to prove their innocence or explain themselves. Matter of fact, the accused has the right to say nothing whatsoever. Throughout the entire process, the accused is meant to be treated fairly, no punishment, no stigma, no adverse inferences, simply because a charge exists. Being arrested and charged or attracting public outrage does not equate to guilt. Conviction follows evidence, not suspicion. The presumption of innocence is there to protect the individual from the immense power of the state. Without it, we would have persons being punished merely based on accusation and nothing else. And if that were the case, imagine how our parliament might look today. Now, Mr. President, the presumption of innocence is, thank you, constitutionally protected. It is a substantive right. When the government seeks to amend the Bail Act to include this new proposed, and I'm looking at Clause 6B and the related amendments that go along with Clause 6B, what they are doing is effectively shifting the burden from the state onto the accused, such that the accused must now justify his or her finances in order to secure his or her liberty before the trial has even begun. And it seems like a presumption is now being imposed on an accused, a presumption of financial wrongdoing. And the accused is now given the burden of disproving it even before he or she has stood trial. So the question that arises in this instance is the government really asking or expecting this Senate to be complicit in the unlawful suspension of the presumption of innocence in criminal matters until such time as a court can be satisfied as to the legitimacy of the source of bail for an accused? Is that what we're meant to do here today? And, Mr. President, this feeds directly into my next point. And it has been said here, it has also been said in the other place, and whoever wants to talk about it as a LLB or I guess 1L version of criminal law 101. Bail has one narrow purpose, and that is to ensure that the accused person returns to court when he or she is expected to do so, and that they don't, while they're out on release, interfere with the criminal justice process. Now, what this proposed bail source hearing does is that it converts bail into a whole other pre-trial sort of sanction, so that bail becomes a financial investigation more than a risk investigation. So both the accused and the courts will now be burdened by this inquiry that is unconnected to bail risk. We must contemplate the question, Mr. President. Are bail hearings really the appropriate forum for financial investigations? Usually a bail proceeding is quite limited in its scope, and it's meant to be quick, it's meant to be expeditious. Bail proceedings were never designed to determine proceeds of crime or to trace financial flows or title to property or assess business records or anything of the sort. We have other legislation and other fora to deal with this. These kinds of inquiries are not appropriate at this stage. They're not meant for the bail stage. Bail is meant to be preventative. It's not meant to be punitive. The conditions that usually attach to bail are meant to be the least restrictive as necessary. They must be reasonable and they must be proportionate. What the government is trying to have us do today, what they're asking us to do, is take a position that is quite inconsistent with the long-standing principles of criminal justice in Commonwealth jurisdictions, and they're asking us to completely redefine bail. We're being asked to sanction de facto detentions without any conviction. Now, imagine in a real and practical sense that an accused is being arbitrarily detained, not because he doesn't qualify for bail, but simply because the source of his bail has not yet been traced. Probably not even his fault. Long, winding, ongoing, maybe inefficient administrative process, but he's locked up and he's waiting there at the mercy of this process. And Mr. President, while I'm talking about the dual burden that this bail source hearing creates, let me expand a bit. So you have a source of bail hearing which requires detailed and financial inquiries, and this is bound to take some time and some resources. And while the inquiry is taking place, you have the accused remaining in custody, not because he or she is dangerous or because they wouldn't show up to court, as I've mentioned, but because the necessary paperwork is not available, or the procedure itself is moving way more slowly than it should. And Senator Al-Rawi would have even touched on this, especially where the tracing is concerned. Every single time I stand to contribute in this Senate, I mention the fact that when we come here to legislate, we need to do so with the full awareness of the culture and the system in which we exist. Whatever we do in here, it affects all of our lives once we go out there. And in many cases, the source of bail inquiry will not be a quick or a simple process, and I've heard several senators mention this before. And let me hasten to add that the wording of the bill, as presented right now, it doesn't give the court any discretion where this is concerned. It says that the court shall conduct the hearing in all offenses. And let me humanize it a little bit more, because oftentimes we come here and we're well-dressed, we know fancy clothes, and we sit in this chamber and we legislate on crime and criminality in particular, this topic of crime, and we think of ourselves as above or out of the reach of these matters. But the reality of it is that any one of us could get touched up, any one of us could get caught up in the system. For instance, this week right here in this chamber, things got a little bit heated at the end of Tuesday's debate, and threats of assault were made, and one member even had to be kind of calmed down. Now, imagine if that had gone south. Right in here, people might have been facing assault charges, and the issue of bail and possibly of a bail source hearing would arise. And then you would have had the accused, if we have this bill in effect, if it becomes an act, you would have the accused sitting in prison until such time as his or her source of bail has been investigated and legitimized. This is how easy it touches and affects us even in here. Now, let me take it out of the chamber and place it in the street for the average Trinbagonian. I've heard it mentioned, so I wouldn't go into too many details about it, but I would very briefly mention it, Mr. President, because I feel like it has been trivialized a bit. Many persons, this is the reality, many persons operate in the informal economy. They don't keep formal accounting records. So we spoke about our market vendors, your people selling fruits and vegetables on the side of the road, your doubles vendors, your barbers. They don't bank everything. And then think about who usually comes to pay bail. In a lot of circumstances, it's mommy, daddy, a grandparent, an older aunt, sometimes even few family members and members from the church or the community scraping together to make up the 30,000 or the 10,000 or how much ever. Now, they've done nothing wrong. They're not facing charges. They live maybe informal, maybe simple, but very lawful livelihoods. Now, when they go to bail a son or a daughter or a nephew or a grandson who find themselves in some nonsense, they're now made to face this sort of intimidating and long-winded investigation into where they get the money from. Now imagine poor Tanti, not accused of any offense, but now she has to reveal her personal financial information, she has to justify her savings, and she basically has to defend her own money before a court. Are we really willing to criminalize poverty or simple living? And I heard the comments to this observation, I heard the response to this observation that Senator Tripathi gave. And I asked the question, is it that the government is now taking to task citizens who choose to deal in cash? Because when you look at the Bail Act, and you look at Section 12(4)(a) of the Act, it actually says, where security is given for the grant of bail, it may be in the form of a cash or certified check. It actually says bail can be given in the form of cash. So a person dealing in cash, they're not doing anything unlawful. They're not doing anything that warrant the kind of response that I've heard coming from the other side. And whether or not we want to admit it, this source of bail hearing, what it does is it's part of the criminal proceedings, and we now have innocent persons being dragged into being a part of a criminal proceedings. Now, remember, when we legislate, we can't just think about our intent. We also have to contemplate the likely outcomes. And these two things do not always align. So we have to think about the practical realities, the implementation, and what happens down the road. And, Mr. President, whether or not we want to admit it, whether or not we want to accept it, these amendments do represent quite a serious intrusion into the privacy and family life of innocent citizens where there's no wrongdoing alleged, but these persons must now face the court. And sure, I admit that the bill itself does contain a few confidentiality provisions, but innocent persons, an old aunt coming to bail, her grandson or nephew, shouldn't have to put their information out there like that in the first place. So now we have the burden of the accused being locked up for however long while waiting for this bail funds to be, source of funds to be legitimized. Then you have a loved one on the outside tied up in the court trying to prove the source of funds or title to property. And they are not the only parties who are burdened in this. We also have the court. And I wouldn't talk much on this because I think Senator John Bates did a remarkable job in taking us through the kind of burden that it puts on our judicial system. She spoke extensively about all that masters already have to deal with, all that they have to do. She spoke about the shortcomings of the system, some inefficiencies, the heavy workload. So I don't need to really rehash this, except to say that when we have an already overburdened criminal justice system and a somewhat inefficient criminal justice system, we already have there one root cause of crime. When you add further burdens to this system, you're not really addressing crime. What you're really doing is creating a problem to try to solve another problem, but adding to the problem that you thought you were solving in the first place. Now, Mr. President, let me just very briefly go back to a point that I should have explored when I spoke about the presumption of innocence. We know that in criminal law, the state is the one who proves criminal conduct or illegality. The accused will have to prove legitimacy or innocence. The burden is on the state from the start. Now, the amendment that's being proposed, what it does is it starts a very dangerous precedent, and it's one that reverses the burden of proof. That any government, that this government, would even seek to threaten the principles of due process or principles or the presumption of innocence is deeply troubling to me. And once the Senate accepts such a shocking reversal of bail, or such a shocking reversal, I should say, of the burden at the bail stage, the question then arises, what prevents similar reversals at various stages in the process? We have to be mindful that once we open the door to burden shifting as a norm, it might become a door that we cannot close later on. It becomes a runaway horse. Once the foundation of the constitutional structure that protects liberty starts to shift, the entire framework is put at risk. We start this now, there's no telling how far this goes. And let me just preempt this. This is not fear-mongering. I know we probably hear that in rebuttal. what this is a fair warning against going down a judicial and a constitutional slippery slope. Now, Mr. President, there are two final points that I want to touch on very briefly before I wrap it up. In piloting the bill, the justification presented by the Honorable Minister, he said there were two things that the bill meant to deal with. And the second thing that he mentioned is that the amendments are meant to address the laundering of money through the use of the criminal justice system. And then, as Senator John Bates pointed out, he mentioned the occurrence, of gang money being used to secure bail, and then the accused is executed shortly after release, and the bail money is now cleaned. Now, be that as it may, we have pretty strong laws in place to deal with criminal proceeds. Does enforcement require some cleaning up, some tightening up, perhaps? And we can address that. We can address that without eroding constitutional and judicial principles upon which our system here is based. Now, if the state suspects that criminal money has been used or is going to be used, then the appropriate response would be to enforce the laws and the procedures that were established precisely to deal with these concerns. There's the Proceeds of Crime Act that allows a prompt investigation into bank accounts, assets, and cash of a person who has been arrested, especially where that person's lifestyle or the assets don't line up with their legitimate earnings. And the beautiful thing is that the Proceeds of Crime Act doesn't replace due process. It actually runs alongside it. So we have a more legitimate way. We have a more constitutionally safe way of addressing the government's stated concerns. You can make an application to the court for a restraining order if you want to freeze bank accounts, valuables, vehicles, if you want to stop the sale or transfer of property. Why not use these powers of restraint and confiscation? Use them. You're found guilty, all right. The state take your cash, sell your property, seize the assets. The important thing here is that the convicted is deprived of any profits or any proceeds from his crime, but at the same time, he is not deprived of his constitutional rights and protections. No one on this side is disputing that criminal proceeds should not be confronted. What we're saying is that bail is not the appropriate mechanism for carrying out that task. And Mr. President, Madam President, Mr. President, Mr. President, yeah, okay. Presiding officers, all right, Mr. President, my final point. And my final point is actually a few suggestions to address the government's stated aims in a safer and more responsible manner. As I would have mentioned, we have POCA, and of course we have the Police Service Financial Investigations Branch and Civil Assets Registry. We need to look at whether our financial enforcement is maybe too slow or maybe under-resourced in its current state. That's something that we probably need to consider. We should give consideration to allowing bail to proceed on its traditional grounds, but then look towards tightening the legal mechanisms that trigger immediate financial investigations post-release or alongside. Now, if there's sufficient evidence to warrant it, apply restraint orders. The idea is to carry out the ongoing financial surveillance while the accused is on bail. So you don't deprive them of their right to liberty, but you still do what you need to do in terms of investigating the source of their funds. So basically, the financial investigation, it runs parallel to the criminal investigation. And of course, being on bail doesn't shield your assets from restraint. This way, we preserve liberty, as I mentioned, while still pursuing enforcement. Now, I know that the minister indicated that, no amendments whatsoever will be considered. Nonetheless, if the government insists on these source of bail hearings, then consideration should be given to having the court have some discretion, and in this regard, you just remove the word shall and you replace it with may, to determine the necessity of the hearing. The Honorable Minister mentioned that they will have discretion. The court will have discretion to determine the form of proceeding, and he mentioned that despite the use of the word shall, there is discretion to determine whether or not there is even need for the proceedings, how the proceedings will happen if the hearing needs to be carried out in the first place. So if that is indeed the case, if that is a true representation of the government's intention, then simply replace the word shall with may, give the court discretion in the first place to determine whether or not such an inquiry is even necessary. I think too that it's necessary, if we're going to go down this road, to have very strict time limits for conducting the hearing. We would have mentioned on this side, and I've heard it coming from the independent bench, the kind of time lapse that takes place while this hearing or while the inquiry is happening. We need to put in place certain safeguards. So time limits for conducting the hearing, and I would go as far as to say the burden should remain with the state to first raise even doubt about the legitimacy of the source of the bail. And I also heard Senator Lewis raise concerns about having the necessary, pointing the wrong way, about having the necessary safeguards and systems in place. And I heard Senator Al-Rawi SC also speak very briefly about the ecosystem that is necessary to even begin to implement something like this. And when Minister Sturge first piloted the bill, he admitted that there's no framework in place for these hearings. He said the court has full discretion to determine the proceedings. So there's no guidelines, there's no regulations, there's no policy, there's nothing in place. So I don't know to determine what. And yes, strides have been made. The previous administration would have made great strides. So we know that several divisions of the court were created. We know that we had the magistracy digitized, we had the land registry digitized, persons can now make online payments, and quite a few strides were made. But there is much more that has to be done before we can even think about making these types of hearings efficient. Madam Vice President, in closing, I would repeat what we on this side have been saying over and over again. As a responsible opposition, we agree with fighting crime. What we are opposing here is fighting crime by eroding constitutional principles, burdening the innocent, and redefining bail and making it into a financial trial. The recommendation is that the government explore safer and much more lawful ways to achieve their stated aims. Madam Vice President, I thank you.
Senator Michael S.V. Dilawasi, SC.
Thank you, Madam Vice President. Madam Vice President, I have not practiced at the criminal bar apart from probably one case in the magistrate's court early in my career. So I'm very interested. I'm interested in what all the senators have to say, but I'm particularly interested in what my colleagues who are attorneys at the criminal bar have had to say on this bill. I have listened with interest to the Honorable Minister, Ms. Senator Vieira, who has practiced earlier in his career at the criminal bar, and I await with great anticipation the contribution of Senator Chote, who is, I believe, still practices at the criminal bar. However, as an attorney, I have practiced at the civil bar, and in that regard, I've had some experience considering and analyzing and construing legislation. And on that basis, I've looked at the bill, and I have some questions which I'm hoping the Honourable Minister will address. I'm hoping Senator Chote will address as well. Now, Madam Vice President, we have heard already that the bill has two purposes. One is to amend the Bail Act to clarify the legislative intention that Parliament has attempted to express by way of section 5.5 of the Bail Act. And the other purpose is to amend the Bail Act so as to introduce provisions that will prevent or at least make it more difficult for an accused or surety to post or secure bail using cash or real property that has been obtained by illegitimate means, whether by the accused or surety or someone else. Now, Madam Vice President, it seems obvious that it is in the public interest that Clause 5.5, subsection 5 be clarified, and more so that cash or real property derived from illegitimate means or from sources derived from illegitimate means should not be used to post or secure bail. So I support those purposes. I am very keen to have legislation in place which will prevent or reduce the risk of what I shall call dirty assets from being used to secure post bail. And I do not want perfection or the objective of getting it entirely right to be the enemy of good. So the bill may have some flaws. That is not going to prevent me from supporting it if it achieves the purposes that I've mentioned. And Madam Vice President, I will now turn to the first purpose of amending subsection 5 of Section 5 to clarify the intention behind that provision. The amendment is introduced by Clause 4 of the bill, but before going to the amendment and subsection 5, I think it's useful to start with just briefly referring to some of the other subsections of that section, clause. This is, well, I should say section because I'm dealing with the Act now, as it is now. Under Section 5.1, a magistrate may grant bail to a person charged with a summary offense. That's straightforward. Subsection 2A is also straightforward. A judge or master can only grant bail to a person charged with murder where he can show exceptional circumstances. Under subsection 2C, the judge or master can grant bail to a person charged with offenses triable either way. Subsection 2B is clear but surprising. It provides that a judge can grant bail for indictable offenses except those listed in Part 1 of the first schedule. So it seems there is no possibility of bail being granted to persons charged with piracy, treason, and capital offenses other than murder. This would seem to be unconstitutional according to the judgment in the Privy Council judgment in Achille Charles. So I should just immediately suggest or recommend that the Clause 4, where it introduces new Section 5, and where that new Section 5, 2B, should be amended just to say an indictable offense. And the words except an offense listed in Part 1 of the first schedule, which refers to piracy and treason, should be struck out. And perhaps dealt with, if you want to deal with it and say that you need exceptional circumstances to get bail for those offenses, put that included in subsection 2. But I certainly don't think that you should outright take away the discretion of the master or judge to grant bail for those offenses. So I come now to subsections 3 and 4, Madam President, which are a little more involved. And perhaps they've been covered already, but suffice it to say that under subsection 3, where a person is charged with one of the offenses specified in Part 2 of the first schedule to the Act, and I'll call them subsection 3 offenses as a shorthand. When a person is charged in the circumstances set out in subsection 3, a judge or master can only grant bail to that person if he can show sufficient cause why his remand in custody is not justified. Under subsection 4, where a person is charged under section 6 of the Firearms Act or with an offense in part 2 of the first schedule to the Act, I'll call those offenses subsection 4 offenses. In the circumstances set out in subsection 4, I'll call that subsection 4 circumstances. A judge or master can only grant bail to that person charged if he or she can show exceptional circumstances to justify the granting of bail. So, Madam Vice President, in summary, under subsections 2A, 3, and 4, the discretion to grant bail to a person charged with murder in any circumstances and to a person charged with a subsection 4 offense in subsection 4 circumstances is limited. Bail can only be granted in such cases where the person charged can show exceptional circumstances. Further, a person charged with a subsection 3 offense in subsection 3 circumstances is also limited. Bail can only be granted where the person shows sufficient cause why his remand is not justified. But then we come to subsection 5, which provides that where a person is charged with murder or with a subsection 3 or subsection 4 offense, he has a right to apply to a judge or master for bail in 2 scenarios. A, where he has been brought before the court and no evidence has been taken within 180 days, and B, where even though evidence has been taken within that period, the trial is not completed within 1 year of the reading of the charge. Now, Madam Vice President, as the subsection 5 confers the right to apply for bail in those circumstances where those deadlines have not been met, it means that the judge or the master has a power or discretion to grant bail. It would make no sense for Parliament to give someone a right to apply for bail if it did not intend that the judge or master should have a discretion to grant bail. So it seems clear that subsection 5 provides that if the deadlines in that subsection have not been met, the judge or master has a discretion to grant bail to persons charged with murder or with subsection 4 and subsection 3 offenses. But the question is, are there any limitations on the scope of that discretion? When I say that discretion, I mean the discretion that no doubt is granted, is conferred by subsection 5. Subsection 5 itself does not limit that power or discretion to cases in which exceptional circumstances are shown or sufficient cause is shown, not expressly anyway. But subsections 2A and 3 and 4 do. It could be argued that it makes no sense for subsection 5 to provide that if the deadlines set out therein are not met, then the discretion to grant bail for murder and for subsection 3 and 4 offenses is the same as it would be if the deadlines had been met. If that is the case, then why have subsection 5 at all? It is mere surplusage. And the courts, in construing a statutory provision, operate generally on the presumption that Parliament intended that a provision have some effect. Thus, the argument can be made that to give it some meaning or some effect, subsection 5 is to be construed as providing that if the deadlines set out therein are not met, then the limitations on the scope of discretion to grant bail for murder and the subsections 3 and 4 offenses do not apply. Now, all of that is to say, Madam Vice President, that it appears that the amendment to subsection 5 is effectively, what it says effectively is that even if the subsection 5 deadlines are met, the scope of the discretion to grant bail for murder and subsection 3 and 4 offenses is the same as that where the deadline is met. So in other words, it's meeting the argument that I said could have been made, and it's saying it's defeating that argument because it's saying, in effect, this subsection is surplusage. Do not, it's expressly saying this subsection, even if the deadlines are not met, it doesn't confer a right to grant bail that is any different to that which is granted under subsections 3 and 4. You still need to show exceptional circumstances. Because I believe that argument had been used, or may have been used, I'm not sure, in the case that the Honorable Minister referred to that was determined by Madam Justice Melanie Singh. And so in that sense, I think there's an attempt to clarify the law. But I suggest that if the government sees subsection 5 as surplusage, instead, and that it really should be given no effect, instead of doing the amendment that it has done, it just take out subsection 5. That is one of the options that the Honorable Minister, I believe, mentioned. And I would recommend that option, because I believe if you leave it, if you pass the amendment as it is, what it does, there is a danger that it leaves room for the argument that given the common law presumption that Parliament intends a statutory provision to have effect, and that it is not to be construed in a manner as to render it odious, given that presumption, there's an argument that even if the amendment is passed, even if the amendment is passed, the argument could be made that in giving the right to apply for bail after the expiry of the deadline expires, the implication is that for these offenses, there is no right to apply for bail and no discretion to grant bail prior to the expiry of the deadline. That is to say, during the 180-day and the 12-month period referred to in subsection 5. So the same argument. Now, I don't know if that is the intention of the government in making the amendment. Now, it would seem to me that if that argument were to succeed, then if that were the intention, it would be defeated by the decision in the Achille Charles case as being unconstitutional. And maybe that argument wouldn't succeed, but my point is, why leave it to chance? Why not just take out subsection 5? Instead of trying to address an argument that had been made in a case before, why not simply take out subsection 5 and take out the risk of the section being construed as denying, as providing that the magistrate or the master or the judge had no discretion to grant bail during the 180-day and the 12-month period. Now I turn to the other purpose of the bill, which is to prevent or at least make it more difficult for dirty assets to be used to post or secure bail. As I have said, this purpose, Madam Vice President, is laudable. Any person, Madam Vice President, any right-thinking person would balk at the idea of the assets of a victim of crime being used to post or secure bail for an accused who may himself be a criminal. So in other words, dirty assets may be derived from crimes committed on persons, and it really, no one would think, everyone, I should say, would want to reduce the risk of the assets taken from victims being used as bail for other criminals or persons who might be criminals. But as I say, Madam Vice President, we have to look at the means by which the bill attempts to achieve that, the purpose. And I go to the amendment, and I have a few concerns about the way in which the bill seeks to achieve that purpose. And I go to amendment. The amendment to Section 3 of the Act set out at Clause 3 of the bill. This is the amendment that introduces the concept of a bail source hearing, and which it defines as an inquiry conducted by a court, either on its own motion by a court or at the request of the prosecution, with a view to determining whether the source of cash or real property used by the accused to post or secure bail was derived from legitimate means. Madam Vice President, my problem is this definition read on its own suggests that the bail source hearing is not something that is mandatory, but rather that the court has a discretion to hold such a hearing. The definition provides that the hearing may be conducted at the request of the prosecution or on the court's motion. But the fact that it's at the request of the prosecution would suggest that even if the prosecution requests such a hearing, the court may refuse the request. Now, of course, I'm saying this is what the definition appears to suggest when it's read on its own. The difficulty arises when we come to Section 6B, which Clause 6 introduces into the Act. Section 6B1 provides a court shall conduct a bail source hearing, which we have already looked at the definition of a bail source hearing, which suggests it's something that the master or judge has a discretion to have. But in this section, a court shall conduct a bail source hearing in relation to all offenses and it sets out the circumstances. So this clause appears to make a bail source hearing mandatory. Now, I know the Honorable Minister of Defense has said that shall may, sometimes the court may interpret shall as may. Shall might be considered, may be interpreted as mandatory or directory. But I think there's a strong argument to be made that looked on its own under Section 6B1, it's a mandatory provision. But I agree it's complicated by the fact that the actual definition suggests that a bail source hearing is something the court has a discretion to have. So my question is, what does the government intend? Does it intend for such a hearing to be mandatory in relation to all offenses where in attempting to post or secure bail, the accused or the surety presents a cash in hand, etc.? I believe, if I'm correct, that the Minister of Defense has said that's the intention, that it's to be in the court's discretion. But that may be the intention, but a court at the end of the day will have to determine that and go through that, maybe it's arguments as to whether it's directory or mandatory. Why leave it to that? Why leave it to the courts? If it's discretionary, simply make the minor amendment to change shall to may, and I believe this is something Senator Roberts-Radgman had mentioned. If you want it to be mandatory, change shall to must. And I believe in the United Kingdom, I'm told that they've stopped using shall, and where they mean for it to be mandatory, they say must. And where they want to have a discretion, they say may. So let's just make a minor amendment, if that's what the government intends, that for it to be a discretionary thing, to me. The other issue I have, the senators have raised a number of issues. Senator Vieira, Senator Al-Rawi, Senator Chote may raise some issues, Senator Francis. I'm not going through those again. I hope those are addressed. So the other issue that I'm raising, which I don't believe, Madam President, anyone has raised, starts with Section 6B2. This is the proposed Section 6B2, which provides, during a bail source hearing, the burden of establishing that the source of the cash or real property used to post or secure bail was derived from legitimate means shall rest upon the person proffering the cash or real property. So the subsection suggests that the Act requires the person proffering this cash or real property to establish or prove that cash or real property is clean, in the sense that if he does so, there is some consequence or benefit, and if he does not do so, there is some detriment. In a criminal trial, the prosecution bears the burden of proving guilt in order to obtain a conviction, and if it fails to do so, the defendant is innocent. What happens in this context if the person proffering the cash or real estate fails to establish that those assets are clean? Now, Section 6.2 of the present Act may appear to provide the answer. Well, if Section 6.2 provides, where the offense or one of the offenses of which the defendant is accused in the proceedings is punishable with imprisonment, it shall be within the discretion of the court to deny bail to the defendant in the following circumstances. And then the subsection sets out at present 7 different circumstances or scenarios. Now, Clause 5 of the bill that is before us would introduce an 8th scenario that would trigger the court's discretion to deny bail. And that's H. And that says, where the court, having completed a bail source hearing, is satisfied that the source of cash or real property used by the accused of the surety to post or secure bail was derived from illegitimate means. So the words that the provision here that the court must be satisfied that these assets are dirty would suggest that the prosecution, the prosecution must persuade the court at some level that they're dirty, which is inconsistent with the other section I read, which suggests that the burden, which expressly states that the burden to show that the assets are clean is on the person proffering the assets to post bail. So I'm having a difficult. Is it that if that burden is not discharged, then the magistrate is deemed to be satisfied that they're dirty? So I'm having a problem with that provision. I would recommend that the burden that is placed on the person putting up the security to show that they are clean, that be removed, and that we simply have the provision H that says where the master or the judge is satisfied that the assets are dirty, then she has a discretion, right? It doesn't mean that she has to deny bail, but she has a discretion to deny bail. I think to place the burden of showing that they are clean and to make that in other words, in order to deny, in order that, sorry, let me start that again. To place the burden on the person who's putting up the assets to show that they are clean, especially if they are the accused, I have a problem with that because for reasons that have already been stated, persons may not have, they may be legitimate assets, but they may not have the records to prove that, especially if they are not sophisticated, perhaps people, they operate on an informal level, or business-wise, or let us say they have to sell assets, not land, but they raise cash because they're selling assets all over to various people. Maybe they're selling the produce, the equipment, and they're selling it cash. To have to bring it's very difficult to prove that I got this cash from about the sale of 5 or 6 different items to different people. Also, if the accused is, and this is a point that was raised by someone else to me, but if the accused is in custody, it may become very difficult for him to get the records, get the evidence, go to the bank and say, I want this statement, because he can't go to the bank. He's in custody. So, I mean, And the other senators may have shown other difficulties, but as to why other reasons as to why this burden should not be placed on the person putting forward the assets. I have no idea, and I will rely on probably what Senator Chote has to say, what the Honourable Minister has to say on what the impact of the bail hearing and having to have a bail hearing, especially if it's mandatory, what the impact will have on the criminal justice system in terms of causing delays, in terms of extending the period of time that people are held on remand because they can't get bail, because they can't get a hearing. So, on the one hand, I'm very interested, I'm very keen, I'm very concerned that we have legislation in place that allows the court to review, if you like, the cleanliness of these assets that are being put forward, to reduce or the risk of dirty assets being put forward as to post bail and so. I think that there's a certain, to achieve that purpose, a certain impingement on perhaps constitutional rights is warranted, because as we know, it's a matter of proportionality, and but the things that concern me are the mandatory aspect of having this bail hearing, and more so the placing the burden, apparently, to show that the assets are clean, placing that burden on the person, on the accused. I like the provision H as it is on its own, where the magistrate has to be, the master or judge has to be, or magistrate has to be satisfied that the assets are dirty. I believe that if a magistrate is satisfied of that state of affairs exists, then she should or he should have the discretion to deny bail. And so, Madam, I don't think I used up all my time, which is a good thing. And that's all I have to say. Thank you very much.
Senator Chote.
Madam President, I must apologize. I think my turn to speak came a bit more quickly than I had anticipated that it would. I am mindful of the fact that as a senator, I am entitled to speak on each of the clauses of the bill under consideration. I am also mindful of the guidance given by the Honorable President of the Senate, which is to say that I will do my best to try to avoid repeating any points or arguments made by my colleagues. If I have to, because my perspective is different from theirs, of course I see myself free to do so. Now, I look at this piece of legislation as I look at any other piece of legislation brought before this Honorable House, and the first question I ask myself is this: why do we need it? Now, in listening to the Honorable Minister, I got the impression that it was somehow connected to trying to combat money laundering. So the next question I ask myself is, if it is that we need to combat money laundering, do we have any evidence produced before this Honorable House to suggest that there is a problem with people using their certified copies of their deeds or their certified checks, which they deposit into accounts held by, I think it's either the Judiciary or the Ministry of Finance, I'm not sure. But is there a problem with that, which has arisen and which needs to be addressed? And alas, I have not heard any such mention of there being such an issue. But let's assume that there is such a problem and we need to address it. The next step I think I will go to is to say, well, does this legislation, as it is drafted, address the problem we are trying to solve? And before I go into that, I think I want to say that I have not at all been convinced that this legislation is necessary to deal with a money laundering issue. Not only have we not been provided with any information to suggest that that is the case, but I looked at the Trinidad and Tobago, it's a long name, National Anti-Money Laundering, Combating Terrorism, Financing, Countering Proliferation, Financing Policy and Strategy, which came from the website of the FIU. This is a very long document. The foreword is signed by the Honorable Attorney General himself. The minister producing this legislation to this Honorable Senate, alas, was not a member of the group of ministers which formulated this policy, but nonetheless, I looked to it for direction. I looked at it for direction to say that in considering all the big issues which this group takes it. Sure.
Can I just ask about the date of the NAMLAC report?
It's the 9th of December, I believe, of 2025. I can go back and check it online, but I think it's the 9th of December, 2025. So in this report, I look to see, I say, okay, well, it's not given to us in the Senate, but I look to the document to see whether this was flagged as an issue, whether this was a big thing which was harming our economy and which we needed to address as senators. If that is the case, obviously we need to address it. Unfortunately, I don't see anything in that document which flags this as being a problem. Now, they say lawyers tend to be a little cynical, and I wouldn't deny that, but I want to refer to what is said in one of the cases referred to during the debate here today, and that is the judgment of Justice Carol Gubin, who I think is now the most senior High Court judge on the civil side. It's a decision of Bagu and Martin. Claim number CV 2020 of -03015 and claim number CV 2021-00626. What the judge was doing in that case was looking at the judiciary's policy in how they handled sureties, that's to say, people who come with their deeds and their checks and so on, who came to have their documentation approved by the judiciary before bail was granted. And this is what Justice Gobin had to say. The remandee population has grown as a result of successive governments' first response to uncontrollable levels of crime, to impose limits on bail rights, bail orders fixing exorbitant sums, which very often make bail inaccessible. And the Honorable Judge goes on. So the cynical side of me said, well, if I'm not given information in the Senate, and if I can't find it in these high-level reports, then is this legislation really intended to deal with the issue of money laundering? But I will say, let's, for the moment, say that it is, because we can't rule it out. Let's say that it is. So how does that work practically? Someone is charged for a criminal offense. Under JIPA, that person is taken before master. That person has what we refer to as an initial hearing. A JIPA says that one of the things which must take place at that initial hearing is the issue of bail. That is to say, the bail application is made and determined by the master. Of course, there are circumstances where it can't be finished in one day. One would imagine if people have to be traced and so on. But the contemplation of a JIPA, and it fits in with the general jurisprudence and thinking about bail, which constrains the right to liberty, unless you have good cause, and I'm paraphrasing. What a JIPA says is bail is not something that can be kicked down the road. Now, there have been instances where legislation has been passed to permit that. That's to say the 180-day provision, which says that in certain circumstances you can't make a bail application within 180 days. There have been other exceptions where constraints have been put on how you may apply for bail. The thing is, I'm not seeing anything in this legislation which legitimately places responsibility or should legitimately place responsibility on an accused person for what his proposed surety is producing to the court. Because you are charged with a criminal offense, and it could be anybody. I'm sure many members of this House, even if they are not lawyers, may have accompanied relatives and friends to the police station on occasion to answer questions of the police and perhaps to see your relative or friend being charged. I don't think that that is something unknown to us. We don't sit here in a vacuum outside and apart from the rest of the world. So what we are saying by this legislation is this. We are saying this person is taken into custody after being charged. Somehow, he is responsible, or his bail adjudication must be delayed or denied because a third party over whom he may have absolutely no control whatsoever has produced a dubious certified check or a dubious certified copy of a deed. Now, to me, that makes absolutely no sense, because you are punishing the accused person, not for the offense for which he may be entitled in the long term to be punished for, but you are punishing him for someone else's misdeeds. Now, I don't think you have to be a criminal lawyer or lawyer at all to say that that does not make sense. It doesn't sound fair. It doesn't sound proportional. It doesn't sound right. Let's put it as basic as that. So you are saying that a third party may have produced a document which needed further investigation and so on, but it must follow that this person will be remanded in custody until that is resolved. Makes no sense to me whatsoever. Now, the other thing which I need to go to is this. When we talk about this whole shall or may and whatnot decision to have this sort of investigation, what we are talking about essentially is some sort of inquisitorial process. But we are not saying to the judicial officer what the judicial officer should use or take into account when determining if to have this kind of process. So how are we going to have that controlled? Is it going to be left up to the individual judicial officer to say, well, I read Charles May, but let me see how I should exercise my discretion in this particular case? We don't know. The accused person doesn't know. Should there not be some criteria for the judicial officer to take into account before that judicial officer determines to exercise the discretion, if in fact it is a discretion? Or if it is the prosecutor, should the prosecutor not produce some sort of material to the court about which the accused should know to say, listen, this is why we don't think that this particular surety should be accepted. Let us not conflate accused with surety. The surety is somebody else completely. The accused is the man or woman charged. So why don't we have these criteria set out so we can have a system that everybody can understand, follow, that they find reasonable? It also means that it allows an accused person, or indeed the person affected whose property is rejected at the end of the day, from possibly challenging that decision by the master not to use the property as a surety. But I totally get Senator Roberts-Radgman's very practical point. And it is this: if you have a third party that you suspect might be trying to launder money very bold-facedly through the judicial system of all places, why does the accused person have to be remanded in custody while that third party is investigated? That makes no sense to me. And we have experienced this kind of thing in the bail system, where we have persons who brought deeds. Most common example is people come and they pledge their property, and they say, look, certified copy of our deed, we paid off the mortgage. They don't know, for example, that they have to have, what's the name of the deed of release. They don't know that they have to have a deed of release to show that title was transferred back to them. Very often when that is discovered, what does the court do? The court contacts the accused person. On the next date of hearing, the court says, hang on, you need to find a fresh bailer or a fresh surety. And the accused person then goes and finds somebody who is appropriate and whose documents are in order and acceptable to the court. So the fact that you have problems within the bail system with the use of documents which probably should not have been accepted for bail in the first place is nothing new. This system has worked out a practical way of resolving it. That is to say, if we have a problem with the surety you have produced, then go find another. That way, the person's liberty is not unnecessarily and oppressively denied. Now, let's go to, where did I put my, yes, bail source hearing, clause 6. So I've more or less dealt with 6B1. 6B2, during a bail source hearing, the burden of establishing that the source of the cash or real property used to post or secure bail was derived from legitimate means shall rest upon the person proffering the cash or real property. Well, other senators have addressed certain issues with respect to this subsection. I don't intend to repeat that. But what concerned me was this. The Honorable Minister, in introducing this bill to this House, basically did not tell us, and there is nothing in the legislation which tells us, what happens at a bail source hearing. Is the accused person expected to be present at this bail source hearing? Because after all, his liberty is denied, or he's being deprived of his liberty during this particular hearing. Why is there going to be no evidence? How is the information going to be evaluated? I would imagine all of these things should be set out. I think it would be absolutely crazy for this hearing not to accommodate some testing of evidential material. And this brings me to a point which I have raised in this Honorable House before. When you don't have rules and regulations, all that happens, the spin-off from that, is cases before the courts. Look at what happened to the Proceeds of Crime Act, enacted in 2001, 20-something years later, we have no rules to that act. What do you have? Constant challenges in the courts to how magistrates deal with such applications, what reasons they give or don't give for their reasons. And the court now has to allocate a considerable portion of its time to deal with legislation which could have been amended for the purposes of clarity. And I have to say, this draft here is even worse than poker, because at least with poker over time, we have the Court of Appeal coming out and saying, I can't recall the name of the case, but essentially the Court of Appeal came out and said, look, you must have due process. And due process entitles the person to have some sort of fair hearing of the matters being litigated. And I would imagine that we would see something like that in this particular clause. But regrettably, it is not there. So what we are legislating here is something which is arbitrary, something which will be used in individual courts in individual ways. There will be no protection, equal protection of the law for persons equally circumstanced. There's nothing here which talks about right of appeal. I don't see how due process finds its place in this clause at all. And I'm just summarizing because it's too much to say. If I had to say everything that I was required to say about this proposed legislation, I would not be able to finish in time, and I certainly would like to be able to do so. But due process involves just that an allegation is made, the person is given the opportunity to answer, the person is entitled to challenge the person making the allegations, the court makes a ruling, the court gives reasons for a ruling, and then it doesn't stop there. There should be a right of appeal. None of that do we see here. We don't even see what the court will be taking into account in coming to its determination. So to me, this is just gray. It's obscure, it's unclear, it is everything that legislation should not be. So for these reasons, I respectfully say that I don't see how this bail source hearing thing can work effectively, but more importantly, I don't see, if it is that you want to catch the people, as I say, who are brave enough to bring your criminal proceeds into the judicial system, if you're brave enough to do that, I don't see why that should affect the person whose liberty is being impacted on. Why should that person be kept in custody because of the wrongdoing of a third party? That makes no sense to me, and I emphasize it because I don't know what is the reasoning and thinking behind it. I know the minister said that it's borrowed from Florida and Florida law. So, take me back to 2017. That's when this story starts. This story starts in 2017 when cash bail was introduced as an option to deeds. And the reason for that was because poor people couldn't access deeds. And also because poor people were paying professional bailers to produce deeds so that bail could be taken, and that was illegal and fraudulent, and the Honorable House at that time wanted to ensure that they put a stop to that. So cash bail was introduced as an option. Now, how does that fit into what we are trying to accomplish here? I'm not entirely sure that I can follow through with that. Because if Florida has that law, what problem was Florida trying to solve? And I became more confused when I heard former Attorney General Senator Al-Rawi talk about it and spoke about his input into it. Because it seems to me as though there was some sort of very complicated reason having little to do with our fact situation and our local circumstances behind the thinking which went into this draft legislation in the first place. So I have to say, unfortunately, that the whole situation is unclear. It makes no sense. It doesn't fit into how our practice operates in Trinidad and Tobago. It doesn't fit into how the judiciary deals with bail in Trinidad and Tobago. It doesn't solve the money laundering problem because you can have FIU come in and search these people up and this kind of thing without having the person kept in custody without good reason. So I have tried to look at this from every possible angle. Because obviously, if there is a money laundering issue, we want to be able to deal with it. Of course, if there is an issue with crime, we want to be able to deal with it. But I am saying that the reasons advanced for this legislation and the wording of the legislation is entirely below par. It doesn't achieve what I think or I glean that it hopes to achieve. Instead, what it does is that it conflates bail, which really amounts to a court saying, I am letting you have your liberty on condition that you attend for your case. That is what bail is about. So, bail is to ensure that a person who is charged shows up in court for his or her case. It is conflating that with this new inquisition into money laundering, and I cannot see a logical reason for so doing. Now, what is the end of all of this? Because I spoke about how it starts. I've spoken a little bit about the middle, how it operates, and I'm going to talk about how it ends. And I go back to 2017, the 4th of June 2017, Hansard, where what was being debated was bail, the Access to Bail Amendment Bill. And the Honorable Minister, then a senator, had this to say. I have said time and time again that first-time offenders, sorry, I am having some difficulty reading my handwriting here. I have said time and time again that first-time offenders from the remand yard, if you do not protect them from the remand yard, it does not take long for them to be indoctrinated into the violent culture of remand yard. And this senator, now minister, certainly knew what he was talking about as a very experienced practitioner and senator at the time. What the senator spoke about was the prolongation of the remand yard stay, which worked against what the Senate was trying to do. That's to say, fight crime. The honorable senator, I think, was not saying, as well as he put it, he was not saying anything that was new. Because Justice Gobin, in the very decision to which I have referred earlier, at page 10 of her judgment, quoted what another senator had said in this very house. Sorry, what another senator had written about. The late Senator Dana Sitahal had written in the Trinidad Guardian of the 20th of June 2004, under the caption, "Like the Black Hole of Calcutta." She described what she saw on a visit to the Royal Jail. Hundreds of prisoners who have been charged but not convicted are held in remand blocks together with a few prohibited immigrants, with no threat of court action challenging these conditions as cruel and unusual punishment. The authorities have done nothing to ameliorate remand conditions as they did in respect of condemned inmates. Late Senator Sitahal said this in 2004. Justice Gobin is reminding us of this in 2023. Former Senator Sturge, now minister, had told us this in this very Senate in 2017, as Senator Roberts tends to say during his presentations. Is it that stick break in our ears? Is it that we are not hearing the words, the erudite words of those who spoke before us and who certainly knew as much perhaps as we do, or even more, about these matters? Is this what we are doing? What is the good reason for accepting such a low standard of legislation which will lead to such oppressive circumstances for no good reason? I am not going to go into the constitutional issues because they have been adequately addressed by other senators. But I have to say, as a matter of conscience, when we legislate, we don't only have to think of why are we doing it, how are we doing it, but we are going to have to look at the outcome of what we are doing. And this is an outcome for all our citizens. You know, sometimes when we come here and we say, well, we're thinking about the poor and so on, I see some smirks on the faces of my fellow senators. You know, bleeding heart senator going at it again. But this is not a boot on your corn. This legislation is a boot on the neck of all citizens. And it is quite true that I perhaps forgot to make some of the points that I intended to make, but I think that I have said enough for this afternoon, and these are my thoughts on the matter. Thank you, Madam Vice President.
Senator Boodhu.
Grateful. Thank you very kindly, Madam Vice President. And Madam Vice President, I'll get as quickly as I can into it.
I want to hear what you're saying. So the speed you're going with, I know we hurry to go home, but let's take it on. I want to understand what you'll be saying, please.
Guided, Madam Vice President. I was merely saying thank you very much for permitting me to join the debate this evening. Thank you very much on the record to the Leader of the Opposition, the Honourable Penelope Beckles-Robinson, for the opportunity for me to join this debate, as well as Senator Dr. Amory Brown. Madam Vice President, a lot has been said about this bill, and I will attempt to the very best of my ability not to be repetitive after hearing significant contributions on this particular bill. But, Madam Vice President, I must, of course, deal with the burning issues, because the consequences of this bill are anything but minor, as we've heard. This bill touches the core of our criminal justice system. It concerns the presumption of innocence. It offends the balance of constitutional rights of citizens and the powers of the state, Madam President. And at the outset, I wish to make my position very clear. Any legislation that interferes with the right to liberty, and more particularly the right to reasonable bail, must be approached with restraint, precision, constitutional fidelity, and we must certainly recognize very clearly what Section 5(2)(f)(3) of the Constitution expressly prevents Parliament from doing without the special requisite majority, which is, Madam Vice President, it prevents depriving a person charged with a criminal offence of the right to reasonable bail without just cause, and not just the right to bail, but the right to reasonable bail, Madam Vice President. That's a fundamental word that is included there. The Constitution permits only one exception to the right to reasonable bail, and that is just cause. It's the just cause exception. And therefore, Madam Vice President, the bill must stand or fall on whether it establishes just cause, and whether it does so in a manner that is proportionate, necessary, and constitutionally sound. So we've heard what Section 4 of the bill does, but I'll just get to it very quickly, which is to clarify a certain position that persons charged with murder or a first schedule offence, where evidence has not been taken within 180 days of the charge, or where evidence has been taken but the trial remains parted within 1 year, that person may apply to the court for bail, but must establish exceptional circumstances exist to justify the granting of the bail. And then the remainder of the bill introduces what is termed in the bill a bail source hearing, but it's also known as a nebia hearing in the U.S. jurisdiction, as we've heard, or it results in a nebia hold after the nebia hearing. This mechanism sees that persons applying for bail in respect of any offence where the proposed surety presents cash of $30,000 or more, or a certified copy of a deed, that's the specific wording, shall be subject to a hearing to determine the legitimacy of the source of those funds, or the source of the funds that has purchased the property, in essence. But before we could assess whether the proposals in the bill are justified, let's understand what the existing legislation is, and I'll take it in the same two parts. So the 2024 amendments to the Bail Act, to my reading, was pretty clear, but I did pay particular attention to Senator de Bastide, Senior Counsel's arguments or submissions on the point. In my very respectful view, exceptional circumstances were required to be shown in applications for bail under Section 5(5), of course. 5(2)(a) having captured the requirements for exceptional circumstances, while 5(5) introduces the specific timeline, the 180 days where no evidence is taken, and 1 year where the trial is part heard. But my view is that Section 5(5) does not dispense with the requirement of exceptional circumstances being established. It merely contextualizes the framework, or it contextualizes exceptional circumstances within the framework of undue delay that exists. And the judicial authority, which was cited by the Honourable Minister of Defence, Terrell Toney, in which he acted as defence counsel, which was delivered, as Senator Al-Rawi said, on the 28th of January 2025 by the Honourable Madam Justice Gail Gonzalez. It considered and rejected submissions to the contrary. At paragraphs 25 and 26 of that judgment, the court confirmed what some practitioners, it is apparent, accepted, which is that exceptional circumstances must be established even where delay is the case or delay is relied upon. So, undue delay was intended, in my opinion, to feature, I should say, right? Undue delay should be taken to be intended to feature as a prominent factor in the court's mind in exercising its discretion. That is not to say that exceptional circumstances went out the door. It is to say that in the circumstances where you have undue delay rather, you are still required to show exceptional circumstances, but the fact of the delay must weigh very heavily on the court's mind, and there's a practical application of that. In practice, there are often the times when courts review bail orders or review conditions that are imposed on bail orders as a result of the delay of the state, of the failure of the prosecution, either to meet their deadlines or their directions. This is a common thing. In fact, there are often times, all of the time, in fact, in the Master's Court in particular, where bail is denied on the first instance, but after repeated non-compliance with the prosecution with the scheduling order, notwithstanding there being specific sanctions that are imposed by a JIPA, the court does review its former ruling of not granting bail, and it comes right around and grants bail, recognizing that undue delay must weigh very heavily on the court's mind when denying somebody their liberty. So that is my position on that. But the second and far more consequential aspect of the bill, Madam Vice President, is the introduction of the bail source hearings, the Nebia hearings. Now, we have heard, and I'm going to attempt not to belabor it, that the court already considers several factors. The prosecution is invited to participate in a bail hearing. They are invited to raise objections. They are invited to produce information. If there is a need for evidence to be put forward, the prosecution is certainly not barred from doing that in respect of any information or evidence they may have that either the accused or the proposed surety proposes to secure the bail bond by use of some ill-begotten or unlawfully obtained means. That already exists. And you see this practically and often in cases where there are drug trafficking offenses, cache of firearms, and generally matters that involve high-value items or large sums of cash. And the court, as a matter almost of rule, considers bank statements, job letters, a statutory declaration of the proposed surety, and any other supporting documents, of course, including any deeds, certificates of title, or any other title documents that evidence ownership of the asset that's being used or proposed for use to secure the bail bond. So there's nothing novel about judicial scrutiny of bail sufficiency and of the legitimacy of the source of funds to a reasonable and necessary proportionate degree. But Clause 6 of this bill goes much further than all of that. It mandates that the court shall conduct a bail source hearing in relation to all offenses where the applicant or surety proposes to secure bail by cash of $30,000 or more, or by real property evidenced by specifically a certified copy of a deed, which I would pause to suggest is rather short-sighted in its breadth by defining very specifically only the certified copy of a deed. But overarchingly, this clause, Madam Vice President, is not discretionary. It is mandatory in its phrasing. The Honourable Minister attempted to suggest that shall is not mandatory and went on to describe a deed of 30 years being sufficient. We didn't say that in the legislation. That's not there in the bill, number one. Number two, it begs the question, well, what about a deed of 20 years, of 10 years, of 5 years? Why 30, I'm not sure. But all of that points to the obvious, that there is a significant deficiency in the drafting of the bill, Madam Vice President. What about a deed of gift? Is it only a deed of conveyance on sale? What about a deed of assent? If one were to inherit property and has a deed of assent, which is prima facie evidence of title, how then is the court going to be satisfied that the person who's gifted who's gifted that inheritance, how is the court able to examine whether the property was initially bought with any unlawfully obtained money, Madam Vice President? So, it leaves far more questions than answers in the mind of the person reading this bill. So, overall, the imposition of this compulsory bail source hearing adds a new and very onerous, yet arbitrary layer to the bail process. And certainly it shifts the burden squarely onto the applicant or the surety. And Senator Chote, Senior Counsel, went through the process of that shifting of the burden, specifically as it relates to the third party, the surety, the proposed surety. But in another place, the Honorable Minister of Defense had raised the idea that you could be granted your own bail. And so it is, in fact, the accused being examined as to the source of funds for his own surety. But even in that case, you're talking now about an accused who now has, all of a sudden, a burden of proof. How is that consistent with the presumption of innocence? And the bill is silent, notably silent, on how that legitimacy is to be proven. There are no statutory parameters, no criteria, no guidance to the judicial officer, and no guidance, more concerningly, to the citizen. The bill does not say a deed of 30 years is not to be sufficient, or it is to be sufficient. It says all deeds are to be proven to be sufficient. But we don't know by what means. And this level of ambiguity, I would submit respectfully, is dangerous when it comes particularly to criminal proceedings. Madam Vice President, we haven't had this mechanism operating in our law. It's acknowledged in this Honorable Senate today that notwithstanding the practices that have developed in respect of the legitimacy of assets being used to secure against bail bonds, notwithstanding that, it's not led. Yes, please.
And by then you'll be able to slow down, so I'll be able to understand all that you're saying. Leader of Government Business.
I didn't.
Okay. Madam Vice President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until completion of the business at hand.
Honorable Senators, the question is that the Senate continue to sit until the completion of the business at hand, inclusive of the matter, the matters at hand. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Senator Boodhu.
Grateful, Madam Vice President. Madam Vice President, I was making the point that the level of ambiguity that we see in this bill is dangerous in criminal proceedings. And we have not had this mechanism in our law before, so there is not any jurisprudence that we can look to for any guidance within our jurisdiction. And so such breadth invites inconsistency, arbitrariness, and unequal treatment before the law, contrary to constitutional guarantees. And my suggestion would be, Madam Vice President, that if the Parliament intends to impose new burdens, the Parliament must clearly define those new burdens. As it relates to cash bail, the current practice already requires, as I said, several documents: bank statement, job letters, utility bills, national identification, statutory declaration. But if this bill intends to add to this list, intends to require more, then the bill certainly has to say so. Citizens should not have to guess what is sufficient to satisfy the court, nor should the individual court have to apply a subjective approach, which obviously and necessarily will result in uneven and unequal thresholds being established from court to court by various courts. In fact, that is clearly, evidently the case when you look at the two judgments that are being compared today. The judgment of the learned Madam Justice Melanie Singh as compared to the later judgment of Madam Justice Gail Gonzalez. They're on the same point. So with respect to real property, Madam Vice President, the uncertainty here is even greater. A certified copy of a deed is prima facie evidence of lawful ownership. It's not necessarily good and marketable title. It's not necessarily evidence of that, but that's not what the bill requires. It is prima facie evidence of lawful ownership or a legal interest. To obtain a deed, stamp duty had to assess the deed, stamp duty had to be paid their money, the document had to be submitted to the Registrar General, the Registrar General had to approve it for registration. The Registrar General has the opportunity to query the deeds, including for any suspicion of fraud or any irregularity prior to registration. And moreover, under the digitization initiatives introduced by the former administration, certified copies of deeds are accompanied by QR codes, which allow instant verification through the Property and Business Registration System, or PBRS, as it relates to the authenticity of the document. Any person with any smartphone can simply scan a QR code on a deed, and it will take you straight to the PBRS system. Now, additionally, attorneys, lending institutions, real estate agents, as we've heard, are all required to comply with FIU obligations insofar as they interact with certain transactions as it relates to attorneys and accountants. And this includes source of funds checks. Now, given the existing framework, Madam Vice President, what more exactly is required of an applicant in the case of a deed? What standard has to be met? The bill is simply silent on these things. And it brings me to what troubles me the most about this bill, which is the shift in the burden of proof. So in our system of criminal justice, Madam Vice President, the burden of proof rests squarely on the shoulders of the prosecution. An accused person is presumed innocent until proven guilty beyond a reasonable doubt. Bail is a constitutional support for and a practical and foundational application of that presumption. This bill, however, requires an accused person, in the case of not to be repetitive about or in relation to Senior Counsel Chote's submission. So I'm speaking now an accused person who wishes to secure his own bail bond. I was proposing himself or proposing his own property. It requires that accused person not only to establish exceptional circumstances, which we've dealt with, current position, but also either himself or in the case of his proposed surety to prove that the funds or property offered as security against his bail bond are not illegitimately obtained. So the prosecution in this case is relieved of the burden altogether of proving illegitimacy, and the citizen is required to prove legitimacy squarely. The bill does not even require the prosecution to put forward a suspicion, to put forward any evidence whatsoever that causes the court to form a suspicion or form the conclusion there is a question to be answered. It is exactly that the accused person who is applying to get bail has to prove that he has not committed a crime for which he has not been accused. That is what the bill reads as. And this shift is concerning, especially when viewed against the broader context, the broader policy context of the government. The government has dismantled the Trinidad and Tobago Revenue Authority Act, which was designed for an institution to partially aid in the detection and prosecution of financial crimes, money laundering, and illicit financing. And the philosophy in that regard was quite simple and sound: follow the money. Crime is a business, Madam Vice President. It's motivated by financial gain. The most effective way to combat it is to disrupt that gain. Instead, but we are here tonight debating a bill that burdens accused persons across social strata at the bail stage, while the government has weakened the state's capacity to investigate and prosecute financial crimes, where white-collar criminals reside. This disproportionately affects persons of lesser means. Madam Vice President, bail hearings are not meant to be mini-trials, as the learned Minister of Defense has said. They are often conducted on the very first day an accused appears in court, and usually what is before the court on that day is a complaint on oath, a summary of evidence, and sometimes a criminal record. And it's noteworthy to point out on the record that a summary of evidence is not in fact any evidence in law. It is not a document under oath or sworn on oath. It's a written summary of the facts upon which the prosecution intends to rely, certain facts they intend to prove. and it's usually produced by the complainant police officer. So it is hardly ever tendered into evidence at trial. In fact, if it arises at trial, it might mostly be because the defense introduces it for a previous inconsistent statement or to challenge a witness, a prosecution witness on an inconsistency or impeachment. So all of that means that at the first hearing, when the court considers a bail application, there's often no evidence at all before the court that can possibly enable the court to consider the strengths and weaknesses of the prosecution's case. And therefore, the court cannot consider the prospects of a conviction at that stage. In fact, the law is not designed to operate that way, and it brings us right back to the fundamental a presumption of innocence. And so the court has already very little to rely on in terms of any preliminary supposition of guilt. And such the presumption of innocence is wholly intact at that stage. The bail source hearing practically now jettisons all of that presumption of innocence and right to silence, and transforms the bail hearing into a practical determination on liberty, putting the surety under examination, including the possibility of cross-examination, contrary respectfully to what the Honourable Minister has said, because the silence of the bill in respect of leading, taking evidence and allowing cross-examination does not prohibit any court from taking evidence at any stage to determine a fact. And Honourable Senator Chote raised that question as to, well, the bill does not introduce a requirement of evidence, yet it's being asked to determine a fact that is so serious in nature that it directly causes somebody either to be denied their liberty or to be released pending conviction. So it's again a burden to prove a crime, to prove that they have not committed a crime, notwithstanding not having been accused of the crime. It is a risk, introducing a risk of remanding the accused into custody as becoming the norm rather than the exception, especially when taken with the already established requirement of showing exceptional circumstances. This, Madam Vice President, altogether is directly contraventional to the Constitution and significantly limits the rights to access reasonable bail. And so let us go through a practical example here. You have an accused who is charged with larceny by trick, which is a non-violent offense, and the sum involved is $350,000. He has no criminal record. The court sets bail at $350,000 with a cash alternative of $35,000, which is 10%, and that's the normal calculation, notwithstanding there being no legislative requirement or guidance to come up with that formulation. That's just generally how it is. Under this bill, a bail source in this case is mandatory. This accused must now prove that whatever sum of money he has in savings, $50,000, whatever he has in his bank account at the time, was lawfully obtained. But taking it a little bit further, this accused, in this example, he is unemployed, he survives on informal cash work, he has no documentary trail beyond his bank deposits, as sporadic as they may be. For example, he is a former CPEP worker, he lost his job since June 2025, and between then and now, he survives on cutting grass in the community. So the only thing he could tell the court is those facts. I've cut grass for a living since June 2025, and whenever I cut grass, somebody pays me cash. Whenever I have an accumulation of cash, I put it in my bank account, and that's where my savings come from. That's all he could say. So, having regard to the fact that he cannot say anything further than that, are those facts sufficient to establish legitimacy of source of funds? How is the court expected to determine, as a matter of fact and on a balance of probabilities, that those submissions are sufficient? The court will have to rely in that case on the fact, if it is a fact, that nothing is forthcoming from the prosecution, and therefore, in the absence of contrary evidence, they may find it sufficient. What I mean by that is, if in those circumstances the prosecution has nothing to offer the court to show that there is a risk that this man is committing an offense and therefore the sum of money that he has in his bank account and has offered as security is ill-gotten, only if the prosecution is silent may the court find it sufficient on exercising an examination of those factors. And all of these interpretive issues will necessarily arise in the mind of the court. So this is uncertainty by definition, and uncertainty often results in injustice. Now, you also have a chilling effect on the sureties, but Senator Chote dealt with that quite adequately. I'm not going to belabor that point. But all in all, the bill adds a potentially punitive layer to bail process. It interferes with constitutional rights. It requires a 3/5 special majority. To proceed otherwise is to invite constitutional challenge. And this Senate, I've said before, must ensure that it plays its constitutional role in ensuring equity, proportionality, necessity, just purpose, and access to justice for all, not only for those who could afford it. And in so doing, this Senate must warn against bills that contradict the Constitution. We must be able to foresee as a Senate that to pass this bill with a simple majority is unsafe and will almost certainly result in constitutional challenges being brought against the state. One has to ask the question of why the constitutional majority clause was removed. If it was contemplated in the initial draft of the bill, why is it removed? And today in this House, the Honorable Minister of Defense admitted that it is inconsistent, but he used the words that it's not a serious inconsistency, not a serious infringement. Those are the words he used. The government cannot be afraid of discourse on issues of constitutionality and where support from either the opposition or the independent bench is required. In weighing the options available to it, the government must err on the side of providing comfort to the citizens that bills are passed with the majority necessary, even where that necessity might be disputed, as it is now. Confidence in the Senate and in the Parliament is essential to the proper functioning of democracy. The Senate has already suffered discrediting allegations, but it is for us to legislate and behave in such a way that the people will have trust and confidence in our decisions, especially where we are producing legislation that affects them, affects their lives, affects their rights, and affects their liberty. And certainly, the Honorable Minister of Defense, having been admitted to practice on the 23rd of October 1998, would appreciate this. He was loath to inform us that he was the most qualified, which I am not disputing at all, but certainly he has to appreciate these things. Crime cannot be fought by suppressing fundamental rights. What we need is better detection, better evidence gathering, better prosecutions. We do not need legislation that entrenches fear, mistrust, and pre-conviction judgment. So I would respectfully urge the government to consult meaningfully with the judiciary, with the DPP, and with the criminal bar, notwithstanding pronouncements made earlier, which I wouldn't dignify with a response. Enforce the Bail Act as it exists. Resource the TTPS and the DPP. Reintroduce robust financial crime detection mechanisms like the TTRA. Stop importing foreign models without importing the institutional safeguards that make them work. And in that regard, I want to point out that NEBIA hearings conducted in the US is conducted against a backdrop of a robust and effective legal framework relating to the proceeds of crime and tax. That is the background. It wasn't a piecemeal introduction or insertion into the bail process. It became part of a larger, when it was introduced, became part of a larger operational legislative package that was already in existence and continues to be revised and amended as necessary. And in that regard, it was said in the case of Cassiano and the State 241 SO, 3rd Division 219, the court noted the increasing frequency of placing so-called NEBIA holds after setting bond at first appearance hearings. The case acknowledges that under Article 1, Section 14 of the Florida Constitution, the court lacks the authority to detain a person accused of a crime for the purpose of inquiring into the source of funds used to post bail unless the state files a motion for pre-trial detention. The court also held that such an inquiry, quote, is for the purpose of ascertaining whether the bail set is sufficient to secure the defendant's appearance, not to deny him pre-trial release. That tells us that this bill as drafted has a fundamental omission.
If you're comparing, you have to compare fully. The US has placed a requirement on the prosecution to file a motion for pre-trial detention for the Nebia hold or for the bail source hearing. And a motion is to be supported by fact, by evidence, and by submissions. And in this bill, the prosecution has only to raise a question or to ask for the hearing in the less serious matters where you don't reach the threshold of 30,000 or no deed is offered, or the court in those two cases is obligated to conduct it for the over 30,000 of the deed. So it's fundamentally different from even the jurisdiction from which they have uprooted part of it and brought it over here. So, Madam Vice President, I would respectfully suggest that this amendment, specifically the bail source hearing part of it, is another attempt to suppress access to liberties, and it is directly related to our policy of instilling fear in law-abiding citizens. And I want to make the point to say law-abiding citizens, because you cannot be on a pending charge or have a conviction and be a surety. So that this affects law-abiding citizens practically. And when law-abiding citizens fear the state, democracy is compromised. It is criminals that must fear lawful consequences of conviction. Uncertainty of pre-trial detention does not and will never achieve that. So, Madam Vice President, with those very few words, I thank you very much.
Attorney General.
Madam Vice President, I begin with an apology. I have spent the better part of the day in the House of Representatives attending there to government business, but I knew that this matter, the bail amendment, was in the safe hands of the Minister of Defense, who has practiced for his entire career in the criminal sphere. I have not. I make no pretense otherwise. Senator Al-Rawi has not. I'm sure that he will make no pretense otherwise. He's an amateur. His amateur work is, and I sat here in the few hours that, the hour or so that I was here, and I said, John, take some deep breaths. But Senator Al-Rawi's work is what we are here to fix this off. This. Senator de la Bastide is, and he made no bones about it, he said that he was not a criminal law practitioner. And I mean, there's nothing wrong with that. We are lawyers, we have different skills, we do different things when, in every day. But I think that we should know what our limitations are. Now, if I could just begin by clarifying one point that my colleague, Senator Chote, who is a criminal practitioner, made. And that related to my signature on the NAMLAC document. I asked specifically when was it dated. I see Senator Al-Rawi looking at me because he knows what is coming. It is dated December 2025. Now, we are all sentient and intelligent beings. We would have read what took place just a little over that signature. You see, Mr. President, Trinidad and Tobago is being monitored by the Caribbean Financial Action Task Force and the Financial Task Force behind it. I'm not saying whose fault any of that is or was, but the Attorney General has to make statements in respect of something that is described as the National Risk Assessment. You know that. Mr. President, the National Risk Assessment for the period December 21 to, is it? I'll tell you in a second. January 21 to December of 2024 is what I signed, I was required to sign in December of 2025. So that to speak of anything inside there as my work is a fallacy. I was doing his work. I was doing his work. It was necessary for me to do his work, because if I did not do his work, the country would suffer. So when I said, as I did, in December of 2025 to the CFATIF, that certain things were well in terms of our strategy. That's him speaking, not me. Now, I just wanted to clear that up before, because I take great umbrage at my signature being in any form or fashion associated with anything that I have not done. That's his work. Now, onto the constitutional points, and that is considerably more important for us this evening. Now, I know that we are grappling with a difficult piece of legislation, but it is not enough for us to say that it's difficult, let's go home, or it's difficult and therefore it's constitutional. You know why? Because the Privy Council has given us permission, if that is what we needed. If we needed permission from the Privy Council, they've said, you make your law for yourself. Don't, I'm paraphrasing here, but beginning with Suraj and Surat, and perhaps Achille Charles itself, which is the case that we are dealing with today on bail, the Privy Council have said to us, listen, when you trench on the fundamental rights, it is no longer necessary. In every case, it is no longer necessary for you to have a 3/5 majority. All that is required is that you need to establish certain criteria. And that formula, that test, is what is known now as the proportionality test, because they recognize that inherent in our constitutional rights, no right is absolute, and inherent in our constitutional rights is a margin of appreciation that is given to the state to pass law which might just trench on those rights without the need for a special majority. He knows it, he cites it all of the time, except when he does not want legislation to pass. And that is what is going on here this afternoon. Now, I'm not talking about anyone on the independent benches. I'm talking about my friend in front of me, because he is my friend. I have a fond spot for him. He doesn't have a fun spot for me. But I have a fun spot for him. I like him. He was my student. I like him. Okay? Now I say all of that. And I have evidence. I come with evidence. I don't just come and say things just like that. So I want to go to the Hansard, because we have something inside here called a Hansard. And the purpose of the Hansard is to record for all times, 100 years down the road, what every single one of us would have said in this place. So when Achilles Charles was decided in 2022, my friends opposite, trying to do, inefficiently I think, but trying to do the responsible thing, came to the parliament to say, okay, Achilles Charles says you're entitled to bail in respect of homicide. They know that a great proportion of the serious crime in this country is committed by repeat offenders. Recidivism is a thing. They know that. You know why I know they know that? Because I sat on that side once. I passed a piece of law when persons were being kidnapped every Monday morning. You know what we did? We, the PNM, what we did, we slipped in kidnapping into the schedule in the Bail Act. And by doing that, we said that there was to be no bail for kidnapping offenses. Now, yes, I want to speak about bleeding hearts, Mr. Boodhu or whoever else. But you know what? We got kidnapping for ransom under control in this country. And we did it by taking a very firm, muscular approach to kidnapping for ransom. And that approach included the denial of bail for persons who were accused in respect of kidnapping for ransom. Now, we did that. You know what? Of course, fast forward to 2024, after Achilles Charles says no bail for, bail for even murder. They come to the House with a bail amendment. And this is some of what was said. It's on the Hansard. The then Attorney General, Reginald Amo, Senior Counsel, described the bill as proportionate. Now, why does he do that? Because he's looking at the threat of a constitutional challenge. He says the bill is proportionate. Then the one whose name shall not be named, the person with no hair on his head, Dr. Keith Rowley. This is what he says. He contends that the bill is necessary to protect the public from a small group of what? Repeat violent offenders, and has been brought in direct response to whose concerns? The concerns of law enforcement. Those are the very concerns that bring us here today. It is the intelligence arm of the police service who have identified the main players behind the gangs, just as they did with respect to kidnapping. It is they who tell us that this measure is necessary. And he whose name shall not be named goes on to say, he stresses that the police themselves requested these bail restrictions to curb, nice word, predatory criminals. Well, we know what a predator is, someone who stalks all of us. We feel as a society that we are being hunted. Right. And we are being hunted. He knows it. He whose name shall not be named. He knows it, and my friend opposite knows it, because he reads the intelligence reports that I read, and he knows the names of these people, okay? Or he read the intelligence reports. Now, there are a number of things that said from the independent bench which mirrored the concerns that were leveled at the legislation today. But Mr. Amo said, we believe as a responsible government that the proposed measures are crucial to reducing the likelihood of repeat offenders, particularly seasoned criminals, from obtaining bail. Now, they aren't hiding. They say that the 2024 measure was designed to prevent seasoned criminals from obtaining bail. Yet they come here this evening to say to us, hypocritically, that they are so concerned about the fundamental rights of certain persons and so on. And they set up all sorts of institutional straw men. That's what they are, institutional straw men. Well, you have to do something about looking at how we check out sureties, cash bail. If I go to the bank with $30,000, I get in serious trouble. But they want a criminal. This is the absurdity of it. They want a criminal, someone who, sorry, not a criminal, someone who has been charged with an offense, to be able to post $30,000 bail because he's working, he has some tomatoes and so on and so forth, and his $30,000 is okay, right? Not my $30,000, which I earn by the sweat of my brow. Now, Senator Amo goes on to say, and I'll look at the case in a while. He says, the Privy Council has told us that the denial of bail, the blanket approach, is unlawful. Yes, they did. They said the blanket approach is unlawful. Now, what my friend did not see is that they said it was perfectly okay to regulate the conditions under which you can get bail. Law is a strange thing. It's full of subtlety. The blanket approach, saying to someone, listen, no bail for persons who are charged with murder, that's unlawful. But you know what? They said that it's okay to have conditions. And this is the same Achille Charles case. Now, that's not me talking there, you know, I mean, maybe it is, but I'm repeating what the gentleman who followed him said. And he knew it. Okay? So if you look at paragraph 74 if you look at paragraph 74 of the Achille Charles case, what you see is that exactly what Mr. Amo is saying, that there are, now, Achilles Charles is a case in which it's a tough case because someone was in prison for 8 years and then freed without more. But that is not, that is the exception, not the rule. They recognize that there are a variety of circumstances in which a murder charge can arise. And then they say that that means that there will be cases where none of the objectives of a prohibition of bail will be served. There's no risk of absconding. So these are all the factors. Is there a risk of absconding? There's no risk of further offending. There's no risk of interfering with witnesses, obstructing the course of justice. In such cases, there's likely to be a very compelling case for bail. But the blanket prohibition means that bail will not be possible. There are exceptions. All that we seek to do properly this time by this amendment is to ensure that with a proportionate piece of legislation, we set out carefully what are the conditions, sensible conditions, which one can attach to avoid that blanket prohibition in respect of bail. That's it. And we've spent hours, not we, you all have spent hours listening to my friends hypocritically pretend that they care about something that the record, the Hansard says, they came to this parliament to treat with before. Now, colleagues, I want to deal with one more point which Senator Boodhu, you see, when you teach for as long as I did and as long as my friend Professor Prasad did, you've taught a number of persons. So Senator Boodhu, some of them you don't remember. Of course,
Unremarkable.
Well, I don't want to say that, but I remember Senator Al-Rawi because I liked him. I liked him. I just don't remember you. I'm agnostic about it, you know. I'm agnostic about it. I don't know whether, I never dislike students. Senator Arts is a university lecturer, a formidable university lecturer. We have a group of us inside here. She's a formidable university lecturer. I'm sure she does remember all of her students. So I apologize if I don't remember you, but you must have been unremarkable. So, there's just one more point, one more constitutional point that I wish to make, and that deals with the reversal. It deals with the reversal of the burden of proof. Now, every first-year law student, as Senator Boodhu once was, would be able to point to this. It's the Constitution of the Republic. It's like a Bible for lawyers. Now, Section 5 of the Constitution, it's early on, so in case you get tired, you know, at least you read 1, 2, 3, 4, 5, maybe you get tired by 6 or 7. But Section 5 of the Constitution is the one which deals with protection of rights and freedoms. Now, I'm on the point that he belabored about the reversal of the burden of proof and how unconstitutional that was and all these other things. Now, we do have a constitution. So this is what Section 5 says. And I'll just run quickly to 5.1d, which is what I think he was referring to. 5.1 says, except as is otherwise provided in this chapter, no law may abrogate, abridge, infringe, authorize the abrogation, abridgment, or infringement of any of the rights and freedoms herein before recognized and declared. Now, if you go down to F, and this is where we are this evening, it says, deprive a person charged with a criminal offense, that's what we're on this evening, I'm sure he knows that. 1, of the right to be presumed innocent until proven guilty according to law. But that's, I tell my students all the time, read on. And this is what it says. It says, but this shall not invalidate a law by reason only that the law imposes on any such person the burden of proving particular facts. Now, that is called a reversal of the burden of proof. It's permissible under the Constitution, and I commend the reading to my friend Senator. I'm sorry, I didn't always succeed. I apologize for that. But so I commend that section to Senator Boodhu.
It was a big class.
Now on the actual mechanics of who produces cash, apart from telling the Senate that if I walk into the bank with, it doesn't have to be $30,000 as the legislation provides. If I walk into the bank with $10,000 in cash, I'm going to be required to fill out a source of funds declaration. I'm going to have to go into a back room and answer a series of questions. And if I just want to know, what happened to the equality of treatment? Why can't someone who is charged with a criminal offense be just asked to do the kind of things that I am asked to do? That's all. Now, on the other questions relating to cash bail and so on, I believe the mover of the bill has a great deal more experience in criminal law and practice, and I will ask him when he winds up now to sort that out. Thank you.
Mr. President, I hope not to detain the members of the Senate too much longer, because it's Friday evening and we are all hearing the merriment on the outside. But I would be abdicating my responsibility if I did not clarify certain matters and if I did not address certain issues raised, which in essence, when I pointed them, we would all see they were non-issues. Now, I saw earlier some amendments being circulated by Senator Al-Rawi, let me dispose of it quickly. Where's it been? Because any criminal practitioner
before this House, and I didn't argue them. We have a committee stage. May I have your ruling on relevance, please, at this point?
Oh, I think the amendments have been circulated to all members, and members can speak on it.
Thank you. And they're in the garbage too.
Thank you for the ruling. Well, the President has ruled.
Do not interrupt. Stand in order.
Under the privileges of the House, Section 55
Stand in
and
order.
46(1). For your guidance, please. It's a very important point, Mr. President.
Please, take a seat. Could you take your seat? That's what I'm saying. Take a seat. Take a seat. I have ruled. Continue.
Now, the Attorney General has made my job very easy by quickly disposing of a point which was not raised, which was not limited to the submissions of inexperienced Senator Boodhu. I heard it elsewhere in the debate. And it's a short point. The fact that a law requires the burden to be shifted and that there's an onus on a citizen to prove certain facts, that by itself, as just read out, does not invalidate that law. So the fact that in bail source hearings, a surety or an accused is required to prove the existence of certain facts, that by itself does not raise a constitutional issue worthy of a special majority under 13(1) or 2. I say no more on that because that is so clear. It is so clear that the very fact of raising it means the fact that you raise it, it ought to be rejected. That should never have formed part of this debate. Now, I want to go to some statistics because Senator Chote, in essence, said that we did not provide statistics. And I have here with me the suspicious transaction reports and suspicious activity reports in Trinidad and Tobago from 2010 to 2024, and it shows a certain pattern. 2010, 111 suspicious transaction reports and suspicious activity reports. That's 2010. 2011, it rose to 303. 2012 to 258. 2013 to 554. 2014 to 617. 2015, 609. 2016, 739. 2017, 877. 2018, 1,110. 2019, 1,019. 2020, 1,831. 2020, 1,831, and that's during COVID. Imagine that. 2021, 1,638. 2022, 958. 2023, 950. But 2024, 1,459. So it paints a picture. Now, we are where we are, and I mean, we are all faced with a choice. We are all responsible. We could vote for the provisions in the bill. We could not vote for it and go back on the blacklist and suffer the consequences. We could abstain. The choice is yours, but we are all here to seek the best interest of all of our citizens. and not the best interests, and there's a trend, a bit of wokeism taking place in this country, where all of a sudden we are seeing persons who ought to know better, all of a sudden seeking to pretend that they are guardians of the rights of those who terrorize the rest of us the most. Defending criminals is for the courts. It's not for here, and I keep hearing almost every week when we come here that this would affect the rights of everybody. This cannot affect the rights of everybody. The only way you are going to be affected is if you are, first thing, charged with a criminal offense. The presumption of innocence is not taken away. So you have to be charged. So how does this, and this is directed to Senator Chote, how does this, with respect to the boot on your neck comment, that this is a boot on the neck of all of us?
I take serious umbrage at that.
Yes, I too. Is it that every one of us are before the courts for repeatedly committing violent offenses? So the first thing is, which makes rubbish of that argument, the first thing is you have to be charged. This, better you say it than me. The second thing is, you are charged with an offense, and having regard to your record, it must be obvious if a judicial officer decides that I have to fix bail at a high amount, it must mean that I have to protect society from you because you are a repeat offender. Or I have to protect society from you having regard to the factual matrix that exists in your case. You are extremely dangerous. So, persons who are charged with obscene language and all of these summary offenses, they are not granted cash bail in the amount of 30,000. Bail of that amount is reserved for the recidivists and for the most dangerous of offenders. It does not target all of those persons who may run afoul of the law because they use obscene language in the presence of the police, they resisted arrest, they were found near to a school smoking a joint, or they took a wine on somebody in stinking dirty without consent. It doesn't apply to anybody like that.
Stinking dirty, stinking dirty.
Or dirty.
Dirty. That one is nothing.
Right, so I, just like the Attorney General, I take umbrage when I hear that it applies, that it is a boot on the neck of all of us. That is the kind of wokeism that should not exist in a parliament that seeks to protect the law-abiding country. And it is racist. I wanted to say that since downstairs because they were seeming to suggest that only one race of people would affect or commit criminal offenses. Yes?
That language is not permissible, not permitted. Please. That you were going good. Continue, but leave all that right now. Okay, thank you.
I wouldn't take chain up. I would proceed without taking chain up. Yes. Now, I heard, I was really looking forward to the contribution of Senator Chote because she practices criminal law. But I was astounded when I heard the contribution. I was astounded. Let me go through, not all of it, very briefly. Here at this point. Why does the accused have to continue to be remanded in custody whilst the surety is checked out? Or to the effect that if the surety fails to check out, he has to remain in custody. Mr. President, if the court, having granted bail, says bail with a surety for 300,000, and you bring your surety, and the surety does not check out, quite apart from this bill, as it stands now, if your surety does not check out, what do you think the judge in chambers would do? Do you think he would say, well, it's not the fault of the accused who just raped somebody. It's not his fault that the surety didn't check out. It's the surety's fault that it didn't check out. It's the clerk of the peace doing her job who didn't approve it. So you know what? I'm going to give you bail. But the reality is, I mean, that is the most stupid argument I've ever heard in a place like this. As it stands, if your surety does not check out, your surety is not approved, you are not on bail. So if you're not on bail, what must the court do? Let you out? That is the kind of wokeism I never thought I would see here, particularly from a senior counsel. And so that this bill is doing the exact same thing, but it is doing it in a particular context. It is doing it in a context where it's not all bails, but it is for cases where the court itself found it necessary to impose bail at a certain amount and upwards. So if you commit an offense and the court says, well, you are a first-time offender, or you're not likely to go to prison for this, I'm going to charge you 5,000 bail, then how is that a boot on your neck in this bill? Exactly. This bill does the exact same thing that exists not only with the clerks of the peace, but the judge in chambers. So right now, and all this seeks to do is to give to the master of the court, who is a creature of statute, and a magistrate who is a creature of statute, all it seeks to do is to give them the power that the clerks of the peace, who are ex officio magistrates of the lowest order, it is seeking to give them that very same power. So what could be wrong with that? Imagine you are a master or a magistrate, and your clerk has more power than you. How does that make sense? How does that even rear its head in a debate like this? If you have an ounce of common sense, you would know that is the law. This bill is simply seeking to empower and give to the magistrate and the master the powers that are currently and have always been exercised by the clerks of the peace. And you know what is the most amazing thing I heard? That for the first time cash bail was ever introduced was 2017. Cash bail existed since the days of Doji. That's the 90s. I've been in practice for 28 years. My very first bail was a cash bail. So I didn't expect to hear a senior counsel say 2017. Anyway, when does it start? Yes. Another point made, that is it fair to conduct a bail source hearing if the accused is not present? Mr. President, for the last 28 years, I have been appearing before the judge in chambers every Friday. Well, I stop now.
Are you, sir?
Yeah, oh yes.
Assistant Registrar.
Assistant Registrar. Every Friday, you come before the judge in chambers. The accuser is never present unless you request him. That's why lawyers have to go to the jail, take instructions, and the lawyers wouldn't have to know what instructions they have to take. The lawyers are the ones who would have to see whether you fit under 6.2 of the Bail Act, whether you qualify, so I know what arguments to make. And if I propose a surety, I have to fill out the form, the declaration to the back of the Act, the second schedule. I would know what is required to be put in it.
and the surety is brought before the judge in chambers, and the judge in chambers would examine the surety and sometimes approve the surety there on the spot or send them downstairs to Mr. Alaha, the registrar, and they would conduct their checks with respect to the second schedule. So I'm trying to understand, if the existing practice is that the accused is not present for a judge in chambers hearing, then what really is wrong with him not being present for a bail source hearing? Nothing wrong with that whatsoever. That is the practice. And the only change here is that we are putting into law, we are making it quite clear that where 30,000 is the bail, that there is a trigger. Before that, as it exists now, if a judge in chambers decides that I'm going to fix bail at a certain amount, you still have to go through the same process, and you go through this process without the accused being present. So how all of a sudden we have a senior practitioner saying, well, why the accused can't be present? There are a variety of reasons why they don't need to be present. They have a lawyer who has taken instructions. When they are present, they add nothing to the proceedings. In fact, when they are refused, they want to cuss and fight, and the police had to restrain them and take them out of the court. So what is the value? Because when people don't get bail, they get angry. They don't get angry with the surety, you know. They get angry with the court. All of a sudden, the court do them something. I go there, I used to go there, and when they are refused, all your wicked woman from Sealands has come out. All you too wicked. The judge wicked. You ain't wicked for raping down the place. That requires bail of 100,000. You ain't wicked because your surety ain't come up to scratch. But because things aren't going in your favor, the judge, everybody else wicked but you. And then you have a set of senators here coming to back you up and tell you the system wicked. Jesus Christ. Oh, you. Is he at home? Next thing. Question was raised. How is this bail source hearing going to operate? I've never seen a statute. There's a 1994 bail statute in existence. And if that bail statute didn't tell you how the processes of the court have to operate, why do we now, amending an existing law, have to come and tell you what the procedure is when it already exists? It already exists. The common law is clear as to how it applies. The judge, another one say, well, how you're adducing evidence. A bail hearing is not a trial. I said that before. In fact, there are cases, I think one by retired Justice Suhan in RoboCup, where mention was made of, I think the case was Remoles, which made it clear. You don't lead evidence in a bail hearing. It's an inquiry, and either you satisfy 6-2 or you don't. So all of a sudden, we are hearing, well, how is this going to work? Well, let me answer you. It's going to work in the same way it has been working for the last 30-something years. Well, more than that. There's nothing new. So I don't understand what that point was about. The Attorney General has dealt with shifting burdens. And just one point on shifting burdens, because I heard it not just from Senator Boodhu, but about how the burden shifts, and the citizen wouldn't know how it works, and citizens shouldn't have to guess. They don't have to guess. The law is clear. The law is amending the existing law. The judge says this is the type of offense that requires $30,000 bail and up, and in those circumstances you have to come and you have to show, you have to satisfy the court that this property is not from illegitimate means. End of story. It doesn't require cross-examination and rebuttal evidence. It never does. Because in the present system, which applies to all bail, so that there's no inconsistency as mentioned by Senator Al-Rawi, who never did a case in his life, there's no inconsistency. For all bails, once you have to submit yourself to the surety in the second schedule, whether it's 10,000 or 0,000, the court has to basically satisfy itself of certain things. That's why you sign the declaration at the end. That's why you sign the declaration at the end. There's nothing new here. This is simply to deal with where a certain amount is fixed and there's a trigger. And to answer the question, because it was quoted selectively, two things, Terrell Tony, which I shouldn't even address, that was a non-issue. But Senator Al-Rawi and someone else sought to go into the jurisprudence on the Nebbia hole, and somebody said it was limited to drug cases, and that's why it was proportionate. That is a very myopic view in the context of Trinidad and Tobago. That's like saying it should only be limited to drug cases because gangs in Trinidad only sell drugs, and we are only targeting those who sell drugs. But those who engage in bringing Venezuelan women and pirating them as prostitutes and doing human trafficking, it shouldn't apply to them. It shouldn't apply to rapists. It shouldn't apply to kidnappers. It shouldn't apply to godmothers, just drugs. It shouldn't apply to terrorism. That is so myopic, it doesn't take stock of the reality that our gangs in Trinidad and Tobago are multifaceted. They are multifaceted. And someone else made I think it was Senator Boodhu, said, well, Nebbia in these cases didn't exist in isolation. It existed with other pieces of legislation and so on. This act does not exist in isolation. I think I made mention in the other place, I think I may have made reference here.
Proceeds of Crime.
Proceeds of Crime Act is applicable. The Explain Your Wealth legislation is applicable. The real estates, yeah, all of these are applicable. This doesn't exist in isolation, so I don't know what the point was. That's the point. He had no point. He came here to get a cocoa sweat and hear himself. You didn't really have a point. I think I've already remoles. He says silence of the bill does not mean evidence is not taken. I would just invite him to read remoles and these other cases. Yeah, well, he should start with Section 5 of the Constitution. That's what all law students do. I think reference was made by Senator Al-Rawi about Terrell Tony and saying that I appeared in Terrell Tony. Well, and that I was somehow not giving the full facts. Let me state what the full facts are. Mr. Keith Scotland appeared in Terrell Tony, provided very little assistance to Justice Gonzalez. Bail was refused. When you read the judgment, let me not say anything else because it might invoke an objection under a certain standing order. But the less you read, the better for you. And then he makes reference to Terrell Tony and saying, well, I'm only referring to Jamal Khan Mohammed because I did it. Terrell Tony, when he was refused bail, when he went with Mr. Scotland, had another application which I also appeared in dealing with the same subject. And of course, in that case, the issue was I already refused bail already on this point, on exceptional circumstances. I was there, the judge didn't want to hear nothing else. So that's why you don't waste your time on that judgment. Of course, he made reference and went into some depth in the matter dealt with by first instance Judge Carol Rubin, and merely made mention of another judgment of Justice of Appeal Henderson. What he didn't tell us is that Justice of Appeal Henderson found the exact opposite to what Justice Carol Rubin found. He should have gone into detail to show you that there were conflicting judgments, and when you read it carefully, you can make a determination. Yeah, very selective. But the short point is, that is on appeal, I understand, and look how long it is on appeal. So I'm told. What I can tell you is also on appeal would be cases on the Section 24 amendment relative to subsection 5 of Section 5 of the Bail Act, 2024. That has been on appeal for a year and change with no resolution. So you have one set of judges following the erudite learning of Justice Nalini Singh, and if you read it in detail, you would see why it's erudite. And another set of judges reading the judgment of Terrell Toney, which really is Mr. Scotland, and you'll know why you say it's not erudite. But there's an obvious conflict in the law, so the Court of Appeal has to resolve it. But if a year later it has not been resolved, what do we do as a responsible government? Do we just sit down and say, well, let's wait for the Court of Appeal to get time to hear it? Or do we try to fix it so that there is certainty in the law?
That's correct.
That's all we're doing. We're trying to fix it like Philip. Right, judging chambers, shifting burdens, removes. Mr. President, I don't want to be accused of tedious repetition, so I believe I'll rely on the submissions made by the learned Attorney General in all other respects. And at this point, I beg to move.
Honorable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clerk.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
President, in accordance with Standing Order 66-1, I beg to move that the Bail Amendment Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Bail Amendment Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. No. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Minister of Defense and Attorney General. You are? Okay. All right. We have a bill that contains 8 clauses. We have 3 sets of amendments, and I want to ask colleagues to advise if they are in possession of all 3 sets. We have amendments from Senator Anthony Vieira. Members are aware of those amendments? Are members in possession? Right, thank you. We have amendments also from the Honorable Attorney General. Are members in possession of the amendments? And then the last set of amendments we have is from Senator Faris Al-Rawi. Are members in possession? Okay, thank you. Now, as I said, we have this bill contains 8 clauses, and we'll have to take these clauses. We'll proceed clause by clause. Okay. Have no amendments, so we'll take them collectively, jointly. Proceed.
Clauses 1 and 2.
The question is that clauses 1 and 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Well, we have amendments to clause 3 from Senator Faris Al-Rawi, as well as the Honorable Attorney General. So, Senator Al-Rawi, would you like to go with yours?
Thank you, Mr. Chairman.
Yeah.
Mr. Chairman, you will note that I propose that Clause 3 be deleted and renumbered. Clause 3 treats with introducing a definition for a bail source hearing. Insofar as our position involves codifying bail source hearings merely as an element for consideration within the existing law, thereby solving the legal dilemma that Madam Justice Gobin had in the cases that she delivered and we spoke to, as contradicted in a different way by Mr. Justice Henderson in the case that he did. It's very simple instead to amend the Act by including something which it does not have, and that is that the Rules Committee can make rules to govern bail hearings. So there would be no need to have a definition of a bail hearing. It can actually simply exist in a different clause, and that clause would be in clause 7 later on in the bill when we come to it. So the reason for proposing that a bail hearing be deleted is that there is no need for one. It can form part of the authority which creatures of statute, meaning masters and magistrates, would need if they had to consider it, because that was the problem Madam Justice Gobin had. Mr. Justice Henderson had a different one. But by introducing the power of the Rules Committee under the Supreme Court of Judicature Act, Section 77, you would allow subsidiary legislation, subject to negative resolution by the Rules Committee, to give you all the powers to treat with bail hearings as may be appropriate within our system without the need to have one, but to have it simply as a consideration. It would take away the argument that there's an ultra-vires approach by having an administrative action, which is what the current system involves, not being subject to statute giving that power. So those are the reasons as to why we suggest that there's no need for a bail hearing. The existing law can take care of it, and therefore we propose it be deleted and treated with under Clause 7.
G or Minister of Defense?
We are not minded to consider that amendment.
Your own amendment?
Amendment 3, in essence, it deletes the existing words either on its own motion or at the request of the prosecution.
Any clarification?
And that was suggested, I think, by Senator Vieira. No, the Bastide, sorry. Oh, there's him. Oh, okay.
Clarification? If not, we will go with Senator Al-Rawi's amendments. The question is that Clause 3 be amended as circulated by Senator Faris Al-Rawi. Those in favor say aye. Aye. Those against say no. I think the noes have it. So we will now go to the Attorney General's amendment. The question is that Clause 3 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 3, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3, as amended, now stand part of the bill.
Clause 4.
The question is that Clause 4 stand part of the bill. We have amendments from Senator Vieira, SC. The floor is yours.
Thank you, Chair. Let me say from the outset, all my amendments are crafted to align with the Privy Council proportionality test framework in Achille Charles. My proposed amendment is concerned about preserving the constitutional presumption of reasonable bail. It seeks to make clear that the accused is not required to earn bail. It preserves judicial scrutiny without reversing the constitutional burden. And it aligns Section 5 with Section 5(2)(f)(3) of the Constitution. I believe that without this clarification, the bill risks normalizing the idea that bail is exceptional rather than presumptive, which I think is constitutionally dangerous.
We drafted the bill consistent with what we consider to be the requirements set out by the Privy Council in Achille Charles. We think that as it is, nothing else is required. We do not think that the bill falls outside of the remit given to us by the Privy Council. The Privy Council itself said that bail could be regulated and gave a number of examples which were non-exhaustive. We think we've done that, and we are not minded to accept the recommendations.
Clarification, intervention. Senator Anthony Vieira, would you want me to put the question? No, I'm asking. So, are you prepared to withdraw? Oh.
You can put it to the vote.
You'd like me to put it? Okay. The question is that clause 4 be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. There are amendments, I think. We have from Senator Vieira and Senator Faris Al-Rawi. Senator Faris Al-Rawi, please.
Thank you, Mr. Chairman. Mr. Chairman, the amendment that we propose is a deletion of Clause 5. Clause 5 is where there is an insertion into Section 6.2 of the Parent Act of a consideration for which a court may deny bail. So Section 6.2 of the Parent Law introduces the circumstances where a court may deny bail, and it proposes to add into that where the court, having completed a bail source hearing, is satisfied that the source of cash or real property used by the accused or the surety to post or secure bail was derived from illegitimate means. The problem with that is, firstly, the bail source hearing as it is something which we consider to be entirely out of context from the jurisdiction from which it was imported. It is not on equal terms with the U.S. jurisprudence, which requires a proceeding before the U.S. court to deny bail, to keep one in custody before the Nebia hold can happen. That's the case that says it. Secondly, it uses language which is alien to what the law actually says, and also language which conflicts with the law. In 5C, as is the bill here before us, cash or real property. When you go to Section 12, 4A, Section 12 of the Parent Act says a person granted bail in criminal proceedings shall surrender to custody. And subsection 2, a court may require a person applying for bail to provide as a condition for bail before his release a surety to secure his surrender to custody. Subsection 4A says the security is cash or certified check where the amount of security is $10,000 or less. Certified check where the amount of security is greater than $10,000. A bond issued by a licensed financial institution as defined in the FIA. A charge on immovable property or such other form of security or combination thereof as the court sees fit. It certainly isn't limited to cash or real property alone. It does not take care of what the existing law provides as the forms in which security may be given. That is expressly set out in Section 12, subsection 4A of the Parent Law. So if we were invited to pass this into law, the new subparagraph H would conflict with subsection 12, with Section 12, 4A. It also says No, that would come under a different clause. So our rationale for deleting that is that, one, it is out of context with the US law from which it was imported. Two, it is alien it is limited only to two aspects of which security is given, and it doesn't therefore meet with 12(4)(e) of the Parent Act. Thank you, Mr. Chairman.
Honorable Attorney General, Minister of Defense, you all could respond to the submission.
We do not agree with the proposed amendment.
Okay. Senator Anthony Vieira, SC.
My amendment seeks to require proportionality before denying bail. The problem with Clause 5, which amends Section 6(2), is that it allows the denial of bail solely on illegitimate source findings without weighing severity or necessity. The justification for my proposed amendment is that this would codify the least intrusive means analysis. It would reflect the Achilles-Charles proportionality, and it would encourage conditional bail rather than an outright refusal of bail.
Minister of Defense.
We do not agree simply because, first of all, this clause only comes into effect when bail is set at a certain amount, and then the bail source bail source hearing occurs. So it has nothing to do with the reverse as being suggested. If you are denied bail, then the bail source hearing is not relevant. So it comes into play only after bail is granted at a stipulated amount, and then you tender certain things, and the court would then embark upon a bail source hearing. So we don't agree.
Just to clarify, my proposed amendment says before denying bail, the court shall consider whether the objectives of this act may be achieved.
It goes back to the proportionality point. We think that, and I'm repeating myself, but we think that in Achilles-Charles, the Privy Council said that you may impose conditions, reasonable conditions. We think that this is a reasonable condition, and therefore we are unable to move from it.
Mr. Chairman, may I?
But AG, just to be clear, in that Achilles-Charles, the board emphasized that it was an adaptable test, and that it was sensitive to context, severity, and consequence. So,
yes, but those are all general words, and we think that we've satisfied the test. And it's not that our draftsmen are different from the draftsmen who have always been in the employ of the Law Reform Commission. So this is the law that we propose.
Mr. Chairman, may I ask the Attorney General a question through you on this? Thank you, sir. Attorney General, in keeping with the proportionality answer that you've just offered, would you mind putting on the record why it is the government is limiting the bail source hearings to only cash or real property and not any other type of property in Section 12(4)(e)?
Senator Al-Rawi, I've heard you talk about putting on the record certain things before, and you said it in the context of what happens afterwards. You know very well that the Supreme Court in the United Kingdom says in Pepper and Hart that they're not getting involved in our business unless there's an ambiguity. So we're entitled to have a discussion. I'm not putting anything on the record. I'm just telling you that we can have a discussion on it. So I take umbrage at that too. Maybe it is that it's late, maybe it is that it's a different time of the year or something like that, but this is not a pepper and heart situation where the legislation is imprecise. If you wish me to give a view on the distinction between Section 5 and Section 6 or something like that, that's fine. That's different from putting something on the record.
So thank you, Honorable AG, for explaining the position that you're taking. I certainly meant no offense by my words in terms of record. I would very much appreciate a view on the limitation to cash and real property as opposed to the matters specified in the parent law, which is Section 12(4), capital E.
Okay, you go ahead on cash and real property.
Any other intervention?
There's no need. The court, in using the various aids of interpretation, would obviously not limit itself, but give a purposive effect to, if it's outside of cash, to real property, would give a purposive effect to capture any sort of property being used to advance security.
I'm sorry, is the Honourable Minister saying that real property is something else? A shoes in action, bank security, an item under the Financial Institutions Act, because that would be most incredible in law and in fact. Would you mind clarifying how a purposive construction of real property would yield something else?
Right. What the court looks at is what is advanced as the security. And if in the court's view it has to limit itself to the words used, then so be it. Outside of that, the court can adopt a purposive interpretation, and it is not limited to a deed of conveyance. It can also extend to certificates of title, but because they are dealing in essence with someone using land to secure bail.
Thank you. I'm not interested in real property. I'm asking the question about bonds. I'm asking about charges on immovable property specifically. I'm asking about choses in actions. I'm asking about, for instance, Bitcoin. I'm asking for other forms of security that persons may have. For instance, a car. A car is a valuable asset. When we go to the schedule of the Bail Act, you will see that you can have title to a car used as security.
Right.
That is not real estate.
Right.
But hold on. I'm interested in understanding clearly from you how real estate can become that.
Let me use the example you used, things outside of real estate. There's a reason why the court does not accept a car. Because if you sell the car, then the surety, the value of the surety dissipates. And all of the other things, the Bitcoin and all of these other things, the court does not have the wherewithal to basically police the disposal of these types of property. But the court can, with respect to certified checks deposited or cash held in the account referred to in the other place, or with respect to real property, the court can treat with those. Outside of that, the court obviously always gives some sort of latitude, but if it goes beyond that to things, as you've mentioned, a car and Bitcoin and so on, which the court, in essence, cannot prevent dissipation, then the court would not consider it. So it is limited to what is the actual practice.
Mr. Chairman, if that's the case, why does the second scheduled statutory declaration to be made by surety or sureties specifically say the opposite of what the minister is saying?
It doesn't.
It says here that the immovable property specified under mortgage, hypothecation, etc., in consideration of. It also speaks to description of property, estimated values, bank account number, amount, other movable property. If the minister is to be believed, then the schedule could not have that, because what the minister has just said is the exact opposite of what the law actually says at page 24 of the Bail Act.
Well, not having practiced criminal law, maybe you do not know. That
I
when
can
the court,
read, I don't need to practice criminal law.
Listen, I think I believe, honorable senators, the government has expressed its view. Senator Faris Al-Rawi has expressed his views, I think we have exhausted this matter. I'd like to put the question up. Honorable Senators, the question is that Clause 5 be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 5 as circulated. The question is that Clause 5 be amended as circulated by Senator Faris Al-Rawi, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 5 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
The question is that Clause 6 stand part of the bill. We have amendments from Senator Anthony Vieira, SC, Senator Faris Al-Rawi, SC, and the Attorney General. So, Senator Vieira, the floor is yours.
Thank you. The objective here is to replace the mandatory bail source hearings with a triggered test. The problem with Clause 6, the bill mandates a bail source hearing automatically once a monetary threshold is crossed, regardless of the context, risk, or practicality. My proposed amendment removes automatic suspicion based on wealth alone. It requires objective grounds, not mere monetary thresholds. It prevents bail hearings from becoming default financial inquests. I would like to suggest we should not criminalize possession of cash or property by default. Suspicion should be grounded, not assumed.
I know that you have a series of amendments to Clause 6. Have you exhausted your submission?
No, that was 6B1. I have another amendment.
Yes, we'll deal with all the 6 now, all the amendments.
All relating to 6.
Right.
Thank you, Chair.
Yeah.
The other amendment speaks to the introduction of evidential flexibility for ordinary persons. The problem with Clause 6, which inserts a new section 6B2, is that the bill places a rigid burden of proof on the accused or the surety, with no regard for our informal economies or administrative delay. The other one is, I'm proposing a 6B2A, and the justification for that amendment is it would introduce real-world evidential flexibility. It would prevent incarceration due to missing paperwork. It would keep the inquiry judicial rather than bureaucratic. As I said in my contribution, justice should not depend on access to accountants, banks, or title offices. My third amendment at 6, the problem with Clause 6B, which new section 6B3, is that without timelines, bail source hearings may prolong remand indefinitely. So the justification for this amendment is to prevent prolonged incarceration due to administrative delay, and it seeks to force proportionality in practice, not theory. Pretrial detention should never become punishment by delay. I wouldn't like to see matters languish in procedural purgatory. And the other one with 6, let's see, where is that? again, it's an attempt to guard against socioeconomic discrimination. As I had said in my contribution, uniform standards risk unequal impact. So by inserting this new section 3A, which is an interpretive provision, the idea is to really signal legislative intent, to guide judicial discretion, and to reinforce equality before the law. Ultimately, all my amendments seek to preserve the bill's legitimate objective, financial integrity of bail, but to restore the constitutional balance, to protect the poor, the informal, and the wrongly accused. Also, it will try to reduce litigation risk and to strengthen the rule of law rather than to weaken it. My concerns is that we want to ensure that the law remains a shield, not a weapon.
Lieutenant General, Defense Minister.
Mr. President, we are confident that the bill as drafted protects constitutional rights, existing constitutional rights, and there's no need to, in essence, write into the bill and in essence, shackle ourselves towards where the existing law already says, when you look at all of the amendments, if a burden shifts to the citizen, it is on a balance of probabilities. There's no need to say that in legislation. All that has been said, in essence, can be covered by our own amendment, which we'll get into shortly.
Faris, Al-Rawi, essay.
Thank you, Mr. Chairman. Mr. Chairman, we propose that clause 6 be deleted for the following reasons. In our general proposals, we maintain that a bail source type hearing, meaning an inquiry or a reflection onto the legitimacy of money, should happen. We think that that should happen in clause 7 and in the schedule. But insofar as 6B is presented, there are issues as follows, which in our mind bring us to deleting it. The first issue which arises is the mandatory use of the word shall, which removes the discretion of the court and causes a feeding of the separation of powers issue that we should have regard for. It's true that in law you can read shall as may in certain circumstances, but you need a court to have that determination. In so far as it's related to all offenses, and you're looking at the accused or surety, the first thing that it does is that it says cash in the sum of $30,000 or more. Reading from the judgment of Madam Justice Gobin in Benjamin Martin, Nilian Bagu, at paragraph 8, the learned judge sets out the written policy which the judiciary occupies and uses. Specifically, under the heading security can also be in the following forms, the judiciary sets out the judiciary's practice that certified check where the amount of security is greater than $10,000, the check shall be made payable to the registrar of the Supreme Court. A bond, registered financial institution, a charge on immovable property, such other forms of security or combinations. In other words, then, the judiciary in its accepted practice, as traversed by the judge in her published judgment, tells us that section 12, subsection 4, capital A, is the law. This amendment takes us into conflict with 12, subsection 4A, because we're saying here that cash in the sum of $30,000 or more, or a certified copy of a deed. If you go back to Madam Justice Gobin's judgment, you will see that they go into by far more requirements than a certified copy of a deed. For those of us who practice in conveyancing or mortgaging, a deed is something under the Registration of Deeds Act. A memorandum of transfer under the Real Property Act, for example, is not evidence of title, because title under the Real Property Act only vests when you have an endorsement on the certificate of title. So you would have to demonstrate satisfaction that the transaction was endorsed for there to actually be ownership proved. To confine people seeking access to bail to cash in the sum of $30,000 being inquired when the Act has 10, and more particularly and very seriously to saying a certified copy of a deed is to completely take for granted what the law actually says, and that's supported also by the language in the schedule to the Bail Act, which I've referred to a little while earlier. The Act also uses very curious language to be found nowhere else. To post or secure bail. Nowhere in the Bail Act are these terms used. What is in fact used in the Bail Act is source of security to be given so as to secure the grant of bail for the accused. That's the wording inside the entire Bail Act. There is no conscious understanding of what to post bail is. That appears to be an American terminology finding itself here. Mr. President, also when we get to the in-camera proceedings for cash or real property, the use of in-camera proceedings, albeit circumscribed by an offense, if you have an improper disclosure, those in-camera proceedings don't form part of a record which is sealed by an order of the court. More particularly, when one is going to an appeal and the reasons have to be given, reasons may very well include the publication of matters which were in camera. Therefore, you will be putting the information in the public domain by the decisions being published. For those reasons, Mr. President, Mr. Chairman, Clause 6 seems to be incapable of being saved because it unduly restricts the methods of security. And more than that, it in fact forms a very significant anomaly. It means that if you come up with any other form of security, the creature of statute, the magistrate or the master who must act only within the statute and not with inherent jurisdiction as a judge, cannot look into any other matter for a bail hearing. So if you're coming with a bond, if you're coming with a certificate of title, if you're coming with a motor vehicle, none of that may be the subject of a bail hearing. So it actually goes against the intention of the government because these things are very specific. And if you use the purposive approach, the literal meaning, the mischief interpretation, as well as the surplusage rules in parliamentary interpretation and legislative interpretation, all of those could never be the subject of a bail hearing. So it doesn't even support the government's approach. For all of these reasons, the new section 6B proposed by subsection 6 cannot work in the best interests of the population, and more particularly cannot work even in law in the circumstances that the government says it's going to work in a bail hearing, Mr. Chairman.
Attorney General, Defense Minister.
Mr. President, let me first start with the issue of the reasons, and when there's an appeal, that somehow the reasons would somehow find itself in the public domain. If proceedings are heard in camera and reasons are given in camera, then the record is sealed so that when it goes to the Court of Appeal, only then those in the Court of Appeal and the parties to the proceedings at the appellate court would have access. Secondly, let me address the issue of a need to give reasons. As it happens now, all hearings are done through the FTR proceedings. So reasons, when given, even orally, are captured by the FTR proceedings, the recording, and they are used in proceedings elsewhere. So there's no need to go into this level of detail. Secondly, there's reference to limiting ourselves to a deed. But the very Bail Act in the second schedule makes provisions and makes reference to the use of a deed and how a deed is construed in proceedings such as those. And it makes reference to the Real Property Act and how deeds are interpreted. Section 133, for instance, deals with such instruments when duly executed have the force of a deed made by the parties. So it captures certificates of titles, deeds, and other sorts of property. So the court is not limited as being suggested. Additionally, we have. I didn't interrupt you.
No, 133
I didn't
of what
interrupt
law?
you. 133 of the Real Property Act.
Of the Real Property Act, thank you.
Right, and we have another reason we can't take into account some of these amendments. We are subject to a moving target in terms of the CFATF requirements. There's a 6 round mutual evaluation which takes place in March. And I go there to say, in essence, that we have to keep upstepping so that we keep in line with the requirements as they keep changing. And we are moving away from cash, and at some point we'll be moving to instruments which are less susceptible to money laundering and so on. Reference was made to the judgment of Justice Gobin. I'm being reminded that when Justice Gobin gave that judgment, she didn't have before her all of the issues that were raised with respect to the evaluations and the changes that we had to make to ensure compliance. So that obviously is taken out of context. But all of this is answered by the amendment we propose, and which, when that time comes, we'll stipulate what it is.
Amendment now?
Our amendment with respect to 6 deals with the proposed section 6B1, and we delete the words shall and instead say the words a court may, which is what Senator Vieira is suggesting in his first amendment.
Mr. Chairman?
Yeah, FarlView.
Yes, final intervention.
Thank you, Mr. Chairman. With respect to my amendment in the reply, the Minister has pointed me to Section 133 of the Real Property Act, which is the execution of instrument by marksman, where the Registrar General may refuse to register any instrument executed by a person signing his name in foreign characters or by making his mark, unless the same appears on a certificate by an attorney at law or justice or by a duly licensed interpreter. Could that possibly be the law we're looking at?
No, it's 133. The mistake came from the law reform, so he's saying it's 133.
133 of?
1303.
130. Sub-3. 130 sub-3.
Of which law?
The same
Real Property Act.
Real Property Act? Yeah. Would you get it? Sorry, could I have it clearly? 103?
130 sub-3. Yes.
130. Thank you.
130 sub-3.
Thank you so much. Yeah. So I'm not finished, sir. I'm on my amendment.
Intervention.
Yes, I'm on my intervention, so the member has just corrected what he has just said.
Yeah, hold on. Just make your final intervention.
Well, I'm getting the law straight. Thank you. 130 of the Real Property Act is instruments and their executions under the Real Property Act. Just, Mr. Chairman, every instrument executed after commencement. These are not deeds for the sake of the law, not at all. And in relation to the Honourable Minister's statement that we're going into a 6th round mutual evaluation in March, I'm aware we're going into a 5th round mutual evaluation in March, but may I ask the Minister what aspect of the requirements that we're to meet says that we must do this? What aspect of FATF and CFATF says that?
I think this matter has been exhausted. We have exhausted this matter.
Chairman, I need an answer to my question.
Mr. President, is this a new debate? Are we in committee?
This is not a debate. We are in committee stage, Mr. Chairman.
No. Listen. Everyone has a chance to intervene and make their submissions. My responsibility is, in my opinion, if I am of the view that we have exhausted it, I will so rule. But I'm giving everybody an opportunity to intervene, but we can't go on forever.
Thank you, Mr. Chairman. Could you point me to where the answer was given?
Well, you're asking me?
Yes, sir, because you said that you're satisfied. So perhaps I missed it. Could you please direct me to where the answer was given?
Involved in any of your business here, no. I am just an umpire. I don't get involved in nothing except to rule and to take decisions. Right? So to ask me for answers.
Mr. Chairman, can we go to the vote? Mr. Chairman, can we go to the vote, please? One member seems to be monopolizing everything.
Anyway,
Mr. Chairman, may I have an answer?
Wait, could you just calm yourself? I'll ask the Honourable Minister of Defence final intervention as to this issue of the FATF. Just respond, if you wish.
Mr. Chairman, the remarks coming from Senator Roberts cannot possibly be within the decorum of this Parliament.
You're obnoxious. Yeah, okay, please. We are in the committee stage.
Mr. Chairman, now he's saying he's wearing mascara. What does that have to do with the debate?
Let us conduct ourselves. Please.
The member is encouraging the crosstalk.
Let us calm ourselves.
Mr. Chairman, he's now asking our members to...
Yeah. Can I ask members to cool themselves? Okay. Listen, we have 3 sets of amendments before us. I believe we have exhausted all 3, and we get into crosstalks now. Crosstalk. The first question I'm going to put to the floor is the following: that clause 6 be amended as circulated by Senator Anthony Vieira, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question, we go now to the other set of amendments, and that is clause 6 be amended as circulated by Senator Faris, Al-Rawi, SC. Those in favor say aye. Those, please, those against say no. I think the noes have it.
His own bench didn't even support.
The third set of amendments, the question is that clause 6 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 6, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6, as amended, now stand part of the bill. Let's go.
Clause 7.
The question is that clause 7 stand part of the bill. Senator Faris, Al-Rawi, SC.
Mr. Chairman, we propose that clause 7 be amended to allow for the interrogation of security which can be provided under Section 12(4)(e). The reason is that we think that there's a legitimate aim in understanding where security comes from, in ensuring it doesn't come from the flows of illicit gains. We believe that that is a legitimate aim. By including it in the ambit of Section 16(2) of the Act, we will therefore be mandating that the judicial officer, one of whom has inherent jurisdiction, that's the judge, but 2 of whom do not because they are creatures of statute, that is the master and the magistrate, by giving them the obligation to look at the source of the security to be provided, we would therefore be directly addressing the mischief pointed out by Madam Justice Gobin. Madam Justice Gobin held the current judicial policy of looking at Thank you, Mr. Chairman. Madam Justice Gobin held the current policy of the judiciary in having bail-type hearings to be unconstitutional because it wasn't contained in parent law. This single amendment here in Clause 7 will give constitutional threading and legislative direction and authority to the master, to the judge, and to the magistrate, allowing them to take this into account. What it does as well is that it directly ties us back to Section 12(4)(a), where the defined securities that are permissible by the court are tied back in. It also allows us to use the language which is inside of the rest of the law, that is, to be given as security for the grant of bail of the accused. Nowhere else in the Act do we say to post bail, etc. So, Mr. Chairman, we believe that the legitimate aim of the government, which we agree is a legitimate aim, of inquiring into the source of funds, ought to be there. We are 100% confident that nothing in FATF or CFATF requires bail source hearings to be dealt with. I have personally checked the records that are going to be required for our investigation for the 5th round mutual evaluation that comes up in March. And unless somebody can show me something to that effect, I stand by the position that it does not exist. So those are the reasons for our amendments, Mr. Chairman.
Minister of Defense?
Yes, please, Mr. Chairman. Mr. Chairman, not because Mr. Senator Al-Rawi doesn't know of the existence, it means that it doesn't exist. That's the first thing. And this is not a court to produce evidence. And the second thing is, go find it. The second thing is...
in crosstalk.
Yes.
Please.
The second thing is we are confident with the law as is drafted. It, in essence, is consistent with all the other parts of the Bail Act. To take into account this amendment would cause some confusion and require further amendments to other passages. So we do not agree.
The question is that Clause 7 be amended as circulated by Senator Faris Al-Rawi, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 7. What? The question is that Clause 7 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that Clause 8 stand part of the bill. Senator Faris Al-Rawi, SC.
Mr. Chairman, we propose that Clause 8 be amended to fix the language in the schedule. The first thing is that as the schedule is proposed to be amended, the guarantee is that I'm reading here from the bill, guarantee that the cash or real property used to post and secure bail for the accused was derived from legitimate means. It says nothing about any other guarantee of any other property or security used in the form, which is both movable, immovable, bonds, bails, any other form or any combination of form, which Section 12, subsection 4E says. So it makes a mockery of the form. The second thing, Mr. Chairman, is that it asks for a guarantee. In a statutory declaration, we have to go back to the Statutory Declarations Act. There's nothing about a guarantee in the Statutory Declarations Act. The penalty for a statutory declaration, a breach of the Statutory Declarations Act, is imprisonment or fine within the confines of the law. To introduce a guarantee does not exist. Further, it says that we are open to an inquiry being conducted. This again deals with a tripping of the right against self-incrimination, and it is out with and ultra vires the Statutory Declarations Act. If the legitimate aim were required to be brought into law, it's very simple. Allow the Rules Committee to develop rules, put in a springboard into the law that says that the Rules Committee established under Section 77 of the Supreme Court Act can make rules, and you can fix everything by having the springboard in Clause 60 in Section 16, the schedule which we're looking at being tidied up, and introduce a new section which would take care of the mischief of the master and the magistrate not having statutory authority, and therefore without inherent jurisdiction, not being able to go into bail hearing type considerations. Mr. Chairman, these are very serious issues. The schedule as drafted, the amendment to the schedule as drafted, conflicts with the very schedule it's going into. And there are aspects of it that are alien to the Statutory Declarations Act. And there is a right against self-incrimination provision, worse yet, an imprisonment included inside of there, which runs contrary to the whole concept of a bail hearing, because the bail hearing that is being dealt with is supposedly to make sure that illicit proceeds don't come in. But that is something that, in my respectful view, is not within the law of the Statutory Declarations Act or within the inherent jurisdiction of the court to treat with, insofar as magistrates and masters don't have it. Thank you, Mr. Chairman.
Minister of Defense, please. Attorney General.
Chair, it's late, and I know that my friend, Senator Al-Rawi, may be tired, as I am, but the second schedule, the consolidation, is quite clear. All that we are doing is to add words to to what is the statutory declaration to be made by a surety, or sureties. It's quite long. He got that bit correct. But the bit that we propose to add is 2, 4, 5 lines long. It's just above the signature of the declarant. So we don't agree with it. I'm not going to discuss it. I'm not going to debate it. It is what it is. I can give him a consolidated copy of the law if he wishes to have it.
Thank you, Honourable
It's
AG. I
without
have one.
merit.
Thank you.
The question is that Clause 8 be amended as circulated by Senator Faris Al-Rawi, SC. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that Clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
New clause 4.
We have 4 new clauses that are proposed by Senator Faris Al-Rawi. I'll now put the new clauses to the committee. The question is that new clause 4 be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 4 will not be read a second time.
New clause 5.
The question is that new clause 5 be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 5 will not be read a second time.
New clause 6.
The question is that new clause 6 be read a second time. Those in favor say aye. Aye. Those against say no. I think the noes have it. New clause 6 will not be read a second time.
New clause 7.
The question is that new clause 7 be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. New clause 7 will not be read a second time.
New preamble, right?
There's a new preamble circulated by Senator Faris Al-Rawi, SC. The question is, go ahead.
New preamble.
The question is that new preamble be read a second time. Those in favor say aye. Aye. Those against say no.
The new preamble.
The noes have it.
The new preamble will not be read a second.
The new preamble will not be read a second time. The question is that the bill as amended be now reported to the Senate. Those in favor say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate.
Mr. President, I wish to report that the Bail Amendment Bill 2026 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on the amendment, the Bail Amendment Bill 2026. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Honorable Minister of Defense.
Mr. President, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No. A division?
Yes.
Mr. Jeremie, SC.
Yes.
Mr. Roberts.
Yes.
Dr. Swaratsingh.
Yes.
Mr. Maharaj.
Yes.
Mr. Batiste.
Yes.
Mr. Alexander.
Yes.
Mr. Ratiram.
Yes.
Professor Prasad.
Yes.
Dr. Chaitan Maharaj.
Yes.
Ms. Charles.
Yes.
Mr. Zakur.
Yes.
Mr. Naked.
Yes.
Mr. Rashid.
Yes.
Mr. Tripathi.
Yes.
Dr. Brown.
No.
Mr. Al-Rawi, SC.
No.
Mrs. Roberts-Radgman.
No.
Mr. Cummings.
No.
Mrs. John Bates?
No.
Mr. Boodhu?
No.
Mr. Vieira, SC?
No.
Ms. Chote, SC?
No.
Dr. Atz?
Yes.
Mr. Bastide, SC?
Yes.
Ms. Jones Simmons?
No.
Mr. Lewis?
No.
Dr. Murray?
Yes.
Mrs. Lalit Etienne?
Yes.
Mr. McNish?
Yes.
Honorable Senators, the result of the division is as follows. 20 members voted for the bill, 10 members voted against the bill. There were no abstentions. The bill is passed.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
The Honorable Leader of Government Business.
I beg to move that the Senate do now adjourn to a date to be fixed.
Honorable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.